is joining us virtually for today's inaugural. May we now request CA Anusha Sreenivasan, President, the Society of Auditors, and Group Captain R. Vijaykumar, retired VSM, Executive Director, Madras Management Association, onto the dais, please. Our special guest, Dr. G Saravanan, will be joining us any moment. Let us all rise for the Tamil Thai Varthu.
ஈராடும் கடலுடுத்த நிலமரந்தை கெழிலொழுகும் ஈராடும் மடனவென திகழ்வரத கண்டமைக்கும் அதில் சிறந்த ராபிடனல் திருநாடும் இறைமுகனும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் என்பமுக
Thank you. May we now request CA Anusha Sreenivasan, first women president of the Society of Auditors, to welcome the gathering.
A very happy morning to all of you. It gives me immense pleasure to welcome you all on behalf of the Society of Auditors and the Madras Management Association to this program, AGILE. It's an acronym of Accounting, GST, Income Tax, and Legal Implications. This is the first of the series that the Society of Auditors has planned for exclusive the real estate sector today. It gives me immense pleasure to welcome Dr. Elangovan, who will be joining us online today. He is the Director General of Ministry of Labour and Employment. I'm sure his thoughts today will enlighten us and, help us introspect further on this topic. We have with us Mr. Saravanan from RERA. He is joining us shortly. He's on the way. He's the adjudicating authority and the principal officer of RERA. And his insights will set the floor rolling. Sorry. It is a special privilege to welcome somebody to their own home. So we have the icon of the Madras Management Association, Group Captain Vijaykumar here. Welcome, sir, to this joint program. Captain Vijaykumar, is a captain, is something, the title which he has earned by his service to the nation and his hard work. True to the title, Captain, he has captained this entire event today, not just in spearheading the program, but also in terms of helping in making all the arrangements meticulously, and he's personally coordinated with my team on every small aspects of this program. Thank you so much, sir, for being there for SOA. Society of Auditors is a 90-year-old organization. We are 90 this year. It is the oldest known accounting body in the Eastern Hemisphere of the globe. And we regularly conduct programs almost on a weekly basis. Our members are chartered accountants, and we do on subjects because our delegates are normally chartered accountants, their staff, and the students. This is the first time we thought about this program, which is actually where we have mixed audience, not only chartered accountants, we have people from builders, we have accountants from the builder's office, other people, there were so many individuals and even teachers who called us to inquire about this program, who have this personal tax issues on real estate and other things. So this program is one of the kind organized by the Society of Auditors. Actually, it is a teamwork, but a lot of credit for this goes to CA Rupa Ramachandran, our committee member, who she was instrumental in not only designing, but also in executing and implementing and working towards this happening today. And also, like I said, our members are chartered accountants. We do a lot of joint programs with other sister organizations who are also CA organizations and group of CAs. This is the first time we are coming out of the shell and we are doing with Madras Management Association. It was absolute pleasure working with them. Our weaknesses were their strengths, because our focus has always been on the technical aspect and making the program. And this time we learned, I think it was a great learning experience for my team in terms of organizing and arranging this program. I welcome all the speakers of today. Some of them are yet to join us. Advocate Vaidheeswaran is here. He's not new to the builders also. He's going to do on the legal aspects. Then we have CA T G Suresh for income tax, CA Prasanna. We have two people from the industry, Samita and Pavitra, and also CA Srikaanth, who will be taking us through the accounting aspects. It's a pleasure having you all. I once again welcome everyone present here. I'm sure today is going to be very enriching and fulfilling. Have a great day. Thank you.
Thank you, ma'am. May we now request Group Captain R. Vijay Kumar, retired VSM, Executive Director of Madras Management Association, to give his introductory remarks.
Good morning, ladies and gentlemen, and thanks, Anusha, for your kind words. It's always a pleasure.
Sorry
Oh.
to interrupt, sir. I think the chief guest is arrived.
Yeah,
The
please
special
come.
guest is- ladies and gentlemen, let's give a big round of applause as we welcome Dr. G Saravanan. May we please request you to take the dais, sir. Over to you, sir.
Good morning, ladies and gentlemen. A warm round of applause to our chief guest for this morning, Mr. Saravanan. He is the principal officer of RERA and for the construction industry. And he's not new for others, members of MMA who are corporate. He's a very important person if you have to construct something very, very big projects, actually. But you learn so many things from his speech today. Thanks to Anusha for the kind words. It's always a pleasure. MMA strongly believe in collaboration. We collaborate. That's maybe one of the reasons we have 8,000 members. We got operate from 10 locations. We do some 650 events in a year. Almost every day there'll be an event, something happening. Plus, we also have a excellent facility. We got 24,000 square foot of this complex ours, and we have a state-of-the-art library, digital library with some 1.25 million research papers, a lot of ebooks. Why I'm telling all this is, especially for the chartered accountant, you are all voracious readers. We all just join armed forces and have fun. You keep reading all through your life. I've seen some of the chartered accountant, one day they don't read, they become totally out of knowledge. That's the reason you need to have so many symposiums, conclaves, and it'll be good to be part of MMA for some of the events. It'll add tremendous value to you. In fact, on the 28th of this month, we are doing on generative AI, where it's already sold out, 300 tickets. You know, it's an event where we are getting speakers from all over the world. The head of Google from US is talking on the strategy, talking there. There's also Jasprit Bindra, who is one of the authority on AI. Why I'm telling, especially for chartered accountants, also some of the young people who are there, the AI is not going to take over your job, but somebody who is using the AI extensively will take your job away. So it's better to do so many things, and especially in the field of education. I know how many of you read the very nice article came in Mint yesterday to say that AI, how is going to impact education actually. Education, they will learn so many things, but ultimately it create the, kill the insight in them. Even simple things like homework, AI will do the homework for children today. So a lot of things are happening. Like coming to today's event, real estate, AGILE, accounting, GST. We strongly believe knowledge sharing is very, very important. And we have some outstanding speakers, as Anusha mentioned, especially our dear friend Vaidheeswaran. I will walk miles to listen to him. He is authority. He gives so much of insights, which we prepare for ourselves. This is a subject which is very dear to my heart because we made this building and GST, somebody told me anything moving, you can take input credit. We took, after when they did the audit, they killed us actually. He said, all the input credit, what you're taking, we think lift is moving, we took input credit. They said, no, lift is not part of the building. So many things which you are not aware, which I think you attend today, you will get to know. Not only a GST is one element where we suffered, so I remember, but the aspect which they taught, especially income tax. Again, it's a very, very difficult area where there also we fought and we got the court order to say that MMA is a charitable education institution. So you have to constantly tell them because they are in the area where they have to add revenue. We are in the area we have to protect our interests. So attending conferences like this where exclusively will benefit immensely our members because that's the reason we are taking this program live. It's live on YouTube, Facebook, Twitter, LinkedIn, also live on webinar. I know thousands of people watch. Later, even if people are not going to be there, please tell them all these are available for them to watch permanently as a reference point of view. Because today the speakers who are there, they're all outstanding people. who are going to be doing something phenomenal, sharing something which otherwise not available in public domain. So all through the day, we have pleased to enjoy your stay at MMA, and really a pleasure to have you with us this morning at MMA. Join us for lunch at 1:15, and the program will go as scheduled. Once again, very warm welcome to Mr. Saravanan. We did it because other speaker secretaries joining us online from Delhi. So yes to them. Has he joined? Yeah. Okay. Thanks so much. Once again, very warm welcome to you. And my dear friend Elangovan, very warm welcome to you, sir. Good morning, Mr. Elangovan. We're all looking forward. I always told them Elangovan will come on time. You're
Good morning. Good morning.
Okay. Over to the MC. Thanks so much once again.
Thank you, sir, for those very informative introductory remarks. We would honestly, want to present a health bouquet to Dr. K.Elangovan. Thank you so much for joining us, sir. Virtually, that's not possible. So please accept our bouquet virtually from here. May we now request A. Anusha Sreenivasan, President of the Society of Auditors, to present a health bouquet to our special guest of the day, Mr. G Saravanan. Ladies and gentlemen, a big round of applause, please. May we now request CAG and Ramaswamy, Secretary of the Society of Auditors, to present a health bouquet to our Group Captain, R. Vijay Kumar, retired VSM, the Executive Director of Madras Management Association. He is already a person with bundle of energy. We wish the health bouquet adds a little more to it. May we now request Captain to present a health bouquet to our President of the Society of Auditors, CA Anusha Sreenivasan, thereby transferring a little energy to the Society of Auditors and being a continuous source of energy always. Thank you. Elangovan, sir, we sincerely wish you were here with us, here physically. A small introduction about Dr. K. Elangovan. He is the Director General of DGFASLI, Ministry of Labour and Employment, Government of India. Dr. R.K.Elangovan is working as a Director General in the Director General Factory Advice Service and Labour Institutes, Ministry of Labour and Employment, Government of India, Mumbai. He received his PhD in Industrial Safety Education from Alagappa University, Karaikudi, Tamil Nadu, MTech in Machine Design from IIT Madras, India, PG DBA from Annamalai University, MSc in Environmental Science from Bharatiya University, and BE in Mechanical Engineering from College of Engineering, Guindy, Anna University, Tamil Nadu. He is a member of many doctoral committees of the academic research programs for the award of Doctor of Philosophy in the field of occupational safety and health. He has been selected and included as an industrial safety expert in the 2010 edition of Marquis Who's Who in the World, distinguishing him as one of the world's foremost achievers in the field. He is an expert faculty in the field of OSH for various renowned institutions and universities, and has been a chairman, member secretary of various technical committees on OSH formed by the central and state governments. He is the lead safety auditor and completed ILAB India Occupational Safety and Health Modernization Program Trainer Academy, conducted at University of Texas at Arlington, USA. He has represented India in G20 OSH Network, Rotterdam Convention, and various other international programs and events on OSH. He has been a member secretary for various committees of DGFASLI and organized many seminars, workshops, and training programs on OSH. He has conducted many regional and national studies in the field of OSH, noise and elimination studies, safety audits in factories and construction sites, on-site and off-site emergency plans, and HRA, quantitative risk analysis, hazard and HAZOP studies. He is actively involved in OSH activities for more than 25 years and published many thematic and research papers at national, international conferences in the field of industrial safety. Thank you very much for being with us, sir. Over to you. Yeah. So he will just sort out the network issues and join us shortly. Yeah. Can I just take this time to introduce Mr. G Saravanan, Principal Officer, RERA. Shri G Saravanan, BABL, has vast expertise in the field of adjudication in indirect taxes. Under his chairmanship, many litigations under TNVAT were brought into a clear dictum. Currently, he is the adjudicating officer of RERA. He is one of the most sought after adjudicating authority in Tamil Nadu. Practiced as an advocate in the city civil courts and high courts at Chennai. Got appointed as district judge in 2006, served as principal district judge at Kanyakumari and Tanjore districts, and also as chairman of Sales Tax Appellate Tribunal, Chennai. We are very honored by your presence, sir. A very warm welcome to you. Waiting to listen to you, sir.
Very good morning to all the dignitaries participating in the seminar. I am here to address all of you on the real estate sector legal aspects. The Act, that is the Real Estate Regulation and Development Act, came into force in the year 2016. It is really a very progressive type of enactment which changed the picture so far as litigation with regard to plot purchases versus promoter is concerned. In what way it is, I will sum up. The Act, the objects of the Act, you are very well aware. That is, regulation and promotion of the real estate sector. First point. And the second object is to ensure sale of plot, apartment or building or sale of real estate project in an efficient and transparent manner. Thirdly, to protect the interest of consumers in the real estate sector. Fourthly, to establish an adjudicating mechanism for speedy disposal of cases and dispute redressal. Finally, to establish the appellate tribunal to hear appeals from the orders of the RERA and the adjudicating officer. The very vital point is bar of jurisdiction of the ordinary civil courts. Because if a plot purchaser goes to any civil court, even if it is lowest rank of the courts or high court, the suit will come for trial at least 2 or 3 years after the filing, and thereafter the plaintiff who goes to the court will be subjected to unnecessary burden of meeting the cross-examination by the defense counsel, so on and so forth. But so far as the procedure adopted in the RERA forum is concerned, it is a very simple summary procedure. We adopt the procedure of filing proof affidavits on behalf of both the parties and marking documents, so that the lengthy cross-examination is avoided. 99% of the cases are admitted on the admitted facts. The documents are there to speak the transactions. So we are very easy to for us to come to a conclusion for a disposal of the cases at an early point of time. Even after the disposal, when the aggrieved person goes to appeal to the appellate tribunal, it is a point that it is a condition that the promoter has to deposit the amount, or otherwise the plot purchaser is to deposit, if he is in due of any amount for getting his plot for delivery, they have to deposit the amount, then only they are entitled to proceed with the cases. So on these aspects, the act is really a very progressive type, saving the time of both the promoter as well as the flat purchaser. Some of the decided cases, the law confirmed by the Supreme Court is clearly says that even if some agreements are entered between the flat purchaser and the promoter, the flat purchaser is always at a disadvantaged position. Whatever the agreement got prepared by the office of the promoter is given, he has no say. He cannot introduce any new conditions in the already prepared draft agreement. So he has to simply sign the agreement. But the law is very clear. Even the Supreme Court has laid down, if the terms and conditions are one-sided, only in favor of the builder, the law is very much concerned about the aggrieved party to grant relief. So here, even the builder is also bound to know the nuances of the law under the RERA Act and cope up with the trend, and so that he can meet the challenges. Even they have their own problems. But in cases where we see even the agreements entered in 2011, they are promised to hand over delivery in 2 or 3 years. Still, they are yet to hand over, citing so many reasons of their own: labor problem, COVID-19. Still, they say COVID-19 is a problem for us. We suspended work for several months, like that. So even taking into all these considerations, the RERA Act is a very much a needed one, making so many changes in the relations between the builder and the flat purchasers. One more thing, very important thing is, Supreme Court made it clear that like banks, home buyers too are financial creditors. That is the law laid down by the Supreme Court. Because they give money, lakhs together or crores together, investing the money for purchase of the flat. So simply after utilizing all these things, they cannot, dragging on so many days, they simply cancel the agreement at one point of time, irritated by the pressure of the flat purchaser, and simply cancel and return the amount. You cannot do like that. You have to repay the amount with appropriate interest, that is the interest at the rate of lending of SBI plus 2%. That is the laid down in the rule itself. So taking into all these things, the legal aspects, the builder is bound to take into consideration for a better prospects in the field. So thank you very much for all of you for patient hearing.
Thank you, sir. That was a very enlightening address on RERA, its inception, purpose, how it has contributed to the ease of doing business and to the consumers, bringing in more transparency in operation. May we now request CA Mahesh Krishnan, Joint Secretary of the Society of Auditors, to present a memento to Mr. G Saravanan. Ladies and gentlemen, a big round of applause, please. Dr. K.Elangovan, our special guest, is ready. Ladies and gentlemen, a big round of applause, please. Thank you, sir. Time to listen to keynote address by Dr. K.Elangovan. Due to network issues, he will not be switching on his video, but we can listen to him. Over to you, sir.
Yeah. Good morning. Shall I continue?
Yes, sir, please.
Audio has some problem. Can I continue?
Yes, sir, please. We are waiting to listen to you, sir.
Yeah. So firstly, I would like to thank the MMA and in particular group captain for inviting me to this August forum and share my thoughts on safety and security applicable to construction industry as it is. All of you know that, construction industry is the one which is not that much organized like a factory when it comes to safety and health and security. There are so many reasons because the industry, construction industry is altogether different from a manufacturing industry. As we know, manufacturing industry has a fixed premises, buildings, fixed equipments, and everything is by and large clearly laid out. But in a construction industry, the site keeps on changing. I always say that, when we go for construction industry, we are of the feeling that, the site which you see today may not be there tomorrow. And every hour, every minute, the site keeps on changing. So the safety and security concerns in terms of construction industry is altogether different from a manufacturing industry. And legally also, we have Factories Act 1948, which started way back in 1948 for factories, whereas construction, the Building and Other Construction Workers Act 1996 was brought in, then Central Rules 1998 and State Rules. Now also you will find that there may not be a full-fledged regulatory mechanism in the country like the factories. The topic of discussion is that the relationship between safety and security, how it is to be clearly taken into account for the betterment of the construction industry. When I talk about safety, it is like protecting human beings, workplaces from accidents, injuries, human errors, unintentional human errors. This is the very important thing. Whenever we talk about safety, the criminal part, crime part is not there. Somebody misses it, somebody unknowingly does it, and therefore it becomes an issue. Otherwise, in a construction industry or in a safety system, the entire causative factor is something like unintentional. Whereas security part of it, we perceive it to be intentional human, doings, or I would say intentional human, errors. You try to disrupt, or you try to create unrest, or you try to put somebody into risk based on your own theory, like creating agony or killing people, using of bombs, grenade, and so on. All of us know that. But the important point is the synergy between safety and security. In fact, if you see the safety system currently in a workplace, including construction sector, has really improved a lot, or can be improved a lot by utilizing the surveillance system, so-called the security systems. Same way, the security and safety, even though the safety is one thing which is something unintentional, routinely it is happening by a miss or something like that, and security is something intentionally somebody is doing, but there is always can be a synergy between safety and security in a workplace. If you see, if in a workplace, when we talk about safety, suppose you are putting a CCTV system, surveillance system, and the surveillance system can also help you in safety as well as in security systems. You see, a CCTV camera can be utilized to find out or record an accident or how it has caused, how a safety violation has happened. Apart from that, it can also capture the details regarding the security violations or intentional disturbances if anyone wants to create in a workplace. And you must be seeing currently the government of India is focusing more on the drone technology. The Honorable Prime Minister has also gave very much importance, giving very much importance on drone technology. Drone is again, in fact, We have taken up drone at a bigger level where we can use drone as a methodology or an instrument to capture safety violations, deviation, as well as it can be used as a, a tool to find the security deviations. And when we come to security by and large, we are focusing only on the security to the human beings or to the workplace. It is not that alone. Security has another bigger dimension, that the security of the information systems in terms of the soft data security, in terms of the innovation, in terms of the rights and privileges. It also has a different dimension when it comes to information-based security management system. Globally, all of you must be knowing there are ISO standards, 45,001 and 18,000 has already been observed. Or you have so many standards on information security management system. Ultimately, safety and security has to be put into practice in a workplace. Then only we can have a better, safe and secure workplaces. In fact, currently the trend is people are going into artificial intelligence-based security management systems. I know I've interacted with a few workplaces, and many places are not coming forward. You can have a CCTV camera surveillance system, and the camera can be put with the artificial intelligence, system embedded into it, wherein the camera, if you put a data, we call it as validation of a data. Suppose a person not wearing a helmet in a construction site, if it is considered as a deviation, then the camera keeps on capturing the deviation and giving you the near misses. And all these cameras, CCTV systems, the drones can be fed with the information regarding the expectations and deviation. And if such deviation happens, what should be done? And then therefore you see if your system manager sitting in your office can get at least 600, 700 near misses or safety deviations and security deviation right on the table without using any additional manpower. And you can put it for PP usage, or you can use it for access control, or you can use it for posture, or you can use it for metal handling, or you can use it for the storage of materials, everything, and including the lifting practices. So the safety and security systems, what was there maybe 5 years ago, is something different as of now. We look in terms of smart PPEs, the PPEs which can embed, chips, which can also tell you where you are positioned, like security system which are coupled with artificial intelligence, and your IPR related protection, data security, preventing data being, being sold or being misused. So it's very important in the current organizations. And construction industry, in fact, it has a very big scope to use these set of advances in safety and security management system. It is very difficult. In fact, we have done the drone technology with study in a big, sea bridge running about 13 kilometers, sitting at one place. We have run the drone for the entire 13 kilometers, take the recordings, and you can keep the data on your table and your computer, and you can analyze what are the safety and security violations, and you can immediately do it. It's like a manual intervention. If you're clubbing with artificial intelligence, it will also capture where the deviations are. We have seen construction site with the 10 or 12 story buildings. We can move the drone to a larger extent. In fact, if you come to construction industry, use of drone technology will be more useful because the building keeps on changing, the height keeps on changing, width keeps on changing, the topography keeps on changing. So it is difficult to go for the fixed surveillance systems like CCTV cameras. So use of drone, you can take the drone up to the topmost floor, maybe 12th floor or 15th floor where construction is happening within fraction of a second, and then you can watch what's happening. And you can also go fly the drone in each and every floor where the construction activity is going on. You can also, now the technology is there, all these drones can be clubbed with sensors, like you can put a lux meter with that, and you can measure the lux level there. You can also impact the petroleum refinery, all those industries. they use it to measure the thickness, ultrasonic testing. You need not carry the people to that particular height. And you can also clearly take the tag number. Suppose if your helmet is having the RFID tag, it can detect the tag number, and it can also tell which person is there at which floor and what he has not done. For example, if you find a person working at height not wearing safety belt, and if you are clubbing this drone technology with the AI or even our own interference, we can find at which floor which person is not working with the safety belt. So it is easy to prevent such accidents, and it can also have clear information to us before really something happens. So the technology is there, and of course, by investing on safety and security, you are investing on the property. You know very well, an accident will cost you at least 15 to 20 lakhs minimum. I'm telling, apart from the agony, legal issues, legal procedures, and so on. But any accident, I've seen construction companies meeting with 5 to 10 accidents become gone. They close the business because all their profit had been wiped out if 5 or 6 people die. You also know whenever accident takes place, like you see the LG polymer issue, where the high power committee was formed by the Andhra Pradesh government, in which I was also member, where it was clearly said, when any accident or disaster cannot be allowed to happen. So my request to the construction industry is that, please try to use these latest tools and technologies, system-based approach, and try to integrate safety and security. Originally, we talked safety, then we came to safety and health, then we came to safety, health, and environment. Then we came, now with the trend is safety, security, health, and environment. It should be a common platform encompassing all these elements for a better management of workplaces. Wish you all a very good conference. And once again, I thank the organizers for inviting me to the conference. Also wish all the construction sites to take forward and have a safe workplaces, protecting our workers at large. Thank you very much.
Thank you, sir.
Thank you, Dr. Elangovan, for joining us. I know you are at the airport. It's always a pleasure listening to you, and thought-provoking insight, and would have kindled thought process of many other people watching the program. Since you are separated by the distance, we've got a digital memento for you. And when you come next time, you'll get the memento delivered. What we do is, on your behalf, we pick up poor school children and give some textbooks, and we also do a lot of other work to them. And it's all because of brilliant people like you come and speak to us. We're able to do this. Thanks so much.
Ladies and gentlemen, a big round of applause, please. Thank you, sir. Thank you for the insightful keynote address. With this, we conclude the inaugural session of AGILE. So may we now request CA Rupa to present a memento to our group captain. Ladies and gentlemen, a big round of applause. As our president said, he's been such a G and guidance to all of us for this entire program. Thank you, sir. This is our first ever program with MMA, first association of SOA with MMA, and we look forward to more. Thank you, sir. With this, we conclude the inaugural session. We mark our sincere gratitude to our special guests who have made this great beginning for the Knowledge Street. We shall break for tea and be back by 10:45 for the first technical session.
small businesses across India. Startups and SMEs with an annual turnover of not exceeding Rs 50 crores are welcome to participate. Log on to governcare.com, mmachennai.org or give a missed call to 97899 60398. The last date for receiving nominations is 15 July 2023. Are you an innovator? If yes, here's your golden chance to celebrate your business. The 12th edition of the most awaited annual Shinni Krishnan Innovation Award from Care and Madras Management Association is now open for online nominations from entrepreneurs and small businesses across India. Startups and SMEs with an annual turnover of not exceeding Rs 50 crores are welcome to participate. Log on to governcare.com, mmachennai.org or give a
Welcome back, ladies and gentlemen. We now move on to the first technical session, RERA, Stamp Duty and Registration by Mr. K Vaitheeswaran, Advocate and Tax Consultants. May we have you on the dais, sir. Ladies and gentlemen, a big round of applause. Vaitheeswaran sir is a person who needs absolutely no introduction, but still, he obtained a law degree from the Madras Law College and enrolled as an advocate in 1990. He has also obtained grad CWA from the Institute of Cost and Works Accountants of India and has completed ACS from the Institute of Company Secretaries of India. His legal firm operates with physical offices at Chennai, Bengaluru, and provides services virtually across the country. He has 33 years of experience in advisory capacity as well as through appearance before the appellate authorities, tribunals, and courts in matters arising under domestic and international tax laws, excise and customs, service tax, VAT, CST, GST, FEMA, RERA, company law, and IBC. He wrote the first comprehensive book, VAT in India, when VAT was introduced in 2005, and has also authored books on CENVAT credit, books for students appearing in the CA final examination. He has written hundreds of articles covering a variety of issues in tax, corporate law, constitutional law, and general laws in both print and digital media. He has recently authored the book Taxation of Digital Economy, published by Oak Bridge, covering international tax and indirect tax aspects of the digital world, which is very complicated indeed. He is considered as a specialist in tax and legal matters with in-depth knowledge of the business and tax laws. He has addressed hundreds of seminars and conferences on law and taxation across the country and abroad, and is the most sought after legal professional in GST and business restructuring matters. He is an expert in real estate contracts and has recently forayed into technology, law, and artificial intelligence. He has been recently appointed as a member of the advisory council formed by the government of Tamil Nadu in respect of GST and other matters. He advises clients across the country on various verticals such as manufacturing sector, retail, healthcare, food and hospitality, gems and jewelry, media and entertainment, information technology, education, charitable institutions, societies and clubs, logistics, infrastructure, real estate, shipping and aviation, travel and leisure, banking and financial services. I need a break. He also advises various associations and chambers of commerce. He is chairman of expert committee on GST, Madras Chamber of Commerce and Industry, and also a member of the General Committee of Madras Chamber. He is the member of Finance and Taxation Committee, CIA South Region. He is also a member of SIC, Indo-American Chamber of Commerce. And his presentations are always very, very special in terms of technical knowledge, and he will make it really interesting in kind of mix of humor and over to you, sir. May we now request C.A. Revati Raghunathan, Regional Council Member, SARC, to present a health bouquet to Vaitheeswaran, sir. Ladies and gentlemen, a big round of applause.
Good morning. It's a pleasure to be here. Firstly, I thank the Society of Auditors and MMA for calling me this day to share some insights on this topic, which is very technical, RERA, stamp duty and registration. In fact, one of my juniors was asking, how come you're speaking on a non-tax segment? I said, everything is my practice segment. So if somebody calls me to speak on a non-tax segment, it is even more challenging and interesting, so that, I also look at fresh insights to share. So thanks, Anusha, a friend for many years, and Vijay for this wonderful initiative. A sector-specific program which touches on 4 key aspects is brilliant. I wish you more success in terms of other sectors and go forward, and gladly would support you wherever possible if time permits. So the earlier part of the inaugural session, Mr. Saravanan mentioned about how RERA was critical, but the younger generation may not know what was the pre-RERA scenario. Pre-RERA scenario, I don't know, you might have watched some old movies, and I may rasp off into Tamil, please forgive me if you don't understand, but I'm sure you'll follow here and there. Typically, sir, in airport vardu sir no. So if somebody is selling a project or somebody is selling a plot, the first point is that airport is coming nearby. This side there is a railway station, and this side there is a bus stand, and you have 24 hours water supply. And inevitably that land would be located somewhere in the jungle or may not be located also. So mis-selling, wrong selling was quite rampant by a set of people. Not all. They were brilliant, genuine players across the industry forever. But the industry got a very bad name because of these unscrupulous players who could do mis-selling, number of unorganized players, inordinate delays. There were stories like, I decided to buy this some 20 years back, now only I've got delivery. Those kind of things. All those things were also there. And then specifications issues. You ask for something, you get something else. All those kind of challenges. And biggest challenge which was always felt was, a project is launched, money is collected, and before any work is done, another land is purchased using that money. And therefore the delivery shortage happens. So this was played by a few set of players, which gave a bad image to the entire industry across the country. And therefore the parliament felt that we need a law which completely regulates this sector. Of course, there have been constant debates as to why should you need a law for one specific sector. Deficiencies everywhere. Even professionals are deficient in service. A doctor could be accused of being deficient in service. A lawyer or a chartered accountant could be deficient in service. Or a retailer could be deficient in service. There is enough legislation to attract deficiency in service. Why do you need a specific law? Was one question that kept coming up. So we look at the object of RERA. Typically create an authority for regulation and promotion of real estate, bring in efficiency and transparency in the sale of real estate project, protect the interest of consumers, establish an effective adjudication and speedy dispute redressal mechanism. That is most important, which Saravanan talked about. Because earlier, you will file a consumer case. And if you file a consumer case, first of all, Consumer Protection Act, the old legislation, by the time it got activated, and most of the district forums did not have members at all. So the consumer complaint would never be taken up. And if you file a civil suit, your grandchild might see the money. So that was the kind of time frame that was involved in litigation, and therefore it was felt that we need to address this aspects. See, the object of RERA is achieved by the fact that the law says that these are things you should do. If you don't do, there are consequences. It's not as everybody goes to RERA and complains and gets it done. The mere pressure that a law has to be complied with will ensure that fairness and transparency will automatically happen. So it applies to the whole of India except Jammu and Kashmir. Different dates came in for different provisions. It overrides all other laws for the time being in force. It completely overrides all other laws for the time being in force. In fact, that is what an interesting judgment of the Supreme Court, if you read in Pioneer Overseas, where they analyzed the interplay of IBC and RERA, and then talked about certain aspects of how RERA would prevail. In fact, if you look at the speech at the Parliament when the law was being moved, the Minister for Urban Development says, the real estate bill that we are taking up today seeks to form a happy alliance between buyers and developers. The bill seeks to address the complexities of the sector by putting in place a regulatory mechanism. Sir, it is really a regulation and not a strangulation. There are many developers who are guided by principles and ethics. That is why these companies are shining better and doing a good job. At the same time, there are some black sheep. Even though there are few in number, they bring a bad name to the entire sector. For only a handful of operators in telecom sector, there is a regulatory mechanism. Therefore, for thousands of people in the real estate sector, there is a need for a regulatory mechanism. Because if you look at TRAI and the legislation for telecom, there are only 5 players or 6 players max, but you had phenomenal regulation. So that was the justification of the minister when a question was asked, why only real estate you need a regulatory mechanism? So, if you are into RERA, the first question that typically comes up for a promoter or a developer, how many of you are from the real estate sector? Builders? Okay. And how many of you are professionals who handle real estate sector? Okay. Then you should know this. All the more. So, a real estate project definition is the most important aspect of RERA, where any development of a building consists of apartments, which also includes conversion of existing building into apartments, development of land into plots or apartments, as the case may be. So the popular thought process everywhere is that redevelopment does not fall under RERA, which is erroneous. Even a redevelopment can fall under RERA if the criteria is met. Of course, there is a criteria in terms of size and apartment, number of units, etc. Now, what is redevelopment? Typically, that happens throughout the state, throughout the country. Typically, it started in Maharashtra, now popular in Tamil Nadu. You have an old set of flats, about 40 flats are there, 25 years old, 30 years old. All of them decide that, water is leaking everywhere, power is not coming, lift is not working, we are not able to, live, decent life in these apartments. But what happens if you have to demolish and build? We can't do it on our own. Let's approach a developer. You talk to a developer, he decides to redevelop the project, and then everybody, of course, the consent is critical of all association members. The new law does give some indication that consent can be up to a percentage. So you get the consent and then you redevelop. So when you redevelop, what happens? The entire existing building is demolished, new building is constructed, and obviously the developer incurs all the cost incurred in redevelopment. And where will he get the money from? He'll get some extra apartments to sell, depends upon the FSI in that area. So he sells those apartments, makes that money and covers the construction. So typically the number of units that is developed can meet the criteria for RERA, and that project may also require RERA registration. So it is important to understand that it is just not new project, but even old projects can come into RERA. You look at many new structures, especially overseas funding, they would not like to be called as a promoter, but promoter is the most significant element of RERA because the promoter is responsible, liable, accountable for all aspects of RERA. A person who constructs or causes to be constructed an independent building or a building consists of apartments or converts an existing building or a part thereof into apartments for the purpose of selling. This is a key word. What are you doing? Development. What is it? Real estate project. Why are you doing it? For selling. So if you are not developing for purpose of selling, you are developing for yourself and you are going to keep it and let it out for others, etc., that would not even qualify as a promoter. So that definition is very critical because this definition is also used in other tax laws. They bring this definition even in the context of GST. Another person who develops a land into a project, whether or not the person also constructs structures or any of the plots for the purpose of selling to other persons. And apart from these two categories, a development authority is also identified as a promoter. An apex state level cooperating housing finance society, etc., is also attracted as a developer, promoter. We don't need to go into these things because they may not be relevant to you. If multiple parties are involved and both of them are involved with equal rights, etc., all of them can be called as promoters and they should be jointly liable for the functions and responsibilities of the acts. So, why is RERA significant today? How does a builder talk to a consumer? Advertisements. How do you know that there is a new project? You watch social media, you watch digital media, you watch print media, you look at the advertisement, you're lured by the advertisement, you see the one-page advertisement, your brand ambassador calls you, you are a big fan of that actor who's seen in that advertisement and therefore you also want to buy that apartment. All that flows from advertisement. Now RERA captures that point by saying that no advertising or marketing or booking or selling or offering or inviting to purchase by a promoter unless the project is registered with RERA. That is why most important for a buyer beware concept, from a consumer concept, when you see an ad, look for the RERA number. The RERA number would indicate that this is a registered project. You go to the website and feed that number, you will get the entire details of the project. The biggest advantage is transparency today for consumers. Every data about the project can be seen in the website of RERA. So RERA registration. Of course, there are projects which will have advertisements where RERA number would not be there because RERA may not apply. I'll come to that a bit later when RERA does not apply. So you should also understand the size of the project and whether RERA applies or not. But if RERA is applicable, obviously when they're talking about an apartment which is 8 floors or 10 floors or 4 floors or 12 apartments, RERA is applicable. So RERA registration becomes critical. So you cannot advertise. Where the development is in phases, each phase is considered as a standalone project requiring registration. In case there is an ongoing project where construction certificate is not issued at the time of the commencement of the act, registration must happen within 3 months from the date of commencement of the act. An application for registration is very, very comprehensive. So there are two aspects of RERA: the consumer side, the builder side. The consumer side is the protection side, the interest side, how his interests are taken care of, how he should not be cheated, how he should get the right product, all those things. The developer side, information. What are you doing? What are you developing? What are you promising? What exactly have you got? What are your approvals? Everything will come in that application. That application is your jadagam, your father's jadagam, your grandfather's jadagam, your great-grandfather's jadagam. Entire data will come in that application. It's very comprehensive and requires authentic information and data. RERA shall have a chairperson and not less than 2 whole-time members appointed by the appellate government. So you met Mr. Saravanan, who is a principal officer in RERA. So RERA is an adjudicating process whereby, let us say, an order is passed. From there is an appeal to a RERA appellate tribunal. So we're talking about that kind of composition here. Role of RERA or functions of RERA, section 34 says, register and regulate real estate projects. Most critical. Publish and maintain a website of records for public viewing of all projects registered, including information provided in the application. How many of you have checked the RERA website? It's important to check the RERA. Your capacity could be as a consumer, your capacity could be as an advisor, your capacity could be as a consultant, or your capacity could be to recommend somebody whether this project is good or not. You go to the website, you will see everything about that project. Not only will you see everything about the project, you will see about the promoter also. You will see past history. You will see delays or efficiency in production, development, everything can be seen in that. There will be enough columns to indicate where the project is, what stage it is, what stage of completion it is. So it is just not what you communicate through email. You will see it in a public website. Maintain database for public viewing and enter names and photos of promoters as defaulters. You know, those days of village Karambulli Sembulli concept, there is the English version of this, publishing defaulters. Now, this can be nasty because it invades your privacy, but at the same time, it forces you to become transparent, forces you to comply with the law. Maintain database for public viewing and enter names and photos of real estate agents. Not many know RERA applies to real estate agents also. Not only can a promoter do a business which involves a RERA registration without registration and publishing the number, etc. Even a real estate agent cannot sell a project which is not registered, and agent must also be registered. So both segments, the selling segments, have brought into the concept of RERA. Then of course fees, etc. in terms of procedures, regulations, orders, etc. they're not minded. But where does RERA get its teeth from? The RERA gets its teeth from when somebody complains, or RERA suo motu calls upon a promoter or allotee. It is not as if the promoter alone is at default. I've seen allottees who are at even more terrible default than promoters. Allotee would sign, promise that he will pay, promise to take up 50% of the apartments, which means the builder is confident that this cash flow is coming from this particular allotee. Suddenly allotee says, I won't pay. He'll quote various reasons. So there are situations where allotee refuses to pay, or there are situations the promoter refuses to deliver or refuses to construct. So complaint can come from either party, or the RERA on suo motu, based on information it has access to, will ask for information. Please call for information, explanation relating to the affairs as may be required. It has all the powers of civil court under CPC, plus it has power to issue interim order restraining any promoter, etc. from carrying out such act until such conclusion of inquiry, without giving notice to such party where the authority deems it necessary. So all principles of natural justice given a go by the parliament legislation itself, but in reality it is not so. RERA in action is very different from what the law says. RERA in action does not pass interim orders just like that. They give an opportunity, ask the persons their view, and then only pass an order. So that way they have implemented natural justice in the system, and that is transparent. They can issue directions that it considers necessary and should be binding on all concerned, which is typically. Now, if some of you may be senior, you will remember there was an act called as MRTP Act. Today is the new competition law. Earlier it is called as the Monopolies Restrictive Trade Practices Act. Under the MRTP Act, somebody can complain if there is a restrictive trade practice. For example, typically I remember this old story. A fellow was manufacturing a particular balm which you apply on your skin. And he put an advertisement saying that the other balm is not at all good, it is not great, it is absolutely bad, his is superior. And in that advertisement, he put the other balm's color. Whole world knew which product it was because they were identified by their color. So now the second party is affected because his market is clearly affected by the restrictive trade practice adopted by the first party, and he ran up to MRTP Commission and complained saying that there is a restrictive practice under the MRTP Act. MRTP, yes, they agreed. Yes, this is very unfair, this is wrong. And therefore, what did they say? They called the other fellow and said, "Inime pannadappa." Because the MRTP Commission did not have significant powers. It could only say cease and desist. That means don't do it and stop. Now that doesn't serve the purpose because the damage is done. So when Parliament created RERA, they realized that this cannot have that simple powers of just stopping something. Power to impose penalty, power to impose interest in regard to the confirmation of obligations cast upon promoters and royalties and real estate. Therefore, the moment you have penalty and interest and compensation that is contemplated as powers, then compliance automatically follows. They can also refer to the Competition Commission in certain cases. So as I said earlier, the application for registration flows from section 4. It is the most critical document. The regulation specifies the format, the time frame and the fees. Basically, the following documents which is critical. Your enterprise details, brief details of projects launched in the past 5 years, whether completed or developed, including current status, delay, details of cases pending, details of type of land and payments pending. This itself will show you whether you are getting into a right transaction or not. The moment you look at this data and see whether this person has got a track record. See, builder's reputation is track record. Have I delivered? There could be some delays, COVID caused delays, etc. But we understand that. But is there inordinate delay or there is some kind of delay which is normally expected whereby the delivery has happened? So track record can be checked by this application itself. Authenticated copy of approval and consent certificate of real estate project, sanctioned plan, layout plan and specifications of the proposed projects or the phase thereof. So RERA comes quite late. The RERA registration presupposes that you have got all other approvals in place. So that approvals coming in will also make it very clear that you are getting into a good project. What is your development plan? What are the facilities you are offering? See, today the advertisement would say that you will have access to a common swimming pool, you will have a club, you will have a sauna, you will have a yoga center, you will have a breathing center, you will have a sleeping center, you will have a nature walk, you have all those things. Mottame plot size 2 ground kuda irukum, but he will offer everything. So there could be situations where there is mis-selling or all kinds of services are offered and facilities are offered, but nothing is delivered. Now in your application you must say, in your RERA application you must say what are all you are giving. And therefore if what you have promised is not delivered, then obviously the consumer authority can knock the doors of RERA and say, I didn't get this. Location details of the project with clear demarcation of land dedicated for the project along with boundaries including latitude and longitude of the end projects of the project. This is a phenomenal data. Biggest challenge before RERA was, where is the project? Where is the location? You might have gone and seen, you won't know where it is. Today, you have GPS data, you have exactly the longitude and latitude of the location, and you can even track it. And they are now bringing even more technology into it, whereby it's absolutely getting transparent. The entire land of the country is going to be mapped with technology in terms of numbering. So therefore, the data is going to be so phenomenal when you go forward. Proforma of allotment letter, agreement for sale and conveyance deed proposed to be signed, number, type and carpet area of apartment. RERA brought a new concept of carpet area. This is very different from what you see. See, for example, you buy an apartment, 3 BHK, 1400 square feet. You may think it is 1400, but 1400 may not be the real situation. Because you have walls, you have internal walls, you have pillars, etc., all those things. So carpet area is after all that. So when somebody says 1,400 carpet area, then you know what exactly you're getting into. So the carpet area in Tamil language, the carpet podakudiya edangal. From English we borrowed all that carpet area. But basically it is your livable space other than the walls and boundaries, etc. So carpet area is an important segment. Number and areas of garage for sale in the project. There is an interesting Supreme Court judgment which says that car park should not be sold. Car park cannot be sold. It's an interesting judgment of the Supreme Court. But in reality, what happens, there is a charge for parking. So they call it as a facility rather than a sale of car park, because you cannot really sell the car park. So those are all you have to capture. How many car parks are you getting? You must be aware. In fact, I have seen projects where, before RERA and all, one set of buyers will get car park. One set of buyers will not get car park. And in the sale deed itself, they'll specify there is no car park. And he cannot sell what he does not have. So when he sells to the next fellow, in that second sale of flat, car park will be not applicable. So those kind of transactions used to happen. And in some cases, builders used to say, I still have development rights still left with me. Those kind of clauses used to be there. All that is not possible today. Today, you need to be absolutely clear as to what you are developing, what is the scope of rights that are given. Now, name and address of the real estate agents, name and address of the contractors, architects, structural engineering, and other person concerned with the development. They don't stop there. You give further declaration that you have legal title to the land on which development is proposed. See, biggest challenge today in real estate is land. Who owns the land? Multiple people will say, I own the land. Title to the land is a big issue. I'll talk about it a bit later in my second part of my stamp duty registration. Not many people focus or give adequate interest on the title part of the story. Title part is as important as the construction part. There are, you'd see in some of the projects in some of the cities, there are still in big litigation because they are not able to sell again because the builder did not have proper title to that land. And therefore, whoever bought that flat could not sell the flat because the land is still under dispute. And land could be under dispute for many other reasons. So title investigation is very important. Therefore, a declaration given along with an affidavit saying I have legal title to the land and this is how I got the land. Land is free from all encumbrances. Time period for completion of the project. And most important, interesting aspect is 70% of the amounts realized for the project will be deposited in a separate account in a scheduled bank. This is where the actual working of RERA happens. This is where it has controlled diversion of funds. This is where it has ensured that one project is not misused for another funds. And therefore, this is a very powerful and effective tool. I'll spend a little more about it a bit later. Now, if you look at what are the issues from a developer's perspective, past history. I would like to do a clean project today, but my past will come and hit me. I have to tell what all has happened in the past. And if I tell what all has happened in the past, I am killing my marketing. So that is one big challenge which some builders face. Information has to be authentic. Therefore, it has to be thoroughly researched and put across. Carpet area has to be clear. Legal title has to be clear. You must be aware as to how much of time you will take to develop your project. RERA does not say you must finish the project in 2 years. RERA says you finish the project within the time you committed. So if you are slow or you have some certain challenges, commit a longer period and sell the product. If you are sure you can finish in 2.5 years' time, put it as 2.5 years. So that is what is important. Time for completion of project is something which you have to specify. Now I'll go to the 70%. So typically when a builder sells, what happens? Today you would have seen advertisements, no? Yesterday it was 7,200 per square feet. Last week it was 6,900 per square feet. And the uncle ivvalaku vekkararu, and the uncle oda friend ivvalaku vekkararu, I'll sell you for this rate. So it's very, very attractive. And then 2 kilometers away is this, 1 kilometer away is that, 3 kilometers away is this. You have a 1-page ad, 2-page ad, etc. and whatnot. Now, moment that is done and somebody is impressed and they go for a booking and they make the payment to the particular developer. There are projects which are sold on the same day of launch, by the way. Today's real estate market is so hungry that there are projects which are sold just like that. And there are projects which also stagnate. So when projects are sold just like that, money just comes pouring in. So what the law says, as soon as you collect the money, 70% of the money you keep it in a separate bank account. That means you can't use it for all your other activities. Keep it in a separate bank account. It is for the cost of construction and land cost and shall use only for that purpose. And how to use it for that purpose? You must withdraw the money from that account to cover the cost of project in proportion to the percentage of completion of project. So you can withdraw money as and when percentage of completion increases. And for that, what is required? A certificate by an engineer, a certificate by an architect, and a certificate by a chartered accountant to the effect that withdrawal is in proportion to the percentage of completion of project. There are rules, formats, etc., which are very, very clear as to how do you go about it. So accounts to be audited within 6 months at the end of every financial year, and a statement is required from the CA to the effect that amounts collected for a particular project has been utilized for that project, and withdrawal is in compliance with the proportion to percentage of completion. So all the more onerous responsibility on the chartered accountant. A chartered accountant who is certifying a project has to be so clear and aware that the money has been utilized for that project, because he is sticking out his neck when he signs this particular certificate. So as far as Tamil Nadu RERA is concerned, your CA certificate is in Form 3 as per TN RERA. And what is the cost of real estate project? It covers the land cost, it includes premium, it includes FSI, it includes all other aspects. Development cost, construction cost, total estimated cost, total actual cost incurred and paid, percentage of completion as per the architect certificate, proportion of cost incurred to the total estimated cost, amount that can be withdrawn. So there is a formula for calculation, amount that can be withdrawn. What was withdrawn last year minus that, and then they will specify how much you can withdraw. So typically, even though the law does not specify so, what practically most builders do is, they have one account, which they call as a collection account. Entire money comes in. Automatically 70% is swiped and taken to a special account. And that is not used for anything else except construction. The 30% is available for your activities, whatever you can do. That 70% has to follow all these procedures, etc. And some people even go one step further, that 70% they don't straight away use that. Whenever money is required, they transfer the withdrawal portion to a third account and use that money for actual operations, etc. It's very, very important, because the 70% account is a very, very holy account. I'll talk about a little more. Uttar Pradesh RERA 2019 directed that banks should not adjust interest payments against the money that is to be deposited in the RERA special account. Haryana RERA, in the case of Supertech home buyers, held that lender was in violation of RERA Act when lender withdrew money from the bank account in which the sale proceeds were deposited. So you may be due to the bank, you may owe money to the finance institution, but he cannot touch this account. This account is meant only for project funds, project utilization, etc. That's why that is 70% is a very special holy account. Haryana RERA issued directions that the designated account should be a no lien account, and the 30% can be deposited in a separate account known as Promoters Free Project Account. Rajasthan RERA issued an order saying that 70% realized should not be used for repayment of loan of the bank until the project is completed. This is one critical aspect. Second aspect, I talked about carpet area. You should know what you are buying. So what is the carpet area of the apartment? Carpet area means a net usable floor area of an apartment, excluding external walls, areas under a service shaft, exclusive balcony or veranda area, exclusive open area, but includes the area covered by internal partition wall of the apartment. Room wall, okay. You know, the thin wall that you have between room is fine. That will all be factored into carpet area. But the outer walls of the apartment, the service shaft area, exclusive balcony will all not form part of carpet area. So anybody who sells as carpet area must demonstrate that the carpet area meets these requirements. Not only should the carpet area be specified, the common area must also be specified. In reality, what is common area is based on the association. அதில் ஒரு வயசான ஒரு old uncle இருப்பார் who decides what is common area. He will stipulate that these are all common areas, none of you can keep anything. There are others, you would have seen that MS Bhaskar, why are you putting my bag on the bike, etc. That kind of stuff. So typically what is common area is later on fought between association owners. See, RERA consumer படுற பாடு இருக்கு பாருங்களேன். Consumer till he gets the project in hand, it's a challenge. But good builders deliver the project in hand. He's happy, he's paid his money, he's got a beautiful apartment, housewarming ceremony done, he has moved in. அதுக்கப்புறம் தான் பிரச்சனையே ஆரம்பிக்கும். Because he has to live with another 30 people, or sometimes today 300 people, 400 people, where there is a big association which will put bylaws and regulations which are much more than RERA, which will stipulate what all you should do, what all you should not do. In some during COVID and all, they went berserk. as to who should come, who should not come to your house. All kind of things went in at a different level. But then that depends again on so many things. Some people want to say, this is a huge association, this our land, entire thing belongs to all of us. Let's put a temple inside. Where do you get the right to put a temple inside a common area? Somebody said yes. Whoever said no was an atheist, and therefore temple was built. So all these things also happen. That is a separate story. But the initial part of it, whether you get all that, is covered by RERA. Entire land of the real estate project or the land for phase development is in phases. That is where Innur Sunday the ground floor fellow will say, I will not pay maintenance because your maintenance covers lift cost. I am not using lift. Not terrace ke ponadilla sir. Inga terrace poi paathirkingala. Therefore, I have not gone to terrace. Therefore, I will not pay maintenance. So this is first separate fight which the treasurer always has to deal with. Entire land is in phases, that is covered for the real estate project. Staircase, lifts, lift lobbies, fire escapes, common entrances, exits of building. These are all common area. Nobody can claim separate ownership. Nobody can say this area is next to my house, my gate, therefore I can use this. No, it's common area. Common basement, terrace, parks, play area, open parking area, common storage parks. Premises for lodging of persons employed for management of property, including accommodation. This is another problem. New projects, etc., they give room for security. They understand that he's a human being, he needs a toilet. Old associations, they will think that the toilet, you never go for toilets. Our old watchman will be sitting somewhere in front of the apartment. He will not have access. None of the flat owners will give toilet access. So you find your own way. So that is old stage. But at least now people are aware as to what is the need of a person who is a security personnel sitting in the 24 hours out there. Installation of central services such as electricity, gas, water, sanitation. Now most of the apartments are coming with piped gas. So then there is a verification of piped gas, whether there is a leakage, all those things come later. The lawmakers of RERA are new lawmakers. That means what? They are aware of what all lawyers will interpret. And therefore, to be safe, they defined apartment in the widest possible manner. Apartment, whether called block, chamber, dwelling unit, flat, office, showroom, shop, godown, premises, suite, tenement unit, or by any other means a separate and self-contained part of any immovable property, including one or more rooms or enclosed spaces, located on one or more floors or any part thereof in a building, or on plot of land used or intended to be used for any residential, commercial use, such as residence, office, shop, showroom, etc., etc. People will find ways to say this is not an apartment. So therefore, they thought it and cleverly captured every possible thing under apartment. What I've given as a picture is a New York City apartment of 55 square feet, where the rent is 1,400 rupees per month, $1,400 per month. 55 square feet is also an apartment. So apartment definition is very, very, very wide. I said RERA registration is not required in certain cases. When the land to be developed does not exceed 500 square meters, not square feet, 500 square meters. So it will be about 5,000 odd square feet. If the land to be developed does not exceed that, no worries. Or the number of apartments proposed to be developed does not exceed 8, including all phases. Why 8? Rajini andakalathu solta, life is in 8 phases, no? So 8 is a number which is picked up. And those days, carry forward laws is 8 years. Some of the parliament is obsessed with the word 8. So 8 is the number of apartments. 10 sollirukkalam rounda illa or dozen sollirukkalam, but 8. Now 8, what happens? There are builders who are scared of RERA. I'm surprised. I've talked to most of the clientele come from that segment in the real estate sector. I talk to them, why are you scared? It's all compliance. Your track record is brilliant. Why are you worried? Why, sir? I don't want to get into that. I'll promote 7 apartments. So huge apartments, 3,000 square feet per floor, 6th floor, you can develop, saying it's 8 apartments. But then you may get caught in the first category. Land to be developed does not exceed 500 square meters. So you may get caught in the land that is covered in the development rather than the units that is there, because you use the word or. So that can always be a trick. You have to be careful on compliance. Second reason why RERA will not apply is if you got completion certificate issued for the project prior to the commencement of the act. Before the act came, if you got your CC, it was not there because of new law. The authority, now we saw what all RERA requirements from a developer's perspective. What happens if the RERA sits on it? You have filed the application, you have gone all aboard with all the documents, etc., and made your application, but RERA sits on it. Therefore, the Act also says RERA within a period of 30 days from the date of receipt of application must either grant registration or reject the application. Once registered, the authority shall provide registration number, login ID and password for accessing the website. This again is a mandatory stipulation. But what happens if it does not happen? In case of failure to grant the registration or in case of failure to reject the application, it shall be deemed to have been registered. Now this is pressure on the RERA to issue permission. It is not as if that, you can put an advertisement saying deemed to be registered at RERA. Nobody does that. But this is a pressure point for the authority to deliver in terms of application approvals, etc. You can always extend your project if you are able to demonstrate force majeure. During COVID time, a lot of people were able to get the extension because the RERA authority themselves voluntarily granted the extension. But force majeure could be very wide: war, flood, drought, fire, etc. In fact, as lawyers, when we draft contracts, as some of you could be young students of law or lawyers, force majeure is an important clause which you define. And the force majeure was war, cyclone, natural disaster, acts of God. I've been drafting for the last so many years. Somehow in my oldest draft, I had put the word epidemic. I didn't realize I had put that. One document cut and paste document. So all other contracts have the word epidemic. So when COVID came, we found that our clients had the epidemic as force majeure. Now we are putting not only epidemic, we are saying lockdown, all these new terms which I have learned. No? So all that is also now put into force majeure to protect your interest in case something happens. Because if lockdown, you can't move your material, you can't do construction. How can you deliver? So unfair practices is listed out. False representation that the service of a particular standard or grade. Marble tiles, not even there, you can complain. False representation that promoter has approved affiliation. False or misleading representation concerning services. Permitting publication of advertisement that are not intended to be offered. So typically these are the standard tick points for somebody to take action. So if the registration is revoked, what the authority will say, he will debar the promoter from accessing website in relation to that project and specify his name in the list of defaulters, display photo, and also inform RERA in other states also. See, this is very, very dangerous. So you can't afford to mis-sell, you can't afford not to deliver. Because you may say, I will do something in this state, I'll do something else in other state. Not possible. Everything will get transported to every other data point that is there. And also direct the bank holding the project account to freeze the account and take further action for facilitating remaining development. But RERA, if you look at it practically in terms of orders passed by RERA, they don't stop the project. Their endeavor is to ensure that the project is completed. So they go out of the way to see how a settlement can be arrived at. In some cases I have seen landowner, consumers, developer. All three are involved. Developer is defaulted. Developer is defunct. Developer is almost in the stage of winding up. Landowner has got a share which he has to sell. Landowner says, I will develop instead of the developer. RERA passes an order permitting the landowner to act as a developer to complete the project so that his interest as well as consumer interest is covered. Now this is going out of the way to solve the problem. Otherwise, simple solution, they can say, your developer has to deliver. Developer cannot deliver. He is no longer in a position to develop. Therefore, the work of RERA has been very interesting because they try to always protect the interest to ensure project is completed. A real estate agent cannot facilitate sale or purchase of an act on behalf of any person to facilitate unless he is also registered. Now all of them are registered. This is a typical, all real estate versions work on weekends. That's why I put this. Because any Saturday, Sunday, you see ECR, OMR will be busy with real estate agents taking around. So, agent cannot facilitate the sale or purchase of any apartment or building in a project if such project is not registered with RERA. So, not only should the agent check whether the project is registered, he must also get registered. So, you have double check as far as consumers are concerned. He has to create a website and enter the following information: quarterly up-to-date list of number and types of apartments that have been booked, garages that have been booked, approvals that have been obtained, quarterly up-to-date status of the project. That will give you clear data as to where your project is, how it is progressing. But nowadays, I would say that builders and developers are even more transparent than what RERA says. Even the advertisements show status of the project as photographs. Site today at so and so time, etc. they put. So they are going that level of transparency because it is important. And today, consumers are also interested in completed projects. So they look at whether the project is complete and CC has been obtained, because that is easy for delivery and you're assured that you can walk into the apartment. Promoter shall at the time of booking and issue of allotment letter be responsible to make available to the allottee sanctioned plan, layout plan along with specifications approved by the competent authority by display. See, I am a lawyer who practices on the real estate title side, where we investigate title or we recommend don't buy or buy a particular property, etc. Typical challenge which we face is some builders are not too happy sharing plans. But that plan is most critical. I need to know what I'm buying. Your approval plan must be known. So to some extent data is available in the website, but whatever is not available, the builder should provide. Some builders are extremely proactive. They prepare one comprehensive document, complete file, bound file, they'll hand it over to you. Adinna mosam, because he gives every data. He gets that document, keeps it inside, does not go through it, and goes ahead to the project. Kuduthathe padikradhukku dhaan. See, it's like this, school days, college days. If it's a bulky document to read, you don't read. If it's a bulky essay to be read, you don't read. Shorter it is given, you read, concept. So some builders also give highlights. They give what are the highlights of this in terms of, so you pick up what you want to pick up and read. So there are very, very proactive developers also. Stage-wise schedule of completion of project, including provisions for civil infrastructure like water, sanitation, electricity. Everybody talks about OMR, right? OMR was tom-tommed as the biggest development and, huge development did happen. Massive roads happened and development happened this side, that side, etc. Road became elevated and every other place got flooded. All that happened. But where is the water? Are you aware that today there is no water connection? There is no water connection in OMR. So you still buy tankers and lorries, etc. So what is the infrastructure the city is providing? What is the infrastructure the corporation is providing in terms of a development? You're talking about a new development. You are required to provide the lines. You're required to provide the water facility. And then, so the builder actually promises this and buys it and gives. Most of the apartments in that segment do not have a sewerage lines. So they have their own septic tank where there is a lorry which comes up and takes those stuff which is created later on. So all that is today a big challenge. That's a cost to the developer. He has his own cost increase because of that. Parliament law, therefore they are not aware of Tamil Nadu. Real estate business stamp duty registrations are state specific. Unfortunately, it's a parliament law. Therefore, what it says, builder has to execute a registered conveyance deed of the apartment plot or building as the case may be in favor of the allottee along with the UDS proportion title of the common area to the association. If you buy an apartment, you get the document in your name. You get a sale deed for the undivided share of land. You get a construction agreement in your favor. Act says this document must be in favor of the association. Because Maharashtra there is a practice. In other parts of the country, single document is utilized for execution of a sale deed for an apartment. In Tamil Nadu, there are two documents. Undivided share of land is a separate document, construction agreement is a separate document. So you can never ever comply with this, but RERA understands this because this is the law of the land. So two documents is different from conveyance deed to an association. Section 17 contemplates execution of a registered conveyance deed in favor of allottee along with UDS, etc. In Tamil Nadu, construction agreement is executed for the apartment and sale deed is executed for the UDS. Both are executed in favor of the allottee and not the association. So it's an inherent conflict, but people live with it. You cannot collect 10% of the cost, not more than 10% of the cost of the apartment unless you enter into a written agreement for sale and register the agreement. This is one more level of chaos. Nobody does this. Nobody wants also to do this. You don't want to register an agreement. But construction agreement is mandatorily registerable. Therefore, if you have a construction agreement where the advance is significant, that you can register the construction agreement and then register the unit. So typically what consumers do is, if the project cost, apartment cost, let us say 1.5 crores, and somebody is paid about 80 lakhs or 90 lakhs, etc., he's going to insist on some rights. Therefore, they register the UDS first. So UDS is registered and construction agreement is also signed so that, some rights are flowing to the buyer. No additions, alterations permissible to the approved and sanctioned plan, etc., without the previous consent of the buyer. Of course, you can do minor additions, alterations, but anything which major which cannot be done unless you get the written consent of at least 2/3 of the allottees other than the promoters. Morning, the chief guest was mentioning that agreements are one-sided, and Supreme Court pointed out that agreements cannot be one-sided. It is important. Not many are still aware. They give all kinds of one-sided clauses. I have all the rights, you don't have any rights, loss, indemnity, everything myself, you don't have anything. You have to give fair clauses, equal clauses. Now, when a project, after you complete the apartment, what happens if there are defects? Normally, if you look at the agreement, it will be silent on defects, or it will say, if you come to me within 6 months of allotment, of delivery, if there is any defect, I'll rectify. You cannot have such clauses because the law says 5 years. RERA talks about 5 years. In the case of any structural defect or any other defect in workmanship, quality or provision of services, the promoters, it is brought to the notice of the promoter within a period of 5 years by the buyer from the date of handing over possession. Promoter shall rectify such defect without any further charge within 30 days. This is theoretical. Promoter has to obtain insurance notified by the appropriate government, including but not limited to insurance in respect of title of the land and building. So what are they asking you? They are asking you for insurance with reference to title. See, title is a matter of diligence, investigation. Developer does investigation, consumer does investigation, bank does investigation. All of them only give investigation and a report with it enough disclaimers. If I give a title opinion, I'll give a disclaimer. For example, somebody comes and says, sir, this property I bought from so-and-so in 1992. So you go to the 1998 document, you go further. You find that before 92, 5 persons who said that they were sons and daughters of X had sold this property. You okay the title. 6th and 7th daughter files a suit. 6th and 7th daughter kano records. Legal heir certificate shows only 5. Legal heir certificate is what you give to the authority who issues accordingly. So the person who's left out in the relative who dies gives a list of who are the legal heirs. You give a certificate based on that. So 2 people who are legal heirs who have right in the property never come into the picture. So what kind of assurance can you give in the title except to some disclaimers? But what the RERA says is get an insurance for title. No insurance company will give a title insurance. It's impossible to get a title insurance. These are all failures. There are consequences, compensation, etc. I'll skip that. Rights of allottee, you can skip that, not a very major one. This is important. Why is RERA powerful? Penalties. If a promoter does not register the project, penalty up to 10% of the estimated cost of the real estate project. That order is violated, or even after that order, registration is not done, imprisonment up to 3 years or fine is extended to further 10%. So that is a kind of power that is there for penalty. False information or condemnation of matters in the application by the promoter, penalty up to 5% of the estimated cost of the real estate project. So these are all consequences which a real estate agent and a promoter face. Failure by the promoter in complying with the order or direction of RERA, penalty every day, which may be cumulatively extended up to 5% of the estimated cost. So these are all quite stringent and strict penalties. As I said earlier, the pressure is to make you comply. Now let's look at RERA in action. This is theory, Parliament Act, etc. Has it worked? Yes. Transparency has happened. Compliance level has increased to a different level. Developers are complying big time. Genuine players are gaining out of RERA. But where do they mess up? Over promising. I will deliver within 1 year. You can't deliver within 1 year. So you are identifying the date of completion is where some of the builders are skipping or slipping. Rather, others are all very careful as to what is their commitment. And it has impacted cash flow because of that 70% thing. As I said, no advertisement without mentioning registration number. Even in social media, you have to specify your registration number. In case you have obtained a CC from CMDA prior to the act, you must specify the CC number also. Biggest challenge in RERA, funding. All easy, comply, file everything, develop it, etc. Paisa. So I need funding. So financing for the project If NBFC get into a problem, real estate also gets into a problem. It impacts the real estate market immediately. Banks have a very, very vague approach to real estate project. Some of the banks are very encouraging, some of them are extremely discouraging. So funding is a huge challenge. So what is the solution? Old loan settlement, IPOs, REITs is a new solution that is coming in the market. And of course, overseas investors can always walk in with non-convertible debentures, compulsory convertible debentures. Those are all funding level issues. Second issue, inventory. RERA makes me comply. I have my own funds. I got my funding. I have created infrastructure. How many buildings are sold? How many units are sold? How many completed units are sold? Huge challenge. So this data will show you something. Unsold stock. If you look at unsold stock in terms of units and apartments, if you look at Q4 21-22 and then compare with Q4 22-23, you look at Chennai, unsold stock was 75,164 units. Now it is 74,608 units. But you look at the numbers, how it has moved, it has not moved very comfortably. So there is always a pile up of unsold stock. There is significant stock that the builder deals with. And money is lost because you put your money in there, unless you realize it, you cannot sell it. So unsold stock has increased by 15% in March 23 compared to the same period last year. Hyderabad saw a maximum increase in unsold stock by 38%, followed by Ahmedabad by 37%, Maharashtra by 29%, and Calcutta by 13%, and Pune by 2%. So Pune seems to be doing very well. So you look at statistics in terms of the inventory that is moving, you also get an idea of the city that is changing, the topography of the city that is changing in terms of development. RERA has also increased the cost. See, one may look at it with a very social objective and say consumers should gain, consumers should be delivered, etc. You look at the poor developer, the kind of approvals that he has to get is mind-boggling. And I can't even talk about the other cost that is involved. There is always all kinds of pain points in a real estate business. So prerequisite for a RERA registration are comprehensive: planning permission, planning permit, approved plans, local body, approved from village panchayat, environment clearance as applicable. Now this environment clearance is a big issue everywhere. NOCs, everybody you have to get NOC. Fire fellow has to give NOC. Airport authority has to give NOC. Why? Because if your height of the building is significantly high, the plane pilot will be in trouble. So the airport authority decides whether your structure is too close to the airport, whether it affects the landing and the takeoff of the planes, and therefore you may not give NOC. Indian Air Force, PW department, traffic police. Now the latest in Tamil Nadu is traffic police. You must get a clear NOC from the traffic police saying that this project will not create traffic. Chennai la poite eppadi serve kudukka mudiyum? This project will not create traffic. Swimming pool. After the accidents that happened elsewhere. Now swimming pool is also a challenge. You must, what kind of swimming pool is maintained, who is the bodyguard that is available, all that is there. ASI. If they are nearby a particular ASI area, that is archaeological survey has identified a particular location as protected by ASI, the idika anga vilum. Inga adicha anga valikkum Yugi sedu. And mari inga adicha anga vilum. So you want to be careful that you don't allow permission here to develop that project. Lifts and escalators. I don't know how many of you are aware, in your apartment complex, lift has got a license. How many of you renew the license? Though not many associations don't even know that they have to renew the license. Lift, NMRE specification, what kind of doors are there is also stipulated in the Lift Act. So all that requires compliance from a real estate perspective is just one sample of what they have to do. There's much more. So huge increase in cost because unless you clear all these things, you cannot get a RERA registrations. And adhikappura you have to sell to the market. So delay in obtaining permissions and NOC from other agencies can affect your RERA registration. And then there is litigation. Somebody files a writ petition saying that this should not be developed. Court admits it. It's the end of story. Till the writ is disposed of, you can't do anything in it. Or somebody gets a stay of the project, gone. Somebody files a PIL saying that this is an environmental disaster. It has filed a PIL, therefore court has also admitted that matter. Factors beyond control. RERA could have been a single window but has become an additional window. That is a fact. All of us were hoping that RERA is one window so that I don't have to touch, approach 30 authorities. But unfortunately, RERA has become the 31st authority. So that becomes some kind of another pain point for a developer. And everywhere in RERA, they use the word completion certificate. In most states, there is no completion certificate. They have an occupancy certificate in some states. But CC as a concept, even GST uses the word CC. CC doesn't exist in most parts of the country. RERA prevails over Companies Act. All this is okay. These are very legal. I can leave it. So what is the starting process? Complaint to a RERA authority. If complaint is maintainable, direction is given to approach the AO or adjudicating officer whom you met today. Then there is an order of the AO. If you are not happy with the order of the AO, you can appeal to the RERA tribunal. So today's RERA implementation status, all states and union territories have notified rules under RERA except Nagaland. 32 states have set up RERA authority. 28 states have set up RERA appellate tribunal. Regulatory authorities of 30 states have authorized their websites under provisions of RERA. 1,08,208 real estate projects have been registered. Tamil Nadu has got 16,640 projects. 77,525 agents have been registered. Tamil Nadu is 2,870. Complaints, 1,11,098 complaints, of which Tamil Nadu is 2,814 complaints. Maximum complaint seems to be in Uttar Pradesh. I don't know why, but that is another side data. So that is my first part of my lecture today, or speech today in real estate RERA. At the end of this session, I'll take questions. I'll finish this session with the stamp duty and registration. I'm going to talk about something which many of you know and most of you don't know. I'll give you some practical examples as to why this topic is important. One client came to me and said that, sir, I have a property. I want to sell. Buyer has come. I want to sell this property. So typically, what does the buyer want? Sir, I want a title opinion. Buyer wants a title opinion. So I looked at the title opinion and said, how are you saying you are the owner? Sir, நான் தான் சார் ஓனர். பட் உங்கள் 2 சிஸ்டர் இருக்காங்களே, ஆஸ் பர் டெத் சர்டிஃபிகேட் அண்ட் லீகல் ஏர் சர்டிஃபிகேட் 2 சிஸ்டர். ஆமாம்மா, தே ஹேவ் 2 சிஸ்டர் இருக்காங்க. ஆஸ் பர் தி டெத் ஆஃப் யுவர் ஃபாதர், ஆல் 3 ஹேவ் ஈக்குவல் ஷேர். இல்லை, என்னோட 2 அக்காவும் எனக்கு லெட்டர் எழுதி கொடுத்துட்டாங்க. தே ஹவ் கிவ் மீ லெட்டர் சேயிங் தட் ஐ எம் நோ லாங்கர் இன்ட்ரெஸ்ட் இன் த ப்ராப்பர்ட்டி. That was his basis for title. How many of them believe that the sister has given a letter saying that I am no longer interested in the property, therefore the other person owns the property? That is absolutely no title. The sisters have to release their rights, or the sisters have to settle their rights on the brother, then only the brother becomes absolute owner. Many of them are blissfully aware, and I am not talking about ordinary people, top level CEOs. So the lack of knowledge in the succession laws, lack of knowledge in the real estate requirements of law is very, very high. So I'm going to spend a little bit of time on this in terms of registration first. What are the documents which are compulsorily required to be registration? Instruments of gift of immovable property. You want to gift away your property to your relative. You want to settle your property in a relative. Mandatory immovable property, you have to register the document. Then, as far as the real estate sector is concerned, section 17F, instruments of agreement related to construction of building. Till one point of time, construction agreement need not be registered in Tamil Nadu. Only after a point of time it became registered. I don't know the exact date. I forgot the exact date. So if it's a very old property, you may find that the construction agreement is just 10 rupees stamp paper. But subsequent transactions, you will find construction agreement is a registered document. Registered document, original duplicate நம்பிக்கிறது கஷ்டம். அது வேற விஷயம். That's a separate, that's a fraud where you could be a victim. So construction agreements require registration. Instruments of agreement relating to sale of immovable property of a value of 100 rupees or more. Instruments of power of attorney relating to immovable property. Instruments relating to agreement relating to deposit of title deeds. These are all mandatorily registerable under section 17. This we can skip, because I think Suresh will talk about in the evening session, where there is something called as 53A of the Transfer Property Act, where there is no, the law contemplates a transaction which is recognized as a transfer, where there is a contract to transfer immovable property, and what happens if such a contract is not registered. So you may even escape capital gains, which probably Suresh will talk about in the last session. How many of you heard of OSR? OSR கேள்விப்பட்டிருக்கீங்களா? OSR is a very important aspect in development. Based on the criteria of the project that is developed, you must give away land to the panchayat, local authority, etc. through a gift deed. So the developer, landowner, etc. will execute a gift deed in favor of the panchayat, etc. I'll give you an example of OSR. Some of you may know. One of the most popular hotels in Germany, or Nungamakamai Road, was suddenly full of department official authorities, where they said that this is an OSR area which has been misused by the hotel and therefore they want to demolish whatever has been constructed there. Immediately questions were raised saying that there are other buildings in Anna Saleh whether OSR has been complied with. So an elderly politician at that point of time said that, yes, of course, this is OSR. I'll put chairs, etc. outside. I'm sitting. People can come and sit with me. Therefore, it is open source reservation. But that is the OSR. OSR is typically not meant for you. It is meant for the public. But practically, OSR put or fence put gate put wrong. So you see most of the projects, there will be a small access. One small wicket gate will give the access. So OSR is very important for a large scale development. Now, how do you give OSR? As I said, instruments of gift. I also said instruments of gift is required if between parties they want to gift away property. It is a registered document. So you can execute a gift deed. Chapter 7 of the Transfer Property Act deals with gifts. Section 123 provides that gift of movable property requires a registered instrument. Under Mohammedan law, 3 things are necessary for creation of a gift: declaration, acceptance, possession. So, hiba, in Muslim law, you call it hiba. I can declare that this is a gift, you can keep it. Hiba does not require registration. So, gift of immovable property requires registration under 123 as well as section 17(1)(a). But because it is personal law, Supreme Court said that there is no necessary for registering gift. You will find all these things in contrast when you come to property law. In property law, you will find personal laws are very different from actual property laws. Registration where it is optional. Most of you would have noticed that if you give your property on lease, you put 11 months lease. Why do you put 11 months lease? It's a habit. Everybody puts 11 months in, non 11 months lease. And keeps renewing after 11 months. Because more than 11, it is mandatory to register. That is why corporates, when they take on lease for 3 years, 5 years, etc., they insist on the lease to be registered. Because lease did not stamp duty. So to avoid the stamp duty, people say, I'll go for 11 months lease. So coming to a real estate project where you're buying an apartment. What are the documents? Conveyance. If it's a conveyance, that means sale deed. There is an undivided share that is sold, or land that is sold, or plot that is sold, 7% of the market value. And registration fee is 2% of the market value. This is the latest development from 1/4/23, where they reduced the registration rate but increased the guideline value. In effect, you're paying more. That's beautifully packaged from April 23, where they said that no, rate but value. So effectively, you're actually paying more. So 7% for the stamp duty and 2% for your registration, effectively 9%. Agreement related to construction of building, 1% stamp duty, 1% registration. So if you're a flat buyer, you will buy under a construction deed, construction agreement and a UDS, and that will be the kind of stamp duty that is there. But if it's a resale flat, that means you're already a owner of the flat. You bought it under a construction agreement, you already have an UDS share. When you sell it, you will simply sell a flat along with the UDS share. That will be a pure conveyance. Entire thing will attract 7+2. So resale flats will attract 7+2 because that's a immovable property by now. There's no construction that is being carried out. Power of attorney for family members, 100 rupees stamp duty and registration is 1000. Non-family members, it is slightly higher. There is something called as gift. There is something called as settlement. You have to be very, very careful in your English language in drafting of these documents. Gift attracts 7% stamp duty plus 2% registration. Settlement attracts 1% of the market value subject to 25,000 maximum in Tamil Nadu. That means if you are settling a property in favor of a family member, maximum is 25,000. If you are gifting a property in favor of a family member, you will get caught in the first category. So you need to understand gift versus settlement. So before that, you need to understand family. Family is very, very well defined in stamp law. It is not the same as section 56 of the Income Tax Act. Please be very, very careful. Family under 56 Act is much, much wider. You know, lineal, descendants will be covered. Whereas here, father, mother, husband, wife, son, daughter, brother, sister. Mamanar, Mamiyarla cover. Mamanar covered. Mamanar, Peripa, ella covered. You know, it's very quite wide as far as relative is concerned. Now, why this is important? This is important because if you settle a property on a relative who falls in the definition of family, you save on stamp duty, and there is no income tax on the hands of the recipient because section 56 will also cover gifts of immovable property, settlement of immovable property to family is not income. So a person may be a family under section 56 Act, but may not be a family under stamp duty. So you cannot think he is a family there, therefore my stamp duty will also be lesser. No, it may not be, it will be quite high. So you have to be very careful on the definition of family. In fact, one fellow filed a writ petition. Writ petition filed paniti, he said that family means father, mother, husband, wife, son, daughter. If son is covered, why not grandson? Therefore, I want the law to be read as including grandson. Court said, so they did not add words to it. They said, this is the words confined to family, you have to live with that. So this is important. When do you settle? You settle a property during marriage, in consideration of marriage, or you say that I've been living for some time, I've earned some money, I would like to settle this property on my daughter, brother, sister, somebody. So then the recital in the settlement deed must say that this is the reason why I am settling. Then it becomes settlement. We get all kinds of kinds. Most of them, old man will come along with son. And both of them will sugar talk me to say that, sir, Paya, upte I want to settle all my property on him. Apro, happy I'm going to stay. Nothing, you won't be happy. We are very clear that when there is a father who says or mother who says we want to absolutely settle on the son, we say put a life interest for yourself. Do not do all these things. You will be completely out of control. Have a life interest. Let the property go to the son. Make it clear. See, there's an advantage. When do you do a settlement? A lot of people think, sir, I've written a will. Seri. Have you done all the things for the will? Yes, I've done all those things. Executor is there, identified as who is the beneficiary, etc. Where is your property? Chennai. What is the worth of property? 5 crores. You're creating problems for your own son. Because after this fellow passes, the will has to be probated in a court of law. You have to go to Madras. Properties in Calcutta, Maharashtra, Mumbai and Chennai requires probate. All other properties, no probate. Probate required only for Hindu. Christian, Muslim, no probate. That's why common code is separately talked about. The law, yeah, nobody talks to all these laws. The laws exist. Anyway, that's the British laws. They drafted those laws like that. So you have to probate. Probate means 3.5% stamp duty. Settlement, 25,000 stamp duty. So practically you should know what to do. Settle it on the son or daughter, but later. So settlement for the purpose of distributing property of the settler among his family when he decides to provide, etc. Or for a religious charitable purpose, you can do a settlement. Whereas gift is simply transfer without any consideration. Now, title verification. 2 stages, 3 stages. Developer wants to develop a property. He looks around for land. He wants to buy a particular land. He has to investigate title. He does all his investigation. He'll have a battery of lawyers. They will investigate, give him reports, etc. Then he goes to the bank for project funding. Bank has got its own panel of lawyers. They'll investigate. Then project is launched. RERA registration happens. Buyer walks in. Most of the consumers do not investigate title. They think that builder would have investigated, bank would have investigated. I don't need to investigate. This is one set of consumers. Another set of consumers has gone for a bank loan. And the bank enna solta, title okay. Nobody has examined title. Consumer should also examine title. Because title is most critical. Ultimately, bank will say, you have bought the property, you are defaulting the loan, you pay. The property does not fetch rights, you still pay money from other sources. Therefore, verification of title is important. I learned this, even though people know me as a tax lawyer, there is one branch of law which we also do, and I should thank my father. He taught me this from my early days. He used to dictate. So we go 50 years, 60 years history. And translation means, title verification means you must have a magnifying glass in your hand. Document, so you have to sit and patiently read through and then chart it out and then go back in history. So what do? Tracing of title, establishing history, matching checking dates, inevitable frauds through matching checking dates. Idhila foreign company vanda suttam. he will put the month, day differently in some transactions. So that also creates complications. Verification of originals. Nobody sees originals these days. Originals are mandatory to be seen. Verification of patta. If land is involved, patta is mandatory. Without patta, SRO will not register. Examining all approvals for plots, DTCP, CMDA, municipality. For flats, CMDA, RERA, municipality. Then encumbrance certificate. Nobody, people get encumbrance certificate, they don't read the encumbrance certificate. Ulla padichu paatha encumbrance irukum. You have to read the encumbrance certificate and see whether there is encumbrance or nil encumbrance. Developer before purchasing property, an apartment buyer or plot before purchasing should check the following. What are you to check? Nobody bothers, but you have to check. No government land is involved. No Porambok land is involved. No land acquisition is involved. Site not covered under Land Sealing Act. Site not covered under land reforms. Property is not temple property or Waqf property. Site of the property is not on a water body. அது எப்படி கண்டுபிடிக்கிறது? மழை வந்தா தெரிஞ்சிரும். If any property has got super flooding, ஒரு காலத்துல water body. Simple philosophy, நீ வேணா மறந்திருக்கலாம். Water does not forget its pathways. So when there is real rain and real floods, water will find its way. ஒரு காலத்துல டி நகர்னால was lake. நுங்கபாக்கத்துல lake area னே ஒன்னு இருக்கு. Why would they call lake area? So all these are, you have to be careful today because courts are active on all these aspects. Water bodies they are prohibiting, they're looking at big, changing things. Survey number, biggest important error which people commit in the sale deed, you must describe the transaction correctly with the correct survey number. Illati vikka mudiyadhu. Subsequently, when you want to sell, if the old survey number of the old document does not match with this, SRO will not register. He'll say, bring the old fellow and amend the old sale deed. 20 years back, I got it. So whatever efforts you put, ensure that the schedule is correctly drafted and the numbers are correctly tallying. Revenue records are consistent. Plots sold are not in OSR. Some people also sell OSR land. Be careful what you buy. OSR, as per plan, will be identified as belonging to Panchayat, etc. That cannot be sold, obviously. So people try to do that also. Updated EC and cross verification. Now you go for registration. Original parent documents will be insisted upon. EC will be insisted upon, Patta will be insisted upon. In city it's called TSLR, in rural it's called Patta. Then ID proof. A lot of people when they buy plot, I always advise, ask the builder to put a sketch. When you're buying a plot, add one more A4 sheet. Put the plan of the entire sketch so that you know plot number 62 where it is. Put on green color, red color, etc. So you also know where it is, your children also know where it is. Otherwise, most children don't know where the property is. In fact, for all our NRI clients, our advice has been, sell everything. Because they are sitting there for 20, 30 years abroad. They don't come to India at all. Children have never come to India. And this man owes about 20, 30 crores of properties in 5, 6 places. I said, what are you going to do? You are going to pass away one fine day. Your children won't even be aware that they have properties here. Even if they are aware, மொத்தமே ஒரு வாரத்துக்கு வருவான். அந்த ஒரு வாரத்துல அவனுக்கு சங்கீதாவுக்கு போனோம், கோயிலுக்கு போனோம், அப்புறம் property transfer பண்ணோம். How will you do all that? So better sell off and invest there if you are having assets here, unless you are very clear that you are going to come back or your children are going to come back. So FMB sketch is very important. At least you know where the land is. Then of course TDS, 184 provisions are there. TDS will apply. So SRO will insist if TDS applicable more than 50 lakhs, then whether TDS has been done. As I said, pattas, there are 8 types of pattas. You have to know which kind of patta is applicable. And typically UDR patta and TSLR patta is applicable as far as general rules are concerned. Pattas are issued by Revenue Department. Today it's very sophisticated. You get an SMS patta transfer is applied for, and then you get a response saying that patta has been transferred. It's very efficient. Tamil Nadu has moved leaps and bounds in patta. And latest today's news indicates that they're going to implement blockchain big time in registration. If they implement blockchain, then the frauds will also go away as far as registration is concerned. Registration Tamil Nadu is online. So you get a token number, you go to the process and then go to the actual SRO office after the number is allotted. So these are the documents. So typically your sale deed, etc. will require online process only. When can SRO refuse to register? SRO can refuse to register certain documents whereby instrument owners convert as outsides without permission for development. Or SRO can also refuse to register if he says, you are trying to register, but it is government. Land belongs to government, or land has been given to a temple by somebody, or a trust by somebody, or a waqf by somebody. So that all that can be a pain points in the portal itself. It will not allow you to move forward because officer can refuse. Then you have to go to High Court and get a special permission and get it registered. Power of attorney. Maximum frauds happen in power of attorney. A will give power in the name of B, and then I have given power, and A's property would not be actually owned by somebody else. Evano power kuduthi evano within. So government started saying that this is too scary. Let's bring life certificate. What is life certificate? The person who gives the power has to be alive when the power is used. So power is given in let us say 2019, and document is presented at 23. Where is the guarantee that the person who gave the power is alive? Because if he dies, power dies. All rights die with the person. Therefore, Tamil Nadu says, bring a life certificate. Get a doctor's certificate that this person is alive. And the insurance companies, when they want to give that 5 year, after 10 years, they give some money on the policy, they will come and say, get a life certificate. My father had a wicked sense of humor. So he went to the LIC's office and said, Nanda, I am alive, give me the compensation. Ninga alive ne vera otha solno, appoda will give you money. So life certificate is a concept like that. Next I move to this most famous transaction of power of attorney by NRIs. NRI ko brother irukkaru, he lives abroad, he owns 1/3 share in the property along with 2 brothers here. All 3 want to sell. Obviously buyer will say, look, one fellow is outside, get his power. So how do you go about it? You call him and execute the document. That's the easiest solution. Marmata. Therefore, next solution is prepare a power of attorney, send it to him, give him clear instructions as to how to print it, how to sign it. Otherwise, he will sothify and you will have to do it again exercise. A practical experience. 2 pages will sign, 1 page will sign. He will not put the date or he will not put the seal from the notary. So give step-by-step instructions like a child so that he simply follows to the T, gets the notary signed, get the original immediately and then have it adjudicated. What is adjudication? Registration of that power duly signed by the notary. You have to get it adjudicated before any district registrar or SRO within 30 days from the date of execution, otherwise not valid. Then once you do that, with that power of attorney, you can present your documents, and that too, all this must happen within 30 days, otherwise life certificate. That fellow has to again go to the doctor and give a life certificate saying that, therefore you can use my power. So life certificate is very, very critical. So NRI transaction, be very, very careful. So real estate as far as future is concerned, brilliant. Transparency has been assured because of RERA. Market has really consolidated. Genuine players are increasing like anything. Therefore, everybody knows who plays well, who does not play well. Realistic project completion deadlines are very, very important. Cash flow is an issue. There is still a cash flow issue with a lot of people earning. Drafting contracts requires much more attention. Unfortunately, it is not getting that kind of attention when you draft the contracts. And organized formats is the order of the day. My last slide, the home buyer. Who is the home buyer in our country? Home buyer is a customer for the builder. Home buyer is a consumer under the Consumer Protection Act. Home buyer is a borrower for the bank. Home buyer is a claimant under the Arbitration Conciliation Act. And thanks to Supreme Court, home buyer is a financial creditor under IBC. Home buyer is a service receiver under GST. If he is a financial creditor, he is a financier. How can he be a service receiver? Home buyer is an allottee under RERA. Home buyer is a purchase under Stamp and Registration Act. Home buyer is an apartment owner under the Apartment Ownership Act. Home buyer is a depositor under the Capital Gains Account Scheme. With that, I thank the organizers once again. Thank you very much for your patient hearing.
That was an enlightening presentation on the entire Jadagam of RERA, its pre-birth, reason for birth, justification for existence, applicability, advantages, powers of RERA, disclosures, gaps, promises versus delivery, utilization of money, specifications of carpet area, common area, exemptions, registration, defects, insurance, duties and penalties, comprehensive statistics, stamp duty, importance of succession laws, OSR, family, gift versus settlement, title verification, due diligence, and the future of real estate with a positive note. You are blessed with a unique skill of simplifying complicated subjects and presenting it in a very, very captivating way. We really wonder whether you are Dasavadaram yourself. It was a 360-degree view of the Act. Thank you so much for simplifying it and presenting it in a capsule. May we now request CA J. Murli, also called as a VAT man, to present a memento to Vaitheeswaran sir. After the memento, we will have a question answer session. Ladies and gentlemen, a big round of applause. Both the indirect tax experts on the dais. Thank you, sir. Over to the audience for questions.
Oh, questions.
We request you all to use the slips which is provided in your registration kit.
Question is, if there is one child, whether a settlement to be done to avoid the issues to the child. Whether one child or more than one child, settlement is a good option because you give clarity, especially if the property is in Chennai, Mumbai or Calcutta. If it's in other parts of the country, will is fine because probate is not mandatory. A registered will is fine, or even a will execute before execute is fine. But if it's a Chennai, Mumbai, Calcutta property, it is advisable that if you execute a will, be ready that it has to be probated. Probated means what? After the person passes away, the children have to file an OP in the High Court. All the legal heirs will have to be arrayed as respondents in the petition, and the court has to pass an order on probate. That becomes a big challenge. So that I won't say it's a challenge, it's a time-consuming process. So if they're available in India, it's fine. They're abroad and all, becomes a painful process. So settlement is definitely an advantage if it's a one child because you give clarity before itself. But I always insist on life interest. Call me old school. I'm not too happy with property being given away just like that. Have no life interest so that the property stays and does not go away. You can put a conditional settlement also. In fact, Tamil Nadu, Karnataka, Kerala and all, there are laws which says that if a property has been settled on the son or the daughter and the son or daughter does not take care of the parents, the settlement can be revoked. So the settlement can come back. There are even more laws like that. So it's property is property. So you have to be careful when you deal with it. And in case there are no issues, if there are no children, even more important that you plan your property well because it depends on which community you belong to. If you belong to Hindu law, then Hindu Succession Act will apply. Under the Hindu Succession Act, class 1 heirs will not be there, class 2 heirs will not be there, class 3 will be somebody, some old cousin, some fellow might get the property. So if you have a mind that you want to give it away a trust or you want to give it away somebody, have that clarity before itself. Does a power of POA executed overseas needs to be apostilled as well? Any power of attorney which involves a sale of immobile property, definitely you must get it adjudicated in the registrar's office. General power is okay. It is okay. It need not be registered. Apostilling, notary is enough. Notary is enough. Or embassy commissioner is enough. During joint development with the landowner, does the landowner be registered under RERA? Is there any difference between unit share and revenue share? Landowner need not be promoter unless he wants to take over promoter's responsibilities. In a joint development agreement, inevitably landowner role கிடையாது. Okay? இந்த கல்யாணத்துல ஒரு சித்தப்பா இருப்பார் தெரியுமா, ஒரு பேக் மாட்டிட்டு அந்த அளவுக்கு தான் ரோல் அவருக்கு. He has to give permissions, etc. Beyond that, he does not have any roles. The developer only develops the property. Of course, he has a right of inspection, etc. But if he takes a little more serious role, if the landowner wants to take a little more serious role, take joint development rights, he also wants to promote the project, etc., he'll be treated as a promoter for RERA. In case he decides to sell during the stage of construction, his share of flats that he's getting, he must also get GST registration. So he has to be very careful when he wants to sell. So in a typical landowner, in a typical joint development agreement, one format is an area share. In an area share, it's very simple. She has land, she gives to me, asks me to develop. I'm able to build 100 flats. So the joint development agreement says, I will sell 60 flats in the market for myself. you will get 40 flats. That's a typical JDA, or the ratio could be different. Now, what really happens is that 40 flats she can sell or retain, 60 I have to sell with the power from her to sell the UDS. So that is called as area share. Instead of that, she says, look, I don't want apartments. I don't want to wait for another 5 years to get the apartments. I want money. So it could be a revenue share, whereby as and when I sell, I'll give 40% or 50% of my collections to her. That is called as a revenue share. Sorry? Commencement of construction project before introduction of RERA, will RERA rules apply? RERA was very smart. It said that if you have got a completion certificate on the date of application of the RERA legislation, that project need not be registered. So completion certificate eppo kadaikum? When the project is complete. That is what our general common sense tells us. But the rules are such that shell pillar coverage kudale CC. So that 1 year window, old projects escaped RERA. So CC if you have got, you are out of RERA. And each state rules for CC is different. GST for plotted development under JDA and revenue, I should not answer because there is a GST faculty. No, though I know the answer, I cannot answer. Syllabus no irukku. I should not reach my syllabus. NRI power of attorney, whether it can be executed overseas. Dharalama can execute overseas, but Daiva say they draft it here. Do not engage a lawyer to draft it overseas. It will be a different kind of document. So draft it here, send it, get it done, and then adjudicate it here. Does the grandchild include the child of a daughter under stamp duty with the practice of transferring through daughter in states like Kerala? See, Kerala is a different concept because they had this Maramagatayam concept, which is somewhat similar to our HUF concept, where the mother plays a much more bigger role than the father. And mother is the head of the family compared to the father. The father is head of the family, mother is head of the family, pasanga is head of the family. The children are the head of the family rather than the parents. That's a different story now. So as far as succession is going, as far as stamp duty is concerned, that family definition is very, very clear. It does not cover grandchildren. It covers only children. It covers the spouse. It covers the brother. So typically what happens is that, let us say a person dies and there are 2 daughters and 2 sons. Terrible, even now, it's so shocking that the patriarchal system mindset is still there in the boys. They come and say, I want the entire property, I don't want to give the property to my sisters. Even openly they say. Even though law says they are equals, the law recognizes that they are equals, it's unfortunate that the brother still thinks that the all property belongs. And then he has his vague answer saying, my sister's marriage was conducted to my father, therefore I have the right to the property. So all this is theory. In law, all 4 are owners. In case the sister is willing to give the property to you because she has a jewelry or whatever, get a settlement. Sister to brother settlement is fine. Do it properly, and as per law, you can do it. Is registration of joint development agreement mandatory? How should it be done? Thanks for that question. It's a brilliant question. I gave you a list of documents for registration. Tamil Nadu Act does not require joint development agreement to be registered. If you voluntarily register also, it is incapable of valuation. How do you value a joint development agreement? Because it is future rights that is coming. JDA is not registrable in Tamil Nadu. Karnataka, mandatory registration. Madhya Pradesh, mandatory registration. Most parts of the country, JDA entry is there with the stamp duty. Now this is very important because JDA, which is unregistered, what happens inter se? If there are rights violation, what happens? Only possibility is arbitration. Ensure you put an arbitration clause. Number 1. Number 2, if you go to the Income Tax Act, in the context of postponing your capital gains for the landowner, the section says that the JDA must be a registered document. But Income Tax Act says JDA must be registered. Registration is not even required under Tamil Nadu law. Then you have to apply doctrine of impossibility and say you can't compel me to do something which is not there in the law. I'm sure Suresh will cover it in the evening. What is the collateral security which NBFCs, banks ask is funding for the project and general repayment period. It will be very, I think there is an accounting person who can answer that, but security is very typically your documents, your original document. In fact, in joint development agreement, the landowner's originals are critical. So big fight between JDA partners as to whether landowner will permit the developer to mortgage these original documents for the development, or landowner refuses and says, I will not part with my originals, you find your own funding. That's the biggest fight which goes on, and finally that is put into a JDA draft. JDA agreement is very, very critical. All clauses are important, both for builder as well as buyer. I've seen many developers who sign JDA without even putting service tax, and then they want to collect GST. No, outdated documents. I see JDAs with landowners where they don't talk about their rights at all. So you need to be careful and balance it to protect your both interests. I think I've covered all the questions. Yeah, I've covered all the questions. Thank you. Thank you.
Thank you so very much, sir. Thank you, sir. We now move on to the second technical session, technology and sustainability in the real estate industry. We have with us Ms. Pavitra Sriprakash, Chief Designer and Director, the Global Design Studio of Shilpa Architects, and Ms. Samhita M, Managing Director, Ila Green Buildings and Infrastructure Consultants, Founder Director, Ila Green School. May we have you on the dais, please. Ladies and gentlemen, a big round of applause. Quick words of introduction about Ms. Pavitra Sriprakash. Pavitra Sriprakash is an architect and urban designer with a focus on sustainability. She is the Chief Designer and Director at the Global Design Studio of Shilpa Architects, which is an acclaimed design house that draws inspiration from cultural values that are distinctly rooted in the subcontinent, fusing vernacular methods with modern design and construction practices. Having practiced urban design and planning in New York and Chicago, Pavitra's work has been India-focused since 2008. Pavitra is the co-founder and director of SGBL Studio, an international architecture and urban design firm with offices in Chicago, New York, and Seoul. This company has executed projects in the US, Belgium, Norway, China, Japan, and Kuwait. Shilpa's international urban design studio. She is an expert in sustainability and has completed research in Columbia University on sustainable, pragmatic landscapes and the interface between architecture and landscape design and planning and robust urban spaces. She has been invited as an expert speaker by University of Tübingen, Germany, CII, the Indian Green Building Council, the Economic Times, Indian Institute of Architects, Design Mission India, Hospitality India Summit, and various forums to address groups about her perspectives about green buildings and sustainability. She has a master's in architecture and urban design from Columbia University and a bachelor degree in architecture from School of Architecture and Planning, Anna University. She is an accomplished Bharatanatyam dancer, columnist on sustainability, an RJ and an artist. A very warm welcome to you. May we now request CA Vice Sridhar, committee member of the Society of Auditors, to present a health bouquet to Ms. Pavitra Sriprakash. Thank you. Words of introduction about Ms. Samhita M, Managing Director, Ila Green Buildings and Infrastructure Consultants, Founder Director, Ila Green School. MArc Sustainable Architecture, PGPM, LED, so many qualifications, actually it runs into all A to Z. Samhita M has been in the green and sustainable space for over 16 years and is an ardent advocate of sustainable living. She is the director at Ila Green Buildings and Infrastructure Consultants, a company founded in March 2009. An architect from Anna University, Samhita's expert lies in planning green and energy efficient building solutions and driving integrated design approach in building design. Prior to starting Ella, she worked with Ashok Leyland Properties and the CII Green Business Center, Hyderabad, where she was associated with all prestigious projects of CII, ranging from developing of green building rating systems and formulating framework for certification of green buildings. Over the last decade, she has trained more than 8,000 professionals in the field of energy efficiency in buildings and green buildings. She has also consulted for more than 500 projects on green building services. Some of the clients under her leadership includes Infosys, Microsoft, ITC, Coal India, Symbiosis, and many, many more. She has worked with 6 state governments towards implementation of Energy Conservation Building Code, ECBC. She has been recognized by Niti Aayog as Women Empowering Lifestyles for Environment, We Life, and also awarded the Telangana State Energy Conservation Award in recognition of her contribution towards energy conservation practices in the state. She founded Ella Green School in 2018 in Chennai, with a prime focus of sowing seeds of sustainability in children at an early age. Today, Ella Green School is IB authorized and caters to more than 300 students. A very warm welcome to you, ma'am. May we now request CA Renuka Murali to present a health bouquet to Ms. Samhita M. Ladies and gentlemen, a big round of applause. Thank you. The rise is all yours.
Okay, great. So thank you everybody for inviting us to be a part of this exciting day of programming. Technology and sustainability in real estate, when Captain Vijay Kumar actually reached out to me and said, we'll talk about it, I was wondering how I'm going to address a group of auditors. But it's our first time doing that because it's a non-creative, very financial, very different background that all of you come from. But hopefully we can add some value by giving you some insights into the kind of technology that we use to bring projects to life in the real estate field. So I'm going to start with that. So overall, the framework for today's format of talking about technology and sustainability, we've kind of broken it down into the tech aspect and then the sustainability aspect. Typically in an architectural or a real estate project, the architectural work happens before, we break ground, and it has to be visioned and designed and all of that. So a lot of the tech tools that I manage or work with on a daily basis happen to be at the design stage. So right now we are experimenting with AI. We've been working on BIM, which is a building information management system, since 2008 or so. We were fairly early adopters of trying to work with BIM to try and envision buildings. But AI and blockchain are things that are much newer even for us. So we're still dabbling with that tech. On the construction side, once the project is tendered and it goes into implementation, we find that there are many construction methodologies in terms of new technology which are being more prevalent in the market today, to either start working on making buildings faster, more efficient, to monitor them better, or to even give you real-time data as to what's going on site versus what's happening, on the design front. And finally, when it comes to operations, I think maintaining and operations of building is really highly tech-enabled nowadays. And we're able to see a lot of technology that's coming in that can help you maintain the building for the life cycle of the entire, time that the building is standing. Sustainability is obviously more Samitha's forte, so I will at this point hand the presentation off to her. Again, she will talk about the design tool, she'll talk about how it's applicable during construction, as well as then going through operations. So typically we'll walk you through the entire design and real estate process of envisioning a building, getting it built, and then what it takes to kind of run into the operations portion of it. And then of course, we'll just go through some pros and cons. So really quickly, jumping into technology. So when you look at the design tools that enhance the performance, as I lightly touched upon, we have artificial intelligence, which is making huge kind of waves in the way we're envisioning and designing buildings. We have design tools for pretty much everything, right from the way it looks to how the building performs. So there are many, many design tools that we can use nowadays, which are AI-based. There's BIM, and then on the construction side, again, we have technology such as MyOne, which is aluminum formwork, which helps people construct faster. There are many developers that are embracers of this technology because this is a very repeatable format and can help people cut down their construction time really, really by a lot. The GFRC panels and 3D modular and precast. On the operation front, we've looked at, the various things that go into the building in maintaining it, whether it's sensor-based software that then reports back on efficiencies, maintenance schedules, and different things like that. So this is kind of it. The overall design tools to enhance performance are AI, BIM, and blockchain. And when you typically look at where the new tech is being developed, I've been finding really by following all these accelerator programs that are available through the real estate chain, that a lot of the tools that are available nowadays that, people are going ahead and funding, and this is where a lot of the excitement is in sustainability, because I think this is the next way forward to try and tie new tech into aspects of, climate sensitive and geo-sensitive, culturally sensitive design that helps us then, create a more sustainable product at the end of the day. The other place where we're seeing a lot of push in terms of new tech is digital marketing, because visioning a project is becoming a lot easier now. So one of the things that I think is hugely inspirational, I was at a talk recently by someone who's closely, working with the metaverse and, working with gamified kind of realms. The future, as far as everyone had predicted, is that the better you are at playing games, the more easy you will find getting work. And I thought this was a really cool sort of an analogy, because nowadays real-time game engines are coming into the space of architectural as well as any kind of visioning. So if I can dream it, I can probably get it translated into a digital image. And that's the kind of, real close tie that's coming in with tech and the dream space. So a lot of the digital marketing, a lot of your customer delight, being able to present things to a customer in a way in which they're able to actually grasp it rather than 2D plans, as well as even envisioning and helping the marketplace in terms of what's available, what's there on offer, has all got to do with, the idea of new tech. On the other front, on building smart spaces, technology helps us on a daily basis. I think Samitha will also touch upon all of these AI tools that we use to try and tell us things like, how much daylight is coming into the building, are we planning enough lights, are we planning enough AC? All of this can be simulated and given to us in real-time data nowadays. When it comes to construction technology, I'll talk about a few of the new things that are happening that I have been personally sort of, working with as we kind of go through the presentation. But this is mainly the kind of spectrum. So it's a really vast topic when you say tech in real estate, because it covers right from, envisioning to showing, to helping create that marketplace, creating that delight, having developers build and sell their product, as well as what it means in terms of investing, where to invest, how to invest, where property markets are headed, etc. So there's a lot that's going on. So when it comes to AI in construction, I think AI and machine learning has been used to handle all of this data, through which I think pretty much everything that has been imagined can quickly be reproduced. So right now we are working on tools that can, where you just design the box and you can ChatGPT pretty much just type in what you want this building to look like, and it does it for us. So I'm really afraid that very soon I'm going to be like out of work because, as long as someone can go into ChatGPT, figure out what that description is, take that and stick it in the AI tool, the building is designed. So it's like, it's really disruptive in this particular space. And I think the other sort of flip side to this is that while things can look really beautiful, we tend to run into a lot of budgeting and cost overruns and value engineering at a later date because, the tools that kind of spit out these images spit out very high images. And then, we kind of have to engineer it and make it really workable. So there's a lot that we kind of need to manage at that kind of the stage of design. BIM is something that we've been working on, as I said, since 2008, which is building information modeling. So plans are no longer just 2D. We are looking at, three-dimensional plans that have all the various disciplines of engineering built into it. And each of these things carry data. So, you're able to kind of tag it almost like a database that helps you manage this project asset. Very often, this helps in facility management and management of a building at a later date because you can tag down annual maintenance data to this. You'll know when your machines are up for rework or some kind of fine tuning, etc. So there's a lot that can be done through this stage. Blockchain is kind of new to us, and honestly, I think it's again more tended towards the management side. So you can start managing complex and large projects by loading all this information that kind of exists in a very transparent space for everyone to be able to access. So we can do things like having smart contracts, we can try and enforce the project scope, eliminate processing fees, etc. So all of this, I think, is definitely more your realm in terms of audit and financing. So I'm no expert on this, just the first two stages. In terms of construction technique, so basically we're looking at rapid construction. I think time is money and everyone is looking for ways in which we can cut down the construction time. So we are doing this by having new materials, and some of these are GFRG panels, which are glass fiber reinforced gypsum, which is basically like a drywall system, which is glass reinforced and can be pre-loaded and made into a panel off-site, just brought and quickly assembled. The next one is, of course, modular and precast, though this has been around for a while. Precast technology is always trying to reinvent itself. The other one is, of course, the light gauge steel frame. So, a lot of the projects that require rapid response time, like, for example, in Kerala after the floods, people use these GFRG panels to quickly sort of rebuild entire communities. Technology of Maivan. Maivan is nothing but like a commercial kind of a brand name, like Xerox is for photocopying, Maivan is for aluminum formwork. So basically what this means is that every floor of a building can be made into a mold like you would have jello and poured in concrete. So once this is done, it's just about taking this entire frame, putting it on the next level, pouring that stage. So as long as every floor of the building is the same, you can use Maivan beautifully. So for larger mass housing, so we're building towers in Hyderabad, which are like 35 to 40 floors, and it's all residential, and it's all similar products on every floor. Maivan works like a charm, and it cuts down your curing time. It doesn't have your 21 days per floor to kind of move to the next level. So it's really a rapid way of constructing. So the third part is, of course, looking at how you can monitor while work is going on site. So here we're seeing huge number of new apps that are coming up, which help project managers go on to site, app track. I remember having a conversation with Captain also about, how, construction workers, their attendance is being checked, their efficiencies are being checked. So there are like a whole bunch of things that can kind of start happening on the management and the construction management side. So yeah, you can track everything remotely. You can have like an integrated design project where, all team members are sitting in various parts of the world, but are still able to track that one project. And this, of course, will also tie into, I think, the part where the auditors come in, which is, the payments, the managing of the budgets, and all of those other things. The digital twin technology is, again, something that's really tied in with both BIM, which is the building information management, as well as your modeling softwares and your AI-based visualization softwares, wherein a twin which is actually loaded completely with the data of the building exists virtually. I was recently at a talk where, they were talking about the digital twin of Changi Airport, and Changi Airport's digital twin exists on the airport manager's, iPad and his screens, and he's able to track exactly what's going on in terms of the building, its efficiency, its daily functioning, as well as details of which flight has landed, what's going to be opening up. So, you kind of understand just by sitting at your desk what's going on instead of having to go around and, make sure that things are on track. So there's a lot that can happen on the digital twin front. So building products are constantly evolving. When I first moved back to India after working in Chicago, we had exactly a handful of green products that were on the market, and products which are sustainable, better efficiency and all that. And this has changed dramatically in the last 2 decades or so. So some of these exciting kind of new products tend to harness renewable energy from either solar sources or from people walking on them, like a picture of these tiles that we're showing here. Sensor-based interventions for water efficiency has been around for a while. We're all used to working with sensor-based taps and water features in bathrooms, etc. Apart from this, pushing the envelope on this is your control of the environment of the entire building. So we have temperature monitors, humidity sensors, we can have CO2 monitoring systems, and all these things tie into what is called the Integrated Building Management System, or an IBMS, which then again functions with the digital twin, spits out data about your actual efficiencies on a daily basis and helps you manage that dashboard. So some new green technology and building products, star-rated appliances, which are a lot more energy efficient, green label products using wood, which is, coming from a sustainable source. And I think at this point, I'll be happy to hand it off to Samita, because she starts talking about sustainability and how a similar process of design, construction, and operations works on the sustainability front.
A very good afternoon to all of you, and thank you, Pavitra, for setting the tone for this session. And I think to just take off from where Pavitra ended, sustainability as such relies heavily on technology today. I mean, what people often get confused is when I say it's a sustainable building, it has to have red brick or rammed earth or something like that. But today we are building millions of square feet in a span of a year or 7 months, 8 months. So in that scenario, technology becomes very critical. And how do we bring in concepts of green efficiency, climate responsive design? And we cannot do that at the scale that we are going without technology. So again, just to follow the same framework, I'll look at looking at design phase, how we bring in technology through various tools, how do we integrate sustainability at the design phase, and again look at construction. So during construction, what all can we do to be sustainable? So a lot of water is being used for curing purpose. A lot of waste is generated. A lot of landfills exist because of construction waste. So how do we minimize all of that? And finally, how is it that operationally, it's important, whatever we've designed, whatever we've spent extra on, in trying to get an excellent green building or a sustainable building, if it is not operated in the fashion it is designed for, then the entire exercise is a waste. So operational sustainability is also something that we look at. And I'll probably run it through with some examples. Just to start with, today there's a lot of push from the global market or from the global leadership as well as country leadership, where we're looking at net zero, we're looking at green, climate resilient buildings. So with all this, the most fundamental factor is how do we design with the focus that the people, community, basic needs are taken care of. That becomes most often when we start talking of technology tools, we tend to forget what is the primary objective, and that's why this slide is one of my powerful slides. So looking at design tools, when we're talking about sustainability, most often when I get into the project, the client or the owner will say, my building is sustainable. I've done everything possible. I've done rainwater harvesting. But that does not definitely define what sustainability is. You may have done a couple of parameters. So we need to have a holistic approach or a guideline. And this is where, rating systems or tools that we call green building tools or rating systems help us or help project teams lay out a roadmap, lay out a framework, how they can go step by step towards green. So it's not just focus focusing on water or not just energy, but you're looking at a holistic approach where you're looking at the site, the water, materials, air quality, occupant well-being, all of these parameters. So this is where rating systems, which have been of course, globally they've been around for a while, but I think from the early 2000s, India slowly started adopting green building rating systems. Today, many projects do it, and we have billions of square feet that are certified green. It gives us a framework. So you have the Indian Green Building Council LEED, which is basically leadership for energy and environmental design. Now, the new rating is WELL. LEED, IGBC focus on green buildings. Now, WELL is the next step, where you're not only looking at the environment, but you're looking at the people using the space, because that has become the more and more concerns are being raised post the pandemic on building health and safety. So that is one thing that's coming up. The next important part is codes. In fact, India did not have an energy code for buildings until very recently, in 2007. So, I mean, 2007 was the first code that India developed, and today, even getting codes mandatory in the states, the entire country is still not following codes. It's partial, like Telangana has a code implemented, Tamil Nadu still does not have a code. So these are some things that the country at a national level is working on, and state governments are also pushing. So there's a difference between codes and rating system. That's why I differentiated it. Code is policy driven, it's by the government, it is mandatory, whereas rating system becomes a voluntary approach. And the third part, there are various software tools, like you just saw in the previous session, where you had, AI, blockchain, you have BIM. We have software tools to actually see how green and quantify your energy savings, or quantify, if you're saying I've done fresh air ventilation. So how can you quantify? This actually bridges the gap between the architect and engineer. I don't know how many of you are aware. Engineers always come back and say, the architect is designing, but this is not relevant. No, but we have numbers to back everything today as per design. So just to give you an idea, these are the tools that are available today. I mean, there are millions of tools that are there, but you can actually analyze your daylight. You can actually quantify the energy savings. If I say I'm going to do high performance glass or roof insulation, I can exactly tell you if I'm spending 10 lakhs, this is my energy savings. So these are the tools that are available today. We have airflow modeling can be done. So just a quick slide on what is the policy in Tamil Nadu as far as sustainability and buildings go. We have implemented, we have notified the Energy Conservation Building Code by the Bureau of Energy Efficiency. It is still not included in the combined building rules. So the implementation is still pending, but the notification has happened. So, it is important for us as designers to incorporate that. And there is also GO on for residential buildings, which talks of a few parameters where, the thermal properties of the walls and glass is included. So that's called HUDD, Housing and Urban Development GO number 57. So these are the only policies that exist as far as. Just to give you a quick case study on how these tools have helped us. This is a small building, about 30,000 square feet on Nungambakam. If you look at at the design stage, how did we achieve, a certain, exercise? If you look at the architect, we work closely with the architect. He just gave us a bare shell because, he said, you come up with suggestions. Very rarely that happens for us as consultants. Normally there is a design that's frozen and we are expected to back work. Here he said, you tell us the suggestion. So what we did is we created the energy model, as you see in the down, and we did a couple of iterations, one with the solar canopy and without a solar canopy. And we did various cases with high performance glass, with shading devices, without shading devices, with aerated aerocon bricks, with regular bricks, with concrete. So we did about 9 cases. And if you actually see here, the numbers, I don't want to go into details, but if you see if I did a regular construction without any shading devices, without high performance glass, I would have been consuming 954 megawatt hours per annum. So as against the best case scenario, which is case 8, where I would have consumed 459 megawatt hours per annum. So best case requires some amount of cost, right? So so when we worked with the client, he came back saying, no, let's not do insulation. Let's not do this. So we arrived at the best possible or optimal solution, which is case 9, where we are able to achieve 620 megawatt hours per annum. So do you see the percentage of savings? If your bill is 10 lakhs, 40% of 10 lakhs is being saved every month. So this is the kind of impact that an energy simulation tool can give you. This is a school building, and if you just see a simple analysis of a classroom at the design stage, so these are the 3 windows on the other side of the classroom, whereas there are 2 doors on the other side of the window on this side, if you see on the side below, which were solid doors, which were initially planned as solid doors because that's how we normally design classroom spaces. But if you realize, the blue area is where you actually have around 300 lux levels, and we were not able to achieve that amount of daylight in case 1. So it just made a design decision more simpler, where we said, let's make the doors also glass. So that means then if you look at the second case, we are able to have diffuse daylight throughout the classroom. So these are, and this is an image of the classroom. So just simple tools that can actually help us in the design stage where we are able to achieve what we're, intending to design. Coming to the construction part. Here, sustainability, of course, while we are using technology, we also have a lot of construction practices over the years which have actually impacted and contributed to climate change. And in fact, landfills, our major contribution towards landfills is construction waste. And if you realize, 100% of construction waste can actually be diverted or recycled if it is managed properly at site. So there are simple ways in which we do it. One is I'm looking at even prior to construction, how do we ensure that the site can be prepped in such a fashion where we minimize pollution control, where we don't have to trouble the other neighboring sites. So some measures I'll talk about how we do it through case studies. And during construction, waste management becomes critical, and resource optimization. During construction, there's a lot of water that is used, labor. How are these things being handled in site? So some of the measures, I'll just quickly run through it. If you look at how do we control erosion or pollution at site, we barricade the site. There's some, even if you can buy treated water from neighboring sites and use it for water spraying on the roadways so that you don't generate too much dust. Swales to ensure that the runoff from the site is, because it's a barren site, when it rains, there's a lot of runoff and it can cause disturbance to even the neighboring sites. So if you can create swales or bunds or a sedimentation tank. So these are some of the measures we have implemented in projects that we have designed. So this is just a simple case study. This is a Coal India corporate office building in Calcutta. So they did simple measures. They used cement bags to barricade the site. They created a sedimentation tank at the point of runoff. They also had a wheel washing facility. So traffic coming in, the equipment, the lorries, etc., all of that could bring in dust. So how do we avoid that? And even the existing trees at site were protected. So these are some of the measures. Moving on to waste management, which is also a very important, in fact, it is being talked about a lot today, especially people think that energy and water crisis are one of the major things that is going to happen, but waste is one of the biggest crises that we are going to face. And how do we handle waste? So we are looking at not only managing the waste, but how do we at the starting point reduce waste? How do we eliminate or reduce? So that today we have a lot of dry construction panels. We have factory-made panels that are coming in. So these are areas where we can reduce waste. And all this has to be planned at design stage, because the structural elements, the MEP, all of them are fixed at the design stage. So this is actually a conventional construction which was done for Coal India corporate office, but how site construction was managed, all this waste was segregated at source. So it makes it easier to engage recycling agents and vendors to, and whatever could be reused at site was reused at site. And this is a simple, this is a school building, the same school that I was talking about. In fact, this existing house that you see on the left side was moved by about 20 meters just through channels, so that you don't demolish and rebuild. One, it becomes cost effective. Second, you're not creating waste, you're utilizing resources. And today this is a simple technology. They just laid out channels and did it. But how can you utilize, again, technology to minimize waste? So in this school project, we use precast, again, to avoid waste generation. So waste was very minimal and managing also becomes easy. Your internal walls are dry panels, aerocon panels. Not only are they, energy efficient, not only are they, contributing to sustainability in terms of life cycle analysis, but they also help in minimizing waste. And no water is used for curing purpose here. We were also able to insulate the walls easily because they're all factory made. Again, this is Coal India building where we, if it's a conventional construction, there are ways. There are jute bags that can be used for curing, with the ponding method for reducing water consumption of, coffered slabs. These were some measures that we were able to achieve. Just to show you, this is the Coal India corporate office building. The other one is the school which I spoke about, the precast structure. Then finally moving on to technology and sustainability as far as we're looking at operations of the building. Today, when we were asked to do a benchmarking exercise of buildings in Tamil Nadu, take a sample size, getting data from buildings had such a cumbersome task for us. And why is that? Because we don't monitor. We don't know where the leakages happen if it's water. So how do we ensure, what gets measured only can get improved. Otherwise, we don't know where we stand. So technology has become very important. Here, we're looking at a data-driven approach. How do we use data to enhance performance? And the most critical part is having a building monitoring system. So this today, most projects are being designed with building monitoring system where you can monitor just not energy or water consumption. You can monitor your CO2 sensors, humidity, temperature, occupant well-being, satisfaction. So many parameters can come in and it's all flexible for as far as the user is concerned. So here, how do we track, measure and improve building performance? We have actually divided into 3 parts based on our experience. One is how do we collect data? Is data collection for every building easy? Because if you expect every person, if the management staff has to go to every meter and take down readings, they will be bound to have errors. So how do we streamline that process? How do we use technology to make sure the sensors are all connected? How we have a one-point contact of collecting all the data? And what do we do with the data? The data visualization, how do we analyze the data? In fact, Infosys is a classic example how if you ask them how much energy is consumed per person, how much energy is consumed per square foot of floor area, they will tell you all these parameters because they're constantly looking to improve because today they have 10,000 employees, tomorrow it will be 20,000, but you cannot increase the resources proportionally. So how do we minimize that? And monitoring. So if there is continuous monitoring, you will be able to plug the leakages, the performance, where there's a shortfall in performance. So just a quick case study on Infosys Pune, where they installed smart metering, because this was an old building and they had to install smart metering. And this has helped reduce per capita consumption by at least 24% from the 2008 levels. Of course, this was a project in 2019 that we did, 18 or 19. So in 10 years, they were able to achieve a 24% reduction just in water consumption. Then going on to how they implemented a BMS system, which monitors occupant comfort. So they know whether the people, the well-being, because for them, their entire business depends on how happy the people are and how their performance is. So their occupant comfort becomes critical. Indoor air quality, which is also related to the well-being of people, how much of fresh air is being pumped into the space. Energy intensity in terms of kilowatt hours per person. Water intensity, health of critical assets, critical operations, renewable energy, they have extensive solar panels. What is the amount of water and wastewater that is being generated, that is being reused, and overall performance at various levels in the campus. So all this is on one dashboard for them. And what is it that they were able to achieve? Is they were able to monitor occupant performance. They could tell exactly how much percentage of the people were unhappy, what are the measures that are required to make sure that that small percentage is also satisfied. Water efficiency, they identified over 200 kiloliters of water leakage. Can you imagine? That much of leakage was happening without identification. Then, of course, occupant well-being, where they stress a lot on occupant well-being. And identifying inefficiencies even in energy. So if the windows are open when the air conditioning is on, there is a message that goes to the operations platform. So these are things that they can minimize inefficiency and performance monitoring overall. And a very interesting thing that they have done is they have calculated how much of GHG, greenhouse gas emissions, as a result of between their offices the employees travel. And to they have a policy in place to minimize employee travel, and they were able to reduce drastically the GHG emissions as a result. 5 kilotons is what they have estimated. And they also developed an app within the campus, because they have very large campuses in Bangalore and Pune, even Chandigarh. So they have apps where employees can say, if I'm going to a place and if he is wanting to car share or a carpool, they can log in and they can pick points and go. So that way they've also reduced a lot of greenhouse gas emissions as a result of transportation, single-use transportation. They also have a performance tracking. This is there at their lobby level. You can actually know how much of water, energy, as against a global benchmark. So you know how much of energy, water, wastage, how much of transportation, score, what is your human experience. All of this is displayed on their platform for everybody to understand and use. Interestingly, if you see here, they did a digital collaboration to reduce the CO2 emissions. How did they arrive at an aim, methodology and solution? They implemented a remote working platform, and they have ensured that, and they've used technologies like Cisco, Skype, etc. to ensure that the GHG emissions are reduced drastically. So having spoken all about the first part of the session where technology we use and sustainability, how critical it is, it is a part of design and it is essential. It is the only way forward, considering the built environment contributes to about 36% of the global greenhouse gas emissions. So you would be surprised. You would think it's a transportation or industrial or factories. No, it's the built environment that contributes to the sizable chunk of GHGs globally and in India. So the pros is, one, it's scalable. You can easily handle the increased demand. Today, Hyderabad is building millions of square feet in one go. All of that is possible. Much faster time frame. Today, you've never heard of buildings in 6 months, 7 months are being constructed. It's of course cost effective. It reduces waste. But what happens is, there's some aspects that we also have to overlook, and we have to find a middle path. One is, how do we are only looking at operational energy. If I use precast panels, my operational energy is going to be lesser. But how are we looking at embodied energy? Embodied energy is the energy that is used in the manufacturing source. It's used for extraction, making of the raw material, making of the panel. So that embodied energy, most often we don't have enough data for that, so we tend to overlook. So that is something that we have to look. And design limitations, like Pavitra explained, the formwork and concrete being piled up in My One technology. Once it's done, you cannot change your design. Especially in residential, you may want to break one wall and increase your room space, or you may want to do something else. It kind of restricts your flexibility in design. That is something we may want to see, whether we put in dry panels inside and just look at the formwork for the exteriors. That's something that, the designers will have to take into account, studying both the pros and cons. And also in terms of, in higher initial investments. So this is something that we always have. In fact, every developer, if it's a corporate office which you're building, you tend to gain from, the first cost. But when builders do projects, not necessarily that they gain the savings from energy or from water. So what happens then? So how do we handle the initial investment? So these are some of the this is where we use tools to ensure that, we're able to come up with optimal solutions and optimal approach. And that's the only way forward. Thank you very much. We are happy to take questions.
Thank you for a lively presentation. Beautifully started with the basics, managing projects, visualizing, use of AI, Mayvan technology. It was just like plain building blocks, app-based real-time monitoring, digital twin and remote monitoring, and on the sustainability, rating system, safety, being responsible for green earth, measurability and quantification of cost and energy saving, recycling waste, role of technology in data collection and management, I think it's maximizing efficiency and protecting the environment and making the most of it. Like the digital twins, I think both of you made the presentation so lively as knowledge twins on technology and sustainability. Thank you so very much. May we now request CA Rajagopalan, Treasurer, Society of Auditors, to present a memento to M. Samhita. Ladies and gentlemen, a big round of applause, please. Thank you. May we now request CA Mohan, Vice President of the Society of Auditors, to present a memento to Ms. Pavitra Sriprakash. A round of applause, please. Thank you. Any questions from the audience?
Okay, the question is how to reduce the heat from a terrace that affects the apartment below the terrace. And you have also put in brackets so that even after good waterproofing or weatherproofing, this seems to be happening. So typically what this falls under is at the design stage, we look at how we reduce urban heat island effect from a rooftop. And there are 2 or 3 strategies that we typically kind of try to include. One is at the design stage, we design the top structural slab to be something that can take a green roof, because this really helps, because once you plant the roof, then it's easy for us to sort of, increase that U value that is incident on that roof, and that helps us make the thermal efficiency of the top floor a lot better. Most cases, this is not possible. But one story here is that at the time when I was just about to leave Chicago, this I'm talking about 2002, 2003, it became mandatory from the city's mayor's office to put in green roofs. Just like it's mandatory in Chennai now to include some percentage of rooftop solar, it became mandatory to put in green roofs to reduce this particular effect. The second thing that we find people are doing a lot is to increase the reflectivity of the top. So we are able to put in, high SRI. SRI is solar reflective index, which is basically a reflective surface on the top. Because this is just like the simple logic of us wearing white clothes in summer versus like not wearing black, because black absorbs and white reflects. So there are high SRI finishes, which are either coatings or tiles, which you can put, and this helps hugely in the top floor comfort level. The third thing that you do is insulate. Like I think Samita walked us through the precast panels in the school having insulation built in. Typically we think of insulation only for cold countries because it helps you keep something warm, but insulation also helps us stay cool. So there are 2 types, either over the deck or under the deck. So the weatherproofing layer can have a layer of insulation that's a part of the actual mother slab. Or otherwise, if you want to do it as a false ceiling within the apartment, this can be retrofitted, and you can put in a gypsum false ceiling with some amount of insulation in there. So I think there are like a couple of ways in which you can try and affect this. But Samit, anything to add?
Yeah, whatever you said, you've covered it all. The most important thing is, just know which is more effective, which material as an insulation will contribute better. If you're looking at overdeck, it's obviously overdeck is over the roof, will obviously be more effective than underdeck insulation. So, and incidentally, since you spoke about Chicago policy, Telangana has a cool roof policy. So it's mandatory for all your roofs in Telangana to have either a reflective paint or a green.
If there are no other questions, we'll break for lunch and get back at 2 o'clock for the next technical session.
Thank you all very much. Thank you. It was lovely being here.
tax laws, especially the indirect tax laws, with specific focus on goods and service tax and customs. He is a successful indirect tax law counsel appearing before Honorable Customs, Excise and Service Tax Appellate Tribunals, the Director General of Foreign Trade, VAT Appellate Tribunals in various states and customs appellate authorities. Different GST authorities including GST Appellate Forums, GST Authority for Advanced Rulings and National Anti-Profiteering Authority (NAA). Hitherto, he had directly been instrumental in several excise, VAT, service tax and GST related developments by interacting with the concerned ministry and or bureaucrats. His suggestions relating to customized compound levy scheme has been acknowledged by the Honorable Prime Minister's Office on 24/7/2015 for favorable consideration while implementing in stages the goods and service tax in India, Section 10 of the CGST Act 2017. Read the relevant version, partly implementing his suggestion. Ladies and gentlemen, I think this deserves a big round of applause. I'm sure a whole bunch of MSMEs is thanking him today for this. He is a professional who delivers lectures in various government forums, including Regional Training Institute of Comptroller and Auditor General, National Academy of Customs, Excise and Narcotics, NACEN, Commercial Taxes State Training Institute, Tamil Nadu and Zonal Training Centers of Reserve Bank of India, etc. In the media and society, he has given a series of interviews and has participated in tax law related discussions on various television programs. He has delivered several lectures on various topics, especially on indirect tax laws, in various workshops, seminars, conducted by educational institutions, universities and economic research centers. He is the founder member of few non-profit academic societies focusing on indirect tax law related academic activities and as well as social services. We are very honored to have you with us, sir. Thank you. May we now request CA Velumuthu, life member of the Society of Auditors, to present a health bouquet to CA Prasanna Krishnan V. Thank you, sir. Over to you.
Yeah, can do it. This one. Thank you. Learned brothers and sisters, good afternoon. Good afternoon. Thank you. Because after hearing me, if you are coming to this mood, I can understand. Before that, I don't see any reason. Anyhow, very nice meeting you, all of you. For believers only, of course. It's a story in mythology. I don't believe that it's a mythology. It's different one for me actually. But in Ramayana, for the death of Ravan, various reasons are told, including a very serious reason of a very indecent misbehavior by a human being. Of course, that is the death penalty could be the best penalty for him. He suffered it. But learned people used to say that there is another reason for that also, a serious reason, equally serious reason. His brother, Kumbhakarna, was well known for his excellent sleeping habit actually, extraordinary sleeping habit. When Ravan was in need of some help from him in the war front, this guy went to him and made a big battalion to go to him and make him to wake up and then come to help him. The learned people say that such a sin will warrant death penalty seriously. If for making such a sin once, death penalty, one-time death penalty, of course, is the possible punishment, I am not sure how many times I will be given death by God actually. Because this is what I am very religiously practicing for more than 2 decades time. And approximately thousands and thousands of people I would have made their sleep to spoil. I don't know, God should be with me. Coming to this one. Generally, this could be there in the mind. No, the guy who is there in the photo is not me. Perhaps some similarities could have been there. I am not that much worse, and at least my spouse accepts that I am a very handsome man, of course. Coming to this matter. This is what the feeling, because too much of confusions said to be there actually. But carefully I am using the word said to be there. Really, it's an excellently drafted and very well implemented one, at least now, if not earlier, at least now. Let us not spend too much time on the very detailed nuances of these matters for one simple reason. I know very well there is a serious need for going to the practical issues in simple language actually. That's very important, I believe, if I'm rightly believing and understanding the requirement of the organizers as well as the participants, if I'm rightly understanding. Let's just briefly but simply discuss. Sir, was contract na enna sir? Minna ella goods gala irundhathu. Ipo goods gala kedaiyadhu. Appo enna sir na adu enna service predominant irundhaduna service. Goods predominant irundhaduna goods. That will be deciding in a composite supply. Was contract na ore oru vaartha that will be suitable and fitting only for one. That is, if you are having any kind of structural additions by doing a civil work, section 2 subsection 119 is covering reasonably. The rest of things will not be covered there. Depending upon the classification, it will go. So, wherever we are referring to was contract, we are talking about only this particular industry, that is the construction industry. Without spending much time on this particular point, we know very well it's a composite supply. Or goods irukku, edo konjam material irukku, அதை சேர்ந்து சப்ளை பண்ணுறோம், that is what there, and predominantly it is coming under the service category, because that is how it is being classified in this law also as a supply of service. Now, there are some provisions which are supposed to be known to you. I don't want to go into the details of that one because we have much more important things to discuss. இதில் பார்த்தீங்கன்னா ஒரு ப்ராட் ஸ்ட்ரக்சரில் ஒரு விஷயம் மட்டும் தெளிவாக தெரியுது. இம்மூவபிள் ப்ராப்பர்ட்டி ட்ரான்ஸ்ஃபர் ஆச்சுன்னா எந்த ஜிஎஸ்டியும் இல்லை, அது மட்டும் ரொம்ப கிளியராக தெரியும். மற்றெல்லாம் தெரியாது, கன்ஃபியூஷனாக இருக்குது, தெரிஞ்ச மாதிரி ஒருத்தர் சொல்லிட்டாரு, அதை நான் நம்பின்னு இருக்கேன், இதெல்லாம் வேறு விஷயம். இதான் நிறைய ஆக்சுவலாக யாரோ ஒருத்தர் நிறைய சந்தோஷமாக சிரிக்கிறார். ஆமாம் சார், இதான் சார் நாட்டில் நடக்குது, தெரிஞ்ச மாதிரியே பேசினுக்கிறான் சார் எல்லாம். இதில் பெரிய பிரச்சனை என்னென்னா, யாருக்கு கரெக்டாக தெரியும் யாருக்கு கரெக்டாக தெரியாதுன்னு கண்டுபிடிக்க முடியல சார். ஏன்னா தெரியாதவன் தான் ரொம்ப கான்ஃபிடென்ட்டாக பேசினுக்கான், தெரிஞ்சவெல்லாம் பாவம் எங்கேயோ ஆஃபீஸ்க்குள்ளே உட்காந்து ஏதோ உட்காந்து தட்டின்னு இருக்கான், அவன் பாட்டில் இல்லை கோர்ட்டில் போய் கத்தின்னு இருக்கான். ஸோ இதான் சார் ஒரே கன்ஃபியூஷனாக இருக்குண்ணா, அது கரெக்ட் தான் ஆக்சுவலாக. ஸோ கமிங் நிறைய செல்ஃப் மேட் குருஸ் ஆர் தேர் இன் திஸ் ஃபீல்ட். இது ரொம்ப அது வந்து சம்திங் லைக் காமதேனு, அது பாட்டில் இட் வில் பி கீப்பிங் ஆன் ப்ரொடியூசிங் சோ மெனி செல்ஃப் மேட் குருஸ். யார் வந்தாலும் நான் ஒரு ஜிஎஸ்டி ஸ்பெஷலிஸ்ட், நான் ஒரு ஜிஎஸ்டி ஸ்பெஷலிஸ்ட்டு. ஸோ நீங்கள் ஜிஎஸ்டியில் யாரும் ப்ராக்டிஷனரே கிடையாது, எல்லாரும் எக்ஸ்பர்ட். சில பொலிட்டிக்கல் பார்ட்டிகள்லாம் பார்த்தீங்கன்னா எவனுமே பார்த்தீங்கன்னா ஒர்க்கரே இருக்க மாட்டான், எல்லாருமே லீடராக இருப்பான், அவன் ஒரு லெட்டர் பேட் வச்சு சுற்றிட்டு இருப்பான். ஸோ இதே மாதிரி இங்கேயும் பார்த்தீங்கன்னா, சார் நான் ஜிஎஸ்டி ப்ராக்டிஸ் பண்ணுறேன் அப்படின்னு சொல்கிறவரே கேட்க மாட்டீங்க. ஐ எம் ஜிஎஸ்டி ஸ்பெஷலிஸ்ட், அவர் ஒரு ஸ்பெஷலிஸ்ட், அவ்வளோதான். ஐ எம் ஜிஎஸ்டி எக்ஸ்பர்ட், அவ்வளோதான். இன்னொரு நான் ஜிஎஸ்டி குரு, அவரே சொல்ல வேண்டியதான். நம்ம மற்றவன் சொல்ல மாட்டான்னு தெரிஞ்சு போச்சு, அட்டில் நம்மளே சொல்ல வேண்டியதுதான். ஸோ கமிங் டு திஸ் ஒன், ஸோ இன் திஸ் கேஸ் யூ நோ வெரி வெல் தட் தி இம்மூவபிள் ப்ராப்பர்ட்டிஸ் ஆர் நாட் அட் ஆல் கோயிங் டு ஹேவ் எனி கைண்ட் ஆஃப் ஜிஎஸ்டி. இட்ஸ் வெரி கிளியர். அப்போ இம்மூவபிள் ப்ராப்பர்ட்டினா என்ன சார்? பேசிக் டவுட். சில டைமில் அது மாதிரி தான் ஏதாவது ரொம்ப பேசிக்காக சில ஏதாவது கேட்கும்போது வெளியிலேருந்து பார்க்கறது இதெல்லாம் ஒரு கேள்வி அப்படின்னு தோணும். பட் அதுக்கு உண்மையிலே நீங்கள் எக்ஸ்பர்ட்டாக இருந்தால் கரெக்டாக பதில் சொல்லணும். யூ மே பி எக்ஸ்பர்ட், ஃபைன், ஓகே. இது ரொம்ப லோ லெவல் கொஸ்டின், ஃபைன், ஓகே. பட் யூ ஷுட் பி ஏபிள் டு ஆன்சர் தட் ஒன். ஸோ இம்மூவபிள் ப்ராப்பர்ட்டி லாட் ஆஃப் ப்ரொவிஷன்ஸ் அதை ட்ரான்ஸ்ஃபர் ஆஃப் ப்ராப்பர்ட்டி ஆக்ட் இருக்குது, ரிஜிஸ்ட்ரேஷன் ஆக்ட் 1908 இருக்குது, இதில் ப்ரொவிஷன்ஸில் டீட்டெயிலாக இருக்குது, எல்லாம் ஓகே. நம்ம சிம்பிளாக அண்டர்ஸ்டாண்ட் பண்ணிக்கணும்னா, ஒரு லேண்டை பார்க்குறீங்களா, அது இம்மூவபிள் ப்ராப்பர்ட்டி. லேண்டு மேலே ஃபாஸ்டன் ஆகி ரொம்ப சீக்கிரம் இடிக்க முடியாத ஒரு பில்டிங் பார்க்குறீங்களா, அது நம்ம பிடபிள்யூடி கட்டுற பில்டிங்லாம் விட்ருங்க, அதெல்லாம் நம்ம இடிக்க வேணாம், அதுவே எண்ணி வந்துடும், சரி விடுங்க. ஸோ ரொம்ப சீக்கிரம் இடித்து முடியாத மாதிரி விச் இஸ் ஃபாஸ்டன் டு த எர்த் ரீசனபிளி, தென் இட் வில் பி கால்ட் அஸ் இம்மூவபிள் ப்ராப்பர்ட்டி. ஸோ இப்போ இம்மூவபிள் ப்ராப்பர்ட்டினா எல்லாரும் இம்மூவபிள் ப்ராப்பர்ட்டி தான் சார் கட்டுறாரு. பேரன் லேண்ட்லேருந்து ஒரு இம்மூவபிள் ப்ராப்பர்ட்டி வர்றதுன்னா அது அவர் கட்டுறது தானே. வாட் ஐ எம் ரெஃபரிங் டு இஸ் அட் தி டைம் ஆஃப் டீல், ஒரு டீலை ஸ்ட்ரைக் பண்ண போகிறீங்க, நீங்கள் வீடு வாங்க போகிறீங்க அப்படின்னா, வீடாகவே கண்ணு முன்னாடி பார்த்தீங்க அப்படின்னா அது இம்மூவபிள் ப்ராப்பர்ட்டி. வெறும் பேரன் லேண்டை பார்க்குறீங்க, இனிமேல் தான் வரப்போகுதுன்னு பண்ணுறாருன்னு வச்சுக்கோங்களேன். ஏதோ ஒரு சீன் சொல்கிறார், இப்படியே வரும், இந்த 13வது மாடியில் 7வது இடத்துல லெஃப்ட் சைடில் திரும்பிங்கன்னா உங்களுக்கு பில்டிங் சொல்கிறார் பார்த்தீங்களா, அதுதான் அவர் இனிமேல் தான் அந்த சர்வீஸ் உங்களுக்கு கொடுக்க போகிறாருன்னு அர்த்தம். அது சர்வீஸ். அப்போ அங்கே லேண்டுக்கு வந்து டேக்ஸ் கிடையாதுன்னு சொன்னீங்களே சார், அப்போ நம்ம லேண்டை மட்டும் விட்டுட்டு தானே சார் டேக்ஸ் பே பண்ணணும். அது ஒரு கேஸில் நல்ல கேஸில் இருக்குது, அதை பற்றி பேசணும் நம்ம. நான் ஏற்கனவே சொன்ன மாதிரி பார்த்தீங்கன்னா, இந்த பார்ட் லேண்டோ லேண்ட் அண்ட் பில்டிங்கோ அந்த 5B பேராகிராஃப் தேவைப்படும் போது இன்னும் டீட்டெயிலாக பேசுவோம். அதில் இது கவர் ஆகிடும்னு வச்சுக்கோங்க. See, நார்மலி ஸ்பீக்கிங் திஸ் இஸ் த ரேட் ஆஃப் டேக்ஸ் வாட் யூ ஆர் ஹேவிங். அது என்ன சார் அது நார்மலி ஸ்பீக்கிங்? இல்லை இது ஜென்ரலின்னு எப்போயாவது சொன்னோன்னால கொஞ்சம் கேர்ஃபுல்லாக இருக்கும். ஏன்னா ஸ்பெசிஃபிக்லி வேறு எங்கேயும் டேமேஜ் இருக்குன்னு அர்த்தம். என்னோட வெல் நோன் கிளையண்ட் ஒரு மோர் தென் 2 decades கிளையண்ட் எக்ஸிஸ். அவர் ஜென்ரலி கிளையண்ட் தான் என்ன பண்ணுவார், நீங்கள் கிளையண்ட்டாக இருக்கிற யாரும் தயவுசெய்து தப்பாக நினச்சிக்காதீங்க. கிளையண்ட்டாக இருக்கிறவர் என்ன பண்ணுவார் அப்படின்னீங்கன்னா ப்ரொஃபஷனல் சொல்கிறது எதுவுமே கேட்க மாட்டார். இதுதான் வந்து கிளையண்ட்டாக இருக்கிறது குவாலிஃபிகேஷன். ப்ரொஃபஷனல் யாருன்னா இவன் தான் கேட்க மாட்டேன்றானே, இவனுக்கு எதுக்கு திருப்பி திருப்பி சொல்லணும் அப்படின்னு நினைக்க மாட்டார். திருப்பி திருப்பி சொல்லி நிற்பார். இதுதான் இவர் குவாலிஃபிகேஷன். இந்த மனுஷன் சாவராலும் இப்படியே தான் இருப்பார், அந்த மனுஷன் சாவராலும் அப்படியே தான் இருப்பார். டிசைன் அப்படி சார், என்ன சார் பண்ணுறது? சரி விடுங்க. நோ கம்மிங் பேக் டு திஸ் ஒன், யூ ஹேவ் a நார்மல் ரேட் ஆஃப் 9+9 9954 சாப்டர்க்குள்ளே போனீங்கன்னா திஸ் இஸ் த ரேட் விச் இஸ் நார்மலி ப்ரொவைடட் தான். ஃபைன், ஓகே. இப்போ இதில் சார் நார்மலி ப்ரொவைடட்னா வேறு ஏதாவது அப்நார்மலாக ஏதாவது சொல்லுங்களா? நான் இருக்குது, there is something else is there. இதில் பார்த்தீங்கன்னா யூ கேன் ஜஸ்ட் ஹேவ் a look on this one. இந்த ரேட் தான் வந்து எஃபெக்டிவாக வரப்போகுது. யூ ஹேவ் நோட்டிஃபிகேஷன் நம்பர் 11/2017 CTR amended. ஸோ அதில் பார்க்கும்போது யூ ஹேவ் சம் ப்ரொவிஷன்ஸ் 9954 என்ட்ரிஸ் ஆர் தேர். இந்த என்ட்ரிஸில் வந்து ஒரு எக்ஸ்ப்ளனேஷன் போர்க்குள்ளே போனீங்க அப்படின்னா ஸ்பெசிஃபிக்காக என்ன சொல்லுவாங்கன்னா, ஒருத்தர் லேண்டும் பில்டிங்கையும் சேர்த்து விற்கிற ஒரு வேலையை பண்ண வேண்டிய கட்டாயத்தில் இருக்காருன்னா, யார் அது டெவலப்பர் இருந்தார்னா, ஒரு டீமிங் பேசிஸில் 1/3 வில் பி த லேண்ட் வேல்யூ. சார் டீமிங் எப்போ வரும்? நார்மலி ஸ்பீக்கிங் டீமிங் எப்போ வரும்? லா மேக்கர் கடுப்பில் இருந்தாருங்கன்னா கண்ணாமனா எல்லாத்தையும் டீம் பண்ணுவார், அது வேறு விஷயம். பட் ஜென்ரலி டீமிங் எப்போ வரும்னா, உங்களால் எதை கண்டுபிடிக்க முடியாதோ அப்போ டீமிங் வரும். இது அநேகமாக இதுதான். இப்போ ஒன்றும் இல்லை, காடு உங்களுக்கு தெரியாதுன்னு வச்சுக்கோங்களேன், கடவுளை உங்களால் பார்க்க முடியாது. நீங்கள் என்ன பண்ணுறீங்க, அநேகமாக காடு இருக்காரு, நீங்கள் டீம் பண்ணிக்கிறீங்க. ஏன்னா உங்கள் நாலேஜ் அவ்வளோதான், அதுக்கு என்ன பண்ண முடியும்? அதுக்காக கடவுள் ஒன்றும் பண்ண முடியாது, அவர் பாட்டில் தேய்மான் தான் இருக்கார். உங்கள் கண்ணுக்கு தெரியலன்னா நீங்கள் டீமிங் பண்ணிக்கிறீங்க, இருக்கிறான்றதை உணர முடியல வரலாம். இதே தான் விஷயம். லேண்ட் வேல்யூன்னு ஒன்று சரியாக கண்டுபிடிக்க முடியாத போது நீங்கள் ஒரு 1/3 டீமிங் வச்சுக்கிட்டிங்கன்னா கரெக்டாக தான் இருக்கும். ஆனால் லா எழுதுன போதே தெரியாதமா என்ன எழுதிட்டாங்க அப்படின்னீங்கன்னா, நீ என்ன ப்ரைஸ்க்குன்னா விற்றுக்க, உங்கள் லேண்ட் வேல்யூ உங்களுடைய ஃப்ளாட் வேல்யூ ரெண்டுத்தையும் டோட்டல் பண்ணி அந்த டோட்டலில் ஒரு 1/3 பிளைண்டாக, அந்த வேர்டு கவனிச்சுக்கோங்க, பிளைண்டாக 1/3 நான் டிடெக்ட் பண்ணி பண்ணுறாரு லா மேக்கர். இதை பார்க்குற ப்ரொவிஷனை பார்க்குற ஒருத்தருக்கு செம கடுப்பாகி போச்சு. உங்களுக்கு லேண்ட் வேல்யூ ஒன்றுனா என்ன கேளுங்க, என் மேலே நம்பிக்கை இல்லைனா ஸ்டேட் கவர்மெண்ட்டில் ஹையஸ்ட் அத்தாரிட்டி ஒருத்தருக்காரு, குறைஞ்சபட்சம் இந்த கன்சர்ன் அத்தாரிட்டி இருக்கார், அவர் பேர் சப் ரிஜிஸ்ட்ரார். அவர் ஆஃபீஸ்க்குள்ளே போனீங்கன்னா நான் எவ்வளோ ரூபாய்க்கு லேண்டை வந்து ரிஜிஸ்டர் பண்ணேன்னு தெரிய போகுது. அதை நீங்கள் டிடெக்ட் பண்ணிவிட்டு மீதி இருக்கிற வேலைக்கு என்ன டேக்ஸ் பண்ணுவோம் போட்டு போக வேண்டியது தானே. ஓ யூ ஆர் ட்ரைங் டு என்ஃபோர்ஸ் சர்டன் திங்ஸ் ஆன் மீ அப்படின்னு ஒரு கேள்வி கேட்குறாரு. இந்த 1/3 வேல்யூ தான் என்னை கம்பல் பண்ணாது அப்படின்னு. ரொம்ப அருமையான ஜட்மெண்ட், ஒரு கிட்டத்தட்ட ஒரு 129 பேஜஸ் ஜட்மெண்ட்டில் ஒரு குறிப்பிட்ட பேராகிராஃபில் வெரி கிளியர்லி தே saying that we are striking down the notifications this particular part. பிகாஸ் சார் அதில் என்ன சார் லாஜிக்னா, உங்களுக்கு அந்த லாஜிக் புரிஞ்சிருக்கும், நான் சொல்ல வேண்டியதில்லை. சார் லேண்டுன்றது ஸ்டேட் சப்ஜெக்ட், லிஸ்ட் உள்ள வர கான்ஸ்டியூஷனில் லிஸ்ட் உள்ள வர மேட்ரு. இதை நான் டேக்ஸ் பண்ணணும்னு நினைக்கிறேன் யூனியன் கவர்மெண்ட்டு, முடியாது. ஃபைன், ஓகே. லிக்கர் டேக்ஸ் பண்ணணும்னு நினைக்கிறேன், முடியாது, லீவ் இட். ஆனால் நான் இன்டெரக்டாக நான் என்ன பண்ண நினைக்கலாம் அப்படின்னீங்கன்னா, சார் உங்கள் லேண்டும் உங்கள் பில்டிங் வேல்யூவும் டோட்டல் பண்ணி அதில் ஒரு 1/3 டிடெக்ட் பண்ணிடுறேன். சார் 1/3 இல்லை சார், ஆக்சுவலாக எனக்கு 44% வருது சார் என் லேண்டு, இருந்து போட்டோம், நான் 1/3 தான் கொடுப்பேன். சார் அப்படி பார்த்தீங்கன்னா என்னுடைய 11% லேண்ட் வேல்யூ நீங்கள் டேக்ஸ் பண்ணுறீங்க சார், இருந்து போட்டோம் பண்ணிக்கிறேன். திஸ் இஸ் வேர் த ப்ராப்ளம் கம்ஸ். அதர் வே ரவுண்ட் இஸ் டிஃப்ரெண்ட் ஒன். உங்கள் ரியல் லேண்ட் வேல்யூ 25% இருக்குது சார். 1 கோடி ரூபாய்க்கு ஒரு ஃப்ளாட் வைக்கிறீங்க, 25 லட்ச ரூபாய் வந்து லேண்டுக்கு அடக்க வேலைன்னு வச்சுக்கோங்க. ஒரு 75 லட்ச ரூபாய் வந்து லெட் மீ சே கன்ஸ்ட்ரக்ஷன் ஆஃப் ஃப்ளாட்டுக்கு ஆகுதுன்னு வச்சுக்கோங்க. இப்போ நீங்கள் இவன் 33% கவர்மெண்ட்டில் கொடுக்குறாங்க ஆன் இட்ஸ் ஓன் பை டிஃபால்ட்னா என்ன பண்ணுவீங்க? வில் பி வெரி ஹாப்பி. சரி, ஓகே, 33% கொடுக்குறாங்களா, எடுத்து போய்ங்க. அப்போ கோர்ட் கம்ஸ் டு சே லெட் இட் பி அட் தி ஆப்ஷன் ஆஃப் தி அசஸி. சார் அவருக்கு வேணும்னா, அவரால் ப்ரூவ் பண்ண முடியாதுன்னு நினைக்கிறாரு, அவர் ரெக்கார்டு தேவையான அளவுக்கு உங்களுக்கு சப்போர்ட்டிங்காக கொடுக்க முடியாதுன்னு நினைக்கிறாருன்னா, நீங்கள் சொல்கிறத ஒத்துக்கிட்டு 33% போட்டோம். இல்லையா, அவர் கரெக்டாக வேல்யூ சொல்கிறாரா, அந்த வேல்யூ பாருங்கள். தட்ஸ் ஆல் த திங், நதிங் மோர் தன் தட். So this is all about what we need to know, the very simple but serious basics of this particular provisions actually. Having said that one, here, இந்த ப்ரொவிஷன்ஸில் பொறுத்தவரைலாம் ஏதோ சர்வீஸ் பண்ணுறோம். கன்ஸ்ட்ரக்ஷன்றது வந்து நான் இப்போ பில்டிங் பற்றி நம்ம சொன்னோம், நிறைய கன்ஸ்ட்ரக்ஷன் பண்ணுறோம் சார். இது வந்து ப்ராடாக பார்க்கும்போது ஒரு கன்ஸ்ட்ரக்ஷன் ஒரு வேர்டில் சொன்னனால நிறைய விஷயங்கள் நம்ம பண்ணுறோம். இதெல்லாம் என்ன பண்ணுறது அப்படின்னா, சார் பொதுவாகவே கன்ஸ்ட்ரக்ஷன் 9+9 தான் சார் ஸ்டாண்டர்ட். நாம் பேசிட்டு இருக்கிற இந்த 1/3 கொஸ்டின்ஸ் எல்லாம் வந்து ஒன்லி ரிலேட்டிங் டு த டெவலப்பர்ஸ் மேட்டர்ஸ். அது கூட என்னன்னா ரெசிடென்ஷியல் காம்ப்ளெக்ஸ் டெவலப் பண்ணுறவனுடைய வேலை. அப்போ கமர்ஷியல் கிடையாது. கமர்ஷியலுக்கு லேண்டு தான், பில்டிங் தான், 18 தான், அவ்வளோதான். நதிங் இஸ் தேர் டு டிஸ்கஸ். சார் அது எப்படி சார் வேல்யூ பண்ணணும்? வி ஹாவ் டு. அதில் எங்கே இப்போ ப்ராப்ளம் வரதுக்கு என்ன கொஸ்டின் எங்கே இருக்குது? லேண்ட் வேல்யூ ஷுட் ஹவ் பின் தேர், தென் ஒன்லி வில் பி ஏபிள் டு டூ த டிராஃப்டிங் ஆஃப் எனி திங் அட் ஆல். அதில் வர சில 1-2 கன்ஃபியூஷன்ஸை தேவையான போது வில் டிஸ்கஸ் இன் டீடைல். இதுதான் சார் இப்போ எஃபெக்டிவ் ரேட்டு. சார் இவ்வளோ வரலாம் நல்லா தான் புரிஞ்சிட்டு இருந்தது. ஓ பரவாயில்லப்பா, செமினாரில் ஒரு 11 நிமிஷத்தில் எல்லாம் புரிய வச்சிட்டாரு, அவ்வளோதான் வெரி சக்ஸஸ்ஃபுல் செஷன், எல்லாம் தெளிவாக தெரிஞ்சு போச்சு, எழுந்து போயிடலாம்னு நினைக்கிற நேரத்தில் இந்த மாதிரி ஒரு ஏடாகூடமான ஸ்க்ரீனு, இது ஒரு ஏடாகூடமான போட்டு ஏன் சார் கன்ஃபியூஸ் பண்ணுறீங்க? நான் ஒன்றுமே பண்ணல சார், நான் நல்லா 1/4/2019 இதை இன்ட்ரடியூஸ் பண்ணாங்க. அது எதுக்கு பண்ணாங்கன்றது வேறு ரீசனு, அதை பேசுகிற அளவுக்கு நம்ம டைம் இல்லை, விட்டுடுங்க. இப்போது இதே இன்ட்ரடியூஸ் ஒன் ரேட், என்ன ரேட்டுன்னா ஃப்ளாட்டாக 3.75. ஃப்ளாட்டாக 3.75 இப்போ 3.75. ஓகே, அது கட்டிடலாமா? கட்டிடலாம். அங்கே ஒரு சின்ன ஒரு ஹிண்ட்ரன்ஸ், ஐடிசி கிடையாது. ஐடிசி கிடையாதுன்றவங்க இது இப்படியே சந்தோஷமாக வந்துட்டு போட்டோம். நான் ஏதாவது ஐடிசி எடுத்துன்னு எங்கே போட்டோம்னா அதெல்லாம் உங்களை யாரும் பர்மிட் பண்ணல. உங்களுக்கு ஐடிசி கிடையாது சார், இது என்ன சார் அநியாயமாக இருக்குது? எனக்கு வேணும்னா நான் ஐடிசி எடுத்துப்பேன், வேணும்னா இந்த ரூட்டில் வருவேன், அப்படிலாம் ஓப்பனில் இல்லை. இட்ஸ் ஏ சிம்பிளி தட் தேர் ஷல் பி அ ரேட் ஆஃப் திஸ் கைண்ட் அண்ட் இட் இஸ் தேர். சார் நான் ஒரு பண்ணுறேன் சார், நமக்கு வழக்கமாக அப்படி தான் பழக்கம். இந்தியன் மைண்ட் செட் எப்படி நீங்கன்னா, ஆடிட்டர் வராரு உங்ககிட்ட, சார் இதான் உங்களுக்கு டியூ டேட்டு அப்படின்றார். சார் டியூ டேட்டுக்குள்ளே ஃபைல் பண்ணலாம் என்ன சார் ஆகும்? சார் இது ஒன் வே, தயவுசெய்து வழியாக போகாதீங்க. சார் ஒன் வழியாக போனால் என்ன சார் ஆகும்? இப்போ இன்வேரியபிளி யூ ஷுட் நோ வாட் வில் ஹேப்பன் இஃப் யூ பிரீச் சர்டன் திங்ஸ். அது ஒரு ஸ்டாண்டர்ட் மைண்ட் செட் ஆகி போச்சு. சார் பண்ணாதீங்கன்னா பண்ணாதீங்க சார், விட்டுடுங்க சார், அது பண்ணால் என்ன சார் ஆகும் அப்படின்னு ஒரு கேள்வி. அதில் ஒரு த்ரில். அது எத்தனா ஒன்று ஏடாவிடமாக பண்ணணும், அதுக்கு ப்ரொஃபஷனல் மண்டே உடச்சிக்கணும். நோ ஃபைன். எனிவோ கம்மிங் பேக் டு திஸ் ஒன், இல்லை சார் நான் ஐடிசி எடுத்து இதை வயலேட் பண்ணி ஐ வில் ஜம்ப் டு த ரெசிடுவல் கிளாஸ் அண்ட் see that I am taxed at 18%. What do you say? அப்படின்னா ட்ரை பண்ணி பாருங்கள். அது 4500 வாட்ஸு கம்பியில் ஒயரை போயின்னு இருக்குது, கரண்ட் போயிட்டு இருக்குது சார், தொடாதீங்கன்றேன். நான் தொட்டு பார்த்து அப்படின்னீங்கன்னா பார்த்துட்டு உயிரோடு இருந்தீங்கன்னா திருப்பி பேசுங்க, அவ்வளோதான், வேறு என்ன சொல்லணும். சார் ரிஸ்கி ஒன். இல்லை சார் இதை ஃபைட் பண்ணலாம்னா பண்ணலாம். தேர் இஸ் டோட்டலி டிஃப்ரெண்ட் ஒன். இது ஈக்விட்டி கோர்ட்டெல்லாம் கிடையாது சார். டேக்ஸ் லாவில் ஈக்விட்டின்ற கான்செப்டே கிடையாது, தப்பாக நினச்சிக்காதீங்க. இதுக்கு அர்த்தம் என்ன நீங்கன்னா, டேக்ஸ் லாவை எப்படி எழுதுறாரோ அப்படி தான். இதில் நியாய தர்மம் இது அதெல்லாம் கொண்டு வரதுல ரொம்ப கஷ்டப்பட்டு ஆர்டிகல் 14 ஆஃப் கான்ஸ்டியூஷன் ஆஃப் இந்தியா யூ கேன் ட்ரை டு பிரிங் இன். ரொம்ப கஷ்டப்பட்டு 19(1)G ஆஃப் ஆர்டிகல் யூ கேன் ஜஸ்ட் ரோப் இன் வித் பவர் ஆஃப் 226 ஆஃப் ஆர்டிகல்ஸ். கொஞ்சம் கஷ்டப்படணும். சும்மா பிளெயினாக நான் இப்படின்னா அவர் அப்படின்னா ஏன் அப்படிலாம் கேட்க முடியாது. இங்கெல்லாம் ஈக்விட்டி கேட்கறதுலாம் ஒன்றும் கிடையாது. ஏன்னா கமிங் பேக் டு திஸ் ஒன், பிகாஸ் டேக்ஸ்லால் பல இடத்துல கான்ஷியஸ் டிஸ்பாரிட்டி இஸ் பெர்மிட்டட். நிறைய கேஸ்லஸ் இருக்குது. சுப்ரீம் கோர்ட் ஹஸ் ஆல்வேஸ் சப்போர்ட்டட் திஸ். சில காரணங்களுக்காக சப்ஜெக்ட் டு சர்டன் லிமிடேஷன்ஸ், கண்டிஷன்ஸ் அண்ட் சேஃப்கார்ட்ஸ் ஒன்லி, certain permissions, certain concessions can be given by the tax law maker. He has got his right. Perhaps ரொம்ப மோசமாக உங்கள் பிஸ்னஸை பாதிக்கிற மாதிரி you can go on that. Now coming to this one, சார் நீங்கள் 3.75 ஒரு ரேட் சொன்னீங்க. என் வாழ்க்கையில் இதுவரை நானும் இதே இண்டஸ்ட்ரியில் தான் அக்கௌண்டண்ட்டாக இருக்கேன், ஆண்டர்பனராக இருக்கேன், இல்லைனா மேபி நான் வேறு ஏதோ ஈவன் ஆடிட் பண்ணுறேன்னு கூட வச்சுக்கோங்க. 3.75 நம்பர் நான் பார்த்த மாதிரியே இல்லையா சார்? நீங்கள் எதாவது தப்பாக போட்டிருக்கீங்களா, இல்லை நான் எதாவது தப்பாக படிச்சிருக்கேனா சார்? அப்படி நான் சொல்கிறது ரைட்டு, நீங்கள் சொல்கிறதும் ரைட்டு. இது விசி சினிமாவே பரவாயில்ல போல இருக்கு. இல்லை விஷயம் என்னன்னா 3.75ன்றது லீகல் புக்கில் நீங்கள் பார்க்குற ரேட், அதுதான் உண்மை. அதில் நீங்கள் இந்த 1/3 எஃபெக்ட் ஒன்று கொஞ்ச நேரத்துக்கு முன்னாடி காமிச்சேன் இல்லையா, நோட்டிஃபிகேஷன் 11/2017 எக்ஸ்ப்ளனேஷன் ஒன்று பார்த்தேன் இல்லையா, அதில் கழிச்சிங்கன்னா என்ன ஆகும்? 1/3 போச்சுன்னா ஒரு 1.5% போகும். ஸோ 3.75 minus 1.25 will be 2.5 and 2.5 plus 2.5 CGST, SGST respectively will be 5%. Effectively 7.5% இருக்கிறது 5 சொல்ல முடியாது. யார் சார் கவர்மெண்ட்ன்றதுக்குன்னா முடிஞ்சால் நான் ஏதாவது உங்களுக்கு சப்போர்ட் பண்ணலாம், ஹெல்ப் பண்ணலாம். ஏற்கனவே ஒரு டைரக்ட் விங்காகவே இருக்கணும், அது கவர்மெண்ட்டுடைய ஒரு பார்ட்டாக இருக்கணும். பிரசிடென்ட்டுக்கு ரிப்போர்ட் பண்ணுறவங்களா இருக்கணும், அப்பாயிண்டட் பை பிரசிடென்ட், அப்பாயிண்டட் பை கவர்னர், ரிப்போர்ட்டிங் டு தெம். அப்படி இருந்தால் மட்டும்தான் அது வரும். அப்படி இல்லை அப்படிங்கன்னா இட் வில் நாட் கம் அண்டர். இட்ஸ் எ செப்பரேட் ஆர்கனைசேஷன். அது ஒரு டேக் ஃபார் எக்ஸாம்பிள் ஒரு தமிழ்நாடு சிமெண்ட்ஸ் அப்படின்னு ஒரு கம்பெனி இருக்காங்க, அது ஒரு கார்பரேஷன் கம்பெனி. இட் இஸ் ஒர்க்கிங் தேர் அண்ட் இட் வில் பி ஆடிட்டட் பை தி. இதுக்கு நீங்கள் வெறும் லேபர் சர்வீஸ் மட்டும்தான் பண்ணுறீங்க. ஒரு இண்டிவிஜுவல் ஹவுஸ், நான் ஒரு பில்டிங்குள்ளே இருக்கிற ஒரு பார்ட்டை நான் சொல்லலை, அதெல்லாம் நிற்காது. இட் ஒன்ட் ஸ்டாண்ட். அதுக்கெல்லாம் நிறைய ட்ரை பண்ணி பார்த்துட்டோம், அதெல்லாம் நிற்காது. அது போகிறதுக்கு முன்னாடி வில் ட்ரை டு அண்டர்ஸ்டாண்ட் தட் வாட் இஸ் த சேஞ்ச் ஹேப்பன்ட் இன் 2019. நான் கொஞ்ச நேரத்துக்கு முன்னாடி சொன்னேன், நம்ம சொல்லணும்னு இல்லை சார், அதில் நிறைய சேஞ்சஸ் வந்திருக்கு அப்படின்னு. 2019 ஏப்ரல்லேருந்து வந்த சேஞ்சஸ்ஸு நான் ஏன் இப்போ தெரிஞ்சுக்கணும்? ஃபஸ்ட்டு கேள்வி அதான். முடிஞ்சு போச்சு. இப்போ ஏதாவது நீங்கள் மார்ச் 2019 பேசியிருந்தால் கூட எனக்கு ஏதாவது ஒரு கிளாரிட்டி வேணுன்றதுக்காக கேட்பேன். என்னையோ மார்ச் 2019 நடந்து போச்சு, போனால் போச்சு, விடுங்க. இப்போ என்ன இப்போ அதை பற்றி பேசி என்ன ஆக போகிறது அப்படின்னீங்கன்னா, பிரச்சனையே எங்கே அப்படிங்கன்னா, இந்த மாதிரி லீகல் ப்ரொவிஷன்ஸில் 5 வருஷம் நார்மல் டைம் அப்படின்னு சொல்லுவாங்க. அதெல்லாம் சும்மா நார்மல் டைம்னு சொல்கிறதெல்லாம் சாதாரணம். எப்பெல்லாம் ஆனுவல் ரிட்டர்ன் எக்ஸ்டெண்ட் ஆகிட்டே போகிறதோ அப்போல்லாம் அந்த பீரியட் வில் பி கீப்பிங் ஆன் பி எக்ஸ்டெண்டிங். அவங்க எப்போ பார்த்தாலும் லிங்க் கொடுக்கறதெல்லாம் ஆனுவல் ரிட்டர்ன் டியூ டேட் தான் கொடுப்பாங்க. டியூ டேட் தான் கொடுப்பாங்க. அதை கூட எக்ஸ்டெண்டட் டியூ டேட் எக்ஸ்டெண்ட் போயிட்டே இருக்க வேண்டியது. அதுக்கப்புறம் கொஞ்சம் முன்ன பின்ன பிரச்சனை ஏதாவது வந்துச்சுன்னா, இப்போ ரீசென்ட்லி இன்னும் கொஞ்சம் அன்அஃபிஷியலாக எக்ஸ்டெண்ட் பண்ணி விட்டா மாதிரி ஏதாவது இன்னும் கொஞ்சம் எக்ஸ்டெண்ட் பண்ணி விடுவாங்க. ஸோ 2018 மார்ச்சில் நடந்த பிரச்சனையை பற்றி பேசுகிறதுக்கு ஆஃபீஸருக்கு டிசம்பர் 2023 வரைக்கும் நோட்டீஸ் கொடுத்து சப்ரேஷன் கேஸை பிடிக்கிறதுக்கு டைம் கொடுக்குறாங்க அப்படிங்கன்னா அது மாதிரி ஒரு வித்தியாக்டிவ் ஈவன் பை 2025 மே ஆர் ஜூன் ஆர் செப்டம்பர் பாசிட்டிவ்லி இந்த ட்ரெண்ட் போச்சுன்னா. ஸோ அப்போது உங்களுக்கு அந்த டைமில் நீங்கள் என்ன பண்ணியிருக்கீங்க அதை கரெக்டாக பண்ணியிருக்கீங்களான்றது தெரிஞ்சுக்கும். சார் நான் தெரிஞ்சுக்கிறதுனால இப்போ என்ன சார் யூஸ்னா ரொம்ப சிம்பிள். அதாவது என்னென்னங்கன்னா நீங்கள் ஏதோ ஒன்று செஞ்சதை ரைட்டாக செஞ்சதாக நினச்சிட்டு இருக்கீங்க, அது ரைட்டு இல்லாமல் போச்சுன்னா என்ன ப்ராப்ளம்ன்றது முதல்ல தெரிஞ்சுக்கோங்க. சரி, ஒரு பெரிய காடு, நல்ல ராத்திரி நேரம், ஒரு ஓவராக படித்த ஒருத்தரும் சுமாராக படித்த ஒருத்தரும் போகிறாங்க. இந்த ரொம்ப படித்தவர் ரொம்ப அனுபவசாலிகிட்ட இருக்கிற பெரிய நியூசன்ஸ் என்ன அப்படின்னா தேவையில்லாமல் அட்வைஸ் கொடுத்துருப்பார். இது ஒரு பெரிய பிரச்சனை, இது ஒரு வியாதி. இது ஆக்சுவலாக யார் ஒருத்தர் நம்மளை என்ன கேட்குறாரோ அதுதான் நம்ம அட்வைஸ் பண்ணணும். சும்மா போகிறவங்களெல்லாம் கூப்பிட்டு பேசிட்டு இருக்கக்கூடாது. இது ஆனால் சில பேருக்கு இது ஒரு பிரச்சனை. இவர் அந்த மாதிரி ஒரு ஆசாமி. இவர் ஊரில் இருக்கிற எல்லாத்தையும் படித்தவர், ஜுவாலஜி, பயாலஜி, கெமிஸ்ட்ரி, அட்டானமி எல்லாம், அட்டாமிக் சயின்ஸ் எல்லாம் படித்தவர். இந்த காட்டில் நடந்து போயிட்டு இருக்கும்போது ஒருத்தர்கிட்ட இவர் டீஸ் பண்ணுறதுக்காக என்னங்கிறாரு, ஏங்க நீங்கள் வந்து இந்த சிங்கம் புலி பற்றியெல்லாம் படிச்சிருக்கீங்களா அப்படின்னு கேட்டார். நான் ஏன் சார் அதெல்லாம் படிச்சிருக்கேன், அதெல்லாம் ஒன்றும் படித்ததில்லை சார். அப்படிங்களா? இந்த சிங்கம் இருக்குது பார்த்தீங்களா, ரொம்ப ஈகோயிஸ்டிக் அனிமல். அதனுடைய கண் இருக்குது பார்த்தீங்களா, ஒரு 30 டிகிரி ஸ்லாண்டட் ஐ விஷன். அது யாராவது பை சான்ஸு இந்த பிளைண்ட் ஏரியா பார்ட் இருக்குது பார்த்தீங்களா, அந்த இடத்துல 3 தடவை அந்த ப்ரே நின்றுடுத்துன்னா அது ஓங்கி ஓங்கி அடிக்க ட்ரை பண்ணும். ஆனால் எவ்வளோ தடவை ட்ரை பண்ணனாலும் 3ஆவது தடவை மிஸ் ஆகிடும். நீங்கள் என்ன தெரிஞ்சுக்கிறீங்கன்னாரு. இவன் நான் ஏன் ஏதோ ராத்திரி நேரம் காட்டில் தனியாக வந்துருக்கோம், ஏதோ ராமகிருஷ்ணன் நல்லது ஏதாவது சொல்லிக் கொடுங்க, நீங்கள் சும்மா சிங்கம் புலின்னு ஏதாவது பயமுறுத்துறீங்க. ஏங்க விவரம் தெரியாதா இருக்குங்க, இந்த காட்டில் நிறைய சிங்கம் வேறு நடமாடுதுங்க. இவர் சொல்லினே இருக்கும்போது பை த டைம் தே ஆர் ஹியரிங் த ரோயிங் சவுண்ட் ஆஃப் த லைன். இவர் நான் முதலே சொன்னேன் வானான்னு, இப்போ வேறு சிங்கம் சத்தம் வேறு கேட்குதுங்க. நீ பெர்பெண்டிகுலர் டைரக்ஷன் இந்த மாதிரி ஏதோ சொல்லிட்டு இருந்தார் இவர் படித்ததெல்லாம். கொஞ்சம் ரோரிங் சவுண்ட் கிட்ட வந்ததும் பாவம் படிக்காத ஒரு பயந்து போயிட்டார், கண்ணா பண்ணான்னு ஓட ஆரம்பிச்சிட்டார். இவர் படித்தவர் எவ்வளோ சொல்கிறார், ஓடாதான்னு. இவர் கொஞ்சம் பேனிக் ஆனதுனால ஏதோ கன்ஃபியூஷனால இவர் ஒரு பக்கம் அவர் ஒரு பக்கம் போய் இடிஞ்சு கண்ணா பண்ணான்னு ஓடினாங்க. அப்புறம் ரொம்ப வெறுத்து போய் சம்மேர் பை நெக்ஸ்ட் மார்னிங் இந்த ஃபாரஸ்ட்னுடைய பார்டரில் வந்து தேர் மீட்டிங். இவர் கொஞ்சம் கிழிஞ்ச சட்டையோடையும் அவர் கொஞ்சம் கிழியாத சட்டையோடையும் வர பயமுறுத்திருக்க. நான் சொன்னது உனக்கு புரிஞ்சுதா இல்லையா, அதாவது சிங்கத்தை பற்றி எவ்வளோ படிச்சிருக்கேன், நான் எவ்வளோ உனக்கு சொல்லிக் கொடுத்துருக்கேன் அப்படின்னாரு. படிக்காதவங்ககிட்ட ஒரு பெரிய இன்டெலிஜென்ட் ப்ராக்டிஸ் என்ன அப்படிங்கன்னா, கொஞ்சமாக தெரிஞ்சு வச்சுருப்பாங்க, நான் கரெக்டாக தெரிஞ்சு வச்சுருப்பாங்க. இது ஒரு நல்ல விஷயம் அவங்ககிட்ட. நான் அவங்களை அவ்வளோதான் புரியும் பாவம், ஆனால் கரெக்டாக புரிஞ்சுப்பாங்க. இந்த ஆள் என்ன சொன்னார், சார் நீங்கள் ரொம்ப படித்தவர், இந்த சிங்கம் என்ன பண்ணுன்றதை நீங்கள் நிறைய படிச்சிட்டிங்க. ஆமாம்மா, அதனால் உங்களுக்கு சிங்கம் என்ன பண்ணணும்னு தெரியும், அதுவும் பசி நேரத்தில். ரைட்டு, நீங்கள் வந்து எனக்கு சொல்லி கொடுத்தீங்க, அதனால் எனக்கு தெரியும். எடுக்கிற ஸ்டாண்ட் ரைட்டுனே வச்சுக்கோங்க. சிங்கம்னு ஒன்று இருக்குது, GST ஆஃபீஸர், அதுக்கு தெரியுமா? இதான் பிரச்சனை. ஸோ ப்ளீஸ் லேர்ன் வாட் ஹி ஹஸ் லேர்ன்ட். தட்ஸ் வெரி இம்பார்ட்டன்ட். தட் மேட்டர்ஸ் அ லாட். ஸோ தெர் இஸ் நோ பாயிண்ட் இன் சேயிங் தட் ஐ நோ திஸ், ஐ வாஸ் டோல்ட் பை ஹிம், ஹி ஆல்சோ நோஸ். தட்ஸ் ஃபைன். Whether the line knows, that matters. Now, coming to this one, 1/4/2019 என்ன நடந்திருக்கு, they are very closely watching. They are well trained. அவங்களுக்கு நிறைய டூல்ஸ் எல்லாம் கொடுக்குறாங்க, நிறைய ட்ரைனிங் எல்லாம் நடக்குது. இந்த ட்ரைனிங் பண்ணுறது வந்து ஒரு நல்ல புண்ணிய காரியம்னா எனக்கு நிறைய புண்ணியம். நீங்கள் எதிர் சைடில் உட்காந்துன்னு மகாபாவி அவன் இதெல்லாம் சொல்லி கொடுத்துட்றானா இவனுக்கு தெரியல அப்படின்னா அந்த மகாபாவியில் நானும் ஒருத்தன். ஃபைன், ஓகே, லீவ் இட். ஸோ கமிங் டு திஸ் ஒன், 1/4/2019 வந்த சேஞ்ச் தான் நம்ம முதல்ல பார்த்த மாதிரி என்னன்னா, ஃபஸ்ட்டு ITC காட் டெனைடு, க்ளோசிங் பேலன்ஸ் ஏதாவது இருந்ததுன்னா இட் காட் வைப்ட் அவுட். இல்லை ஆன்கோயிங் ப்ராஜெக்ட்னு வித்தின் த மீனிங் ஆஃப் தட் டைம் இஃப் யூ ஆர் ஏபிள் டு ப்ரூவ்னா அந்த ஷார்ட் டைமுக்கு அந்த ப்ராஜெக்ட் மட்டும் கண்டினியூ பண்ணி ITCயோடு சேர்த்து முடிச்சுக்கோங்கன்னு அலோவ் பண்ணாங்க. That's what the serious change. Rate also got changed. That you know very well that நான் சொன்ன மாதிரி இந்த 3.75 கதையெல்லாம் அப்போ தான் வந்தது. அதுக்கப்புறமா இந்த 1/3 provisions are always there, no doubt about it. And you know very well the Gujarat High Court case is also supporting you if you are interested to prove a different value of land value, and you can go ahead if you want. Now having said that one, இதுலேயே இன்னொரு கொஸ்டின் உங்களுக்கு என்ன வருதுன்னா, 1/4/2019 போது தான் வந்து இந்த அஃபோர்டபுள் ஹவுசிங் ஸ்கீம் வெரி ஃபேமஸ்லி கெட்டிங் இன்ட்ரடியூஸ்ட். இந்த ஸ்கீம் உங்களால் பண்ண முடியும் அப்படின்னு நம்பிக்கை இருந்ததுன்னா உங்களுக்கு சூட் ஆகும்னா பண்ணலாம். இந்த ரேட் இஸ் லிட்டில் அட்ராக்டிவ். அதுக்கும் ITC கிடையாது, இதுக்கும் ITC கிடையாது, ஃபைன். பட் அட்லீஸ்ட் ரேட்டாக கம்மியாக இருக்குது. ஒரு கொஞ்சம் அஃபோர்டபுள் ப்ரைஸுக்கு இருக்கிறதோட அஃபோர்டபுள் ப்ரைஸ்லேயே நீங்கள் வந்து இதையும் கொடுத்தீங்கன்னா மேபி த மார்க்கெட் ப்ரைஸ் வில் பி வெரி காம்படிட்டிவ், இட் அப்பியர்ஸ். ஸோ இதுதான் கண்டிஷன்ஸ் இஃப் யூ ஆர் ஏபிள் டு சி. ஸோ பார்த்தீங்கன்னா ஒரு கார்பெட் ஏரியா ஆஃப் அபவுட் சம் 60 ஸ்கொயர் மீட்டர்ஸ் வச்சுக்கோங்க. 60 ஸ்கொயர் மீட்டர்ஸ்னால் ரஃப்லி அபவுட் ஒரு 645 ஸ்கொயர் ஃபீட் வச்சுக்கோங்களேன், சம்திங் லைக் தட். அதே மாதிரி இன்கேஸ் ஆஃப் அதர் சிட்டிஸ் ஏதாவது இருந்ததுன்னா, சின்ன சிட்டிஸ் மெட்ரோபாலிட்டன் தவிர இருந்தது அப்படின்னா ஒரு 90 ஸ்கொயர் மீட்டர்ஸ் வச்சுக்கோங்க. இதுதான் வந்து சப்போஸ் டு பி த கார்பெட் ஏரியா, நாட் தி கம்ப்ளீட் ஷெல் ஏரியா, கார்பெட் ஏரியா ஐ எம் ஜஸ்ட் ரெஃபரிங் டு. அண்ட் தட்ஸ் வெரி இம்பார்ட்டன்ட், இந்த கண்டிஷன் கப்புள்டு. அண்ட் ஒரு 45 lakh rupeesக்கு தாண்டாத மாதிரி இஃப் யூ ஆர் ஹேவிங் தி let me say gross value, then the price of the property, then you will be able to see that it is falling under this. இப்போ கொஸ்டின் என்ன அப்படின்னீங்கன்னா, சார் இது ரொம்ப தியரிட்டிக்கலாக இருக்குது சார். இட்ஸ் ஓகே, நான் ஒரு ப்ராஜெக்டை கன்சீவ் பண்ணி இப்படியே நீங்கள் சொன்ன இந்த இன்ஸ்டேப்பை வச்சுன்னு பிடிச்சிட்டு அப்படியே கரெக்டாக பண்ணுறதுன்றது பண்ண முடிஞ்சால் நான் பண்ணுறேன், அது வேறு விஷயம். பட் எனக்கு என்ன தோன்றதுன்றதை நான் சொல்கிறேன். ஏன்னா நான் ஒரு ப்ராக்டிக்கல் பில்டர். ஒரு ப்ராஜெக்ட் நான் வந்து கன்சீவ் பண்ணுறேன், தயார் பண்ணுறேன், ரைட், ஓகே இருக்கட்டும். அதுலேயே ஒரு பார்ட் வந்து இந்த மாதிரி ஒரு அஃபோர்டபுள் ஹவுஸ் ஆகும், இன்னொரு பார்ட் வந்து நான் அஃபோர்டபுள் ஆகும். பண்ணால் எப்படி சார் இருக்கும்? ஒரு ஃபியூஷன் மாதிரி சூப்பராக இருக்கும்ல சார் அப்படின்னு ஒரு தாட் வருது. இது தாட் வந்தது. லா இஸ் நாட் ப்ரிவென்டிங். சொல்ல போனீங்கன்னா கேரளாவுடைய ஒரு ஏஆர் டிசிஷனு, கிரசன்ட் பில்டர்ஸ் வர்சஸ் தி டிபார்ட்மெண்ட் ஆக்சுவலி, அது இட் காட் டிசைடட் தட் யூ கேன் டூ போத். ஏன்னா லா இஸ் நாட் டிஸ்டர்பிங் யூ. இந்த இப்போ இவங்க சொல்லியிருக்கிற இந்த 0.75 + 0.75 ஒரு பக்கம் பண்ணிவிட்டு சப்ஜெக்ட் டு கம்ப்ளைண்ட்ஸ் ஆஃப் த ஏரியா அண்ட் ப்ரைஸ் ஆஃப் த ஃப்ளாட் அண்ட் திஸ் ஒன், அண்ட் அடிஷ்னலி நான் அஃபோர்டபுளாக ஒரு ஆர்ஆர்பியோ ஆர்இபியோ நீங்கள் பண்ணுறதுன்னா பண்ணலாம், யூமே பண்ண முடியும். பட் யூ ஹேவ் டு see that the conditions are sincerely followed by you. அது உங்களுக்கு டைம் இருந்ததுன்னா அந்த ஏஆர் டிசிஷன் படிக்கலாம். ஐ திங்க் இட் வாஸ் ரிலீஸ்ட் ஆன் 12th July 2000. ஓகே, ஒரே காம்ப்ளெக்ஸ்குள்ளே அஃபோர்டபுளும் நான் அஃபோர்டபுள் மேட்டர்ஸும் இருக்கலாம் அப்படின்னு சொல்கிறது. யூ கேன் ட்ரை இட், யூ கேன் ஒர்க் இட். சார் திடீர்னு ஒரு டவுட் சார், வழக்கமான டவுட்டு கேட்டால் வருத்தப்படாதீங்க, நீங்கள் தான் முன்னாடி வர சொல்லிட்டீங்க சார், ஏதாவது வயலேஷன் ஆகி போச்சுன்னா என்ன சார் பண்ணுறது? வயலேஷன் ஆச்சுங்கன்னா சார் சொன்னால் அந்த முட்டாள் ஆஃபீஸருக்கு புரிய மாட்டேங்குது, என்ன சார் பண்ணுறது? சார் நீங்கள் வேறு ஏதாவது பழைய லாவில் கூட கொஞ்சம் சான்ஸ் எடுத்திருப்பீங்க. மேபி ஒரு பழைய வேட் அண்ட் சர்வீஸ் டேக்ஸ்ன்ற போது கூட அது கூட தப்பு தான், இந்த கூட எடுத்திருப்பீங்க. இந்த லாவில் சான்ஸ் எடுக்கிறதுக்கு பாசிபிலிட்டி இல்லை சார். யூ ஹேவ் டு ரைஸ் அன் இன்வாய்ஸ் இந்த ரெலவெண்ட் டைம். முடிஞ்சால் ரைஸ் பண்ணி உங்கள்கிட்டே வச்சுக்கோங்க. எதுக்கு ரெண்டாவது காப்பி வேறு பிரிண்ட் பண்ணி கஸ்டமருக்கு கொடுத்து வேஸ்ட் பண்ணுறீங்க? பேப்பர் வேறு வேஸ்ட்டு. நீங்களே ஒரே ஒரு காப்பி பிரிண்ட் அடிச்சு நீங்கள்கிட்ட உங்கள்கிட்டே வச்சுக்கோங்க. ஏன்னா கஸ்டமர் எல்லாருமே B2C, நீங்கள் ஒன்றும் இன்வாய்ஸ் போட முடியாது அவர் மேலே. இதே போட பிரிண்ட் அடிச்சு வச்சுக்கோங்க. அதெல்லாம் முடியாது சார், பேப்பர் வேஸ்ட் ஆகுது சார். நான் சரி ஓகே, அட்லீஸ்ட் இன்வாய்ஸை போட்டு ரூல் 42 சப்ரூல் 2 கிளாஸ் Q இஸ் பர்மிட்டிங் யூ கிளியர்லி தட் போனால் போதியா டிஎஸ்சியாவது போட்டு வச்சுக்கோங்க, போட்டு பிடிஎஃபாவது போட்டு வச்சுக்கோங்க. பில்லு போட மாட்டேன்னு முடியாதீங்க, 1 to 2 பெனல்ட்டி போட்டு போடுவோம். ஸோ டோன்ட் டேக் ரிஸ்க். பில்லுன்னு ஒன்று தயவு செய்து போடணும். சரி சார், பில்லு போட வேண்டிய சுச்சுவேஷன் எங்கே சார் வருது? பெரும்பாலும் நாங்கள் அட்வான்ஸ் வாங்குகிறோம், அதில் வந்து மைல் ஸ்டோன் பேசிஸில் நாங்கள் பிஸ்னஸ் பண்ணிட்டுருக்கோம். அது பண்ணும்போது இதுதான் வருது, ஒரு பார்ட் வருது 10% 20% வரும்போது போடுறோம்னா அதான் இந்த 10% 20% வரும்போது கண்டினியூஸ் சப்ளை சர்வீஸில் ஒரு பார்ட் ஐடென்டிஃபைபிள் மைல் ஸ்டோன் தெரியறது இல்லையா? அதை வரச்சே ப்ளீஸ் ரைஸ் அ பில். அவ்வளோதான் விஷயம், வேறு ஒன்றும் ரெக்யர்மெண்ட் இல்லை. போட்டு நீங்களே வச்சு வச்சுக்கோங்க, தேர் இஸ் அ மேட்டர். சார் பில்லு போடுறதுக்கு கொஞ்சம் டைம் எடுத்துக்கலாமாண்ணா? சார் உங்கள் கொஞ்சம் என்னன்னு எனக்கு தெரியாது. இந்த புராணத்தில்னா உண்டு, தேவகணம்னு சொல்லுவாங்க. வந்து நமக்கெல்லாம் வந்து 1 நிமிஷம்னா நம்ம ஏதோ 60 செகண்டில் கவுண்ட் பண்ணுவோம். இவர் தேவர்களுக்கெல்லாம் ஒரு நிமிஷம், அது எவ்வளோ நிமிஷம்னா கிட்டத்தட்ட ஒரு 10 தசாப்தம் போனப்புறம் வரும், அது ஒரு நூற்றாண்டு போனப்புறம் வரும். அந்த டைம் எல்லாம் நமக்கு செட் ஆகுது. லா இஸ் வெரி கிளியர். உங்களுடைய டைம் ஆஃப் சப்ளை உங்களுக்கு அலோவ் பண்ணதில்லைன்னு ஒரு 30 நாள் டைம் உங்களுக்கு கொடுக்குறாங்க. சர்வீஸை முடிச்சிங்களா 30 நாளுக்குள்ளே, மைல் ஸ்டோன் முடிச்சிங்களா 30 நாளுக்குள்ளே ஒரு பில்லை போட்டு பத்திரமா எடுத்து வச்சுக்கோங்க. பணம் வந்தால் யூ ஆர் லயபிள், என்ஷூர் தட் இந்த மந்த் யூ ஆர் பேயிங் இட். பணமோ இன்வாய்ஸோ சர்வீஸோ விச் எவர் இஸ் எவர்லியர், தட்ஸ் வாட் இஸ் கவுண்டிங் ஆக்சுவலி. ஸோ see that it is going that way. Again சார், இப்போ க்ளோசிங் பேலன்ஸ் எல்லாம் நாங்கள் வச்சுருந்தோம் 31/3/2019. ஒரே குழப்பமாக இருக்குது. ஒருத்தர் வச்சுக்கோன்னார், ஒருத்தர் எடுத்துருன்னார், இன்னொருத்தர் வந்து எனக்கு ரொம்ப புத்திசாலித்தனமாக ஒரு ஐடியா கொடுத்தார். உன்னுடைய ஐடிசியை நீ இதையும் பண்ணாத, பத்திரமா வச்சுக்கோ. வச்சுன்னு என்ன சார் பண்ணுறது? எங்கள் ஆஃபீஸர் திட்டிகிட்டே இருக்காருன்னா வச்சுக்கோ, பிற்காலத்தில் அவன் எப்போயாவது ஆடிட்டுக்கு வருவான், அவன் வரும்போது ஏதாவது பாயிண்ட்டை பிடிப்பான், queryன்னு வரும். ஆடிட் பேரை ரைஸ் பண்ணும்போது இந்த ஐடிசி எடுத்து விடு, அவ்வளோதான். DRC 03 முடிஞ்சிடும், அவங்க மேலே முடிஞ்சிடும். சார் எலிஜிபிள் ஐடிசி இருந்தால் தானே சார் எடுத்து யூஸ் பண்ண முடியும். அதான் 31/3/2019 ஐஸ் கொடுத்ததுக்கு அதை வச்சு நீங்கள் என்ன பண்ணுறது? ஸோ அந்த மாதிரி ஏதாவது தப்பாக யாராவது புத்திசாலித்தனமான அட்வைஸ்ன்ற பேரில் சொன்னாங்கன்னா கேட்காதீங்க. சார் 31/3/2019 டிசிஷன்ஸ் இஸ் வெரி கிளியர். அந்த டைமில் ஒரு Annexure 4 வாஸ் கிவன் தேர். ஒரு வேளை ஆன்கோயிங் ப்ராஜெக்ட் ஏதாவது இருந்ததுன்னா நீங்கள் எலெக்ட் பண்ணி அதை எடுத்து எழுதிங்கன்னா யூ கேன் ஜஸ்ட் மேக் யூஸ் ஆஃப் இட், பண்ணலாம். அது இட் வாஸ் பர்மிட்டட். அது ஒரு எக்ஸப்ஷனல் மேட்டர். அப்படி இல்லைனா பை டிஃபால்ட் யூ ஆர் ஃபாலிங் அண்டர் த நியூ ரேட். புது ரேட்டில் 3.75 நோ ஐடிசி எல்லாம் கிளியராக சொல்லியாச்சு. there is no point in just trying to stick on to a stand knowing very well that it is not going to hold water. Then இது ஓகே சார், இது வந்து ஓரளவுக்கு கிளியராக இருக்குது. இதெல்லாம் நீங்கள் சொன்னதெல்லாம் வந்து நான் சர்வீஸ் பண்ணி சம்பாதிக்கிற இன்கம்க்கு டேக்ஸ் கட்டுற கதையெல்லாம் நீங்கள் சொல்லிட்டே வந்தீங்க. சார் இன்கம்க்கு நான் ஜிஎஸ்டி கட்டுறதை பற்றி கூட பெருசாக வருத்தப்படல சார், ஆனால் எக்ஸ்பென்ஸ் பண்ணாலாம் ஜிஎஸ்டி கட்டணும்னு சொல்கிறாங்க சார், அதான் சார் என்னால் தாங்க முடியல அப்படின்றது ஒரு ஸ்டாண்டர்ட் கொரி. என்ன இதில் நீங்கள் புரிஞ்சிக்க வேண்டியது இருக்குது அப்படின்னீங்கன்னா, ரிவர்ஸ் சார்ஜ் மெக்கானிசம் யாரை எந்த மாதிரி ஃபோக்கஸ் பண்ணணுன்றதுக்கு ரொம்ப எக்கனாமிக்கல், சைக்கலாஜிக்கல் அண்ட் அதர் ரீசன்ஸ் ஆல்சோ டேக்கன் இன்டு கன்சிடரேஷன் அண்ட் டன். ஏறக்குறைய இது ஓரளவு செட்டிலான ஒரு கான்செப்ட். இந்த ரிவர்ஸ் சார்ஜ் கான்செப்ட்ன்றது பார்த்தீங்கன்னா இட்ஸ் மோஸ்ட்லி செட்டில்டு. இதில் கொஞ்சம் மோசமாக அடி வாங்கினது யாருன்னா கன்ஸ்ட்ரக்ஷன் இண்டஸ்ட்ரி. ஐ அண்டர்ஸ்டாண்ட். ஏன்னா இது கிட்டத்தட்ட இந்த சர்க்குலர் நம்பர் 108 ஒன்று ரொம்ப வருஷத்துக்கு முன்னாடி 2009 ஒன்று கொடுத்தாங்க. அது கொடுத்தாங்கன்னு சொல்ல மாட்டேன், வாங்கினாங்க. இப்படி வேணா வச்சுக்கலாம். அதுக்கு மேலே இந்த டீசெண்டான ஃபோரத்தில் பேச முடியாது. வாங்கினாங்க. ஸோ அப்படி இருக்கும்போது அப்போலேருந்தே ஒரு பிரச்சனை என்னன்னா, கன்ஸ்ட்ரக்ஷன் இண்டஸ்ட்ரி ஹேட் ஆல்வேஸ் பீன் பிஹைண்ட் தி ஸ்க்ரீன். அவங்க தைரியமாக எந்த ரெப்ரசன்டேஷனும் வெளியில் வர மாட்டாங்க. நிறைய அசோசியேஷனாக வச்சுப்பாங்க, அசோசியேஷனாக நிறைய இருக்கும். பட் கரெக்டாக வந்து இதுதான் என் பிரச்சனை, நான் இப்படி தான் கரெக்டாக பிஸ்னஸ் பண்ணிட்டு இருக்கேன், why are you disturbing me அப்படின்னு வரவே மாட்டாங்க. ரெண்டாவது உங்களுக்குள்ள ஒரு பிரச்சனை என்னன்னா, ரொம்ப ஃபேமஸாக தப்பாக ஒரு ஐடியாவை யாராவது கான்செப்ட் ஆரம்பிச்சு விடுவார், எல்லாரும் ஒரே மாதிரி ஃபாலோ பண்ணுவாங்க. ஆஃபீஸர் ரொம்ப சந்தோஷப்படுவார். ஏன்னீங்கன்னா மற்ற இண்டஸ்ட்ரியிலாம் பார்த்தீங்கன்னா எவனாவது எக்ஸப்ஷனலாக தப்பு பண்ணுவான். நம்ம கன்ஸ்ட்ரக்ஷன் இண்டஸ்ட்ரிக்கு வந்து ரொம்ப பெருமை உண்டு. என்னன்னீங்கன்னா ஒரே மாதிரி எல்லாரும் தப்பு பண்ணுவாங்க. ஸோ ஒரு ஆஃபீஸர் போய் ஒரு கொரி போட்டான்னா ஒரு குறைஞ்சது ஒரு 100 ஷோகாஸ் நோட்டீஸ் அதே மாதிரி காப்பி அடிச்சிடலாம். இது ஒரு அன்ஃபார்ச்சுனேட் மேட்டர். இது ஒரு சம்டைம் பேக் இந்த ஒரு அட்வர்டைஸ்மெண்ட் ஏதோ ஒன்று வந்தது. சார் நீங்கள் இதை பண்ணீங்கன்னா குமார் சொன்னாருங்க, இன்னொருத்தர் குமார் சொன்னார். குமார் கடைசி வரலும் 10 கேரக்டர் குமார் சொன்னார்னு சொல்லுமே தவிர அந்த குமார்ன்ற கேரக்டர் கண்ணுக்கே தெரியாது. இது ஒரு பெரிய வர மாதிரி ஒரு அட்வர்டைஸ்மெண்ட் வந்து அந்த மாதிரி யாராவது ஒருத்தர் தப்பாக ஒரு விஷயத்தை கிளப்பி விட்டுறாரு. அது இட் இஸ் பிளைண்ட்லி ஃபாலோட் பை த இண்டஸ்ட்ரி ஃபார் சம் ரீசன் நாட் நோன் டு மீ அட்லீஸ்ட். ஸோ இப்போ விஷயம் என்னன்னீங்கன்னா ரிவர்ஸ் சார்ஜை பொறுத்தவரையிலும் ஹவு இட் இஸ் கமிங் தர்னா அன்ரிஜிஸ்டர்ட் சப்ளையர்கிட்ட வாங்கலைன்னா உங்களுக்கு டேமேஜ் அப்படிங்கிறது முதல்ல ஆரம்பிக்கும் போது 17/2017 செக்ஷன் 9 வந்தபோது ஆரம்பித்த போது இருந்தது. ஒரு 94 RCM இருந்தது, செக்ஷன் 95 RCM இருந்தது அஃப்கோர்ஸ். இப்போயும் ஒரு பார்ட் வந்து 13/2017 நோட்டிஃபிகேஷனில் கண்டினியூ ஆகிட்டு இருக்கு, அது வேறு பிரச்சனை. ஆனால் ரிஜிஸ்ட்ரேஷன் பண்ணாத ஒரு சப்ளையர்கிட்ட வாங்கினா பனிஷ்மெண்ட் வாங்குற ஒரே இண்டஸ்ட்ரி, பெருமைக்குரிய இண்டஸ்ட்ரி நம்ம கன்ஸ்ட்ரக்ஷன் இண்டஸ்ட்ரி தான். எப்படினீங்கன்னா இது பாருங்கள், எது டபுள் ஜோப்பாடி. சரி, ஒரு பக்கம் போய் தெரியாதனமாக போய் என்ன பண்ணிட்டாங்க இவங்க, ஹோட்டல் இண்டஸ்ட்ரியில் இருக்கிறவங்கலாம் போயிட்டு நாங்கள்லாம் வந்து 5 ஸ்டார் ஹோட்டல் கிடையாது, பிராண்டட் கூட்ஸு இன்புட் ஆஃப் மெட்டீரியலாக வாங்கணும்னு இல்லை, அப்படியே வாங்கினாலும் நாங்கள் வாங்குறது தயிர், பால், கீரை, பழம், காய், நெல், எண்ணெய், இது வாட் எவர் இட் இஸ். இதுக்கு ஒன்றும் பெரிய பிராண்டட் ஐட்டமாக இருந்து ஜிஎஸ்டிக்கு இன்புட்லாம் கிடையாது. எங்களுக்கு வேண்டாம் சார், எங்களை விட்டுருங்க, ஐடிசி வேண்டாம், 5% கட்டிட்டு போயிடுறோம். இவங்க போய் ஒரு ரெப்ரசன்டேஷன் பண்ணாங்க. த லேர்னட் மேன் வாஸ் ஃபினான்ஸ் மினிஸ்டர் ஜஸ்ட் கன்வின்ஸ் தெம், சார் சொல்கிறத கேளுங்க, தட் இண்டஸ்ட்ரி இஸ் டிஃப்ரெண்ட். அவரே சொன்னார், தட் இண்டஸ்ட்ரி இஸ் டிஃப்ரெண்ட், டோன்ட் காப்பி தெம். ஹோட்டல் இண்டஸ்ட்ரியில் தேர் ஆர் 2 layers. ஒரு சின்ன ஹோட்டல் இண்டஸ்ட்ரி இருக்குது, ஒரு பெரிய ஹோட்டல் இண்டஸ்ட்ரி இருக்குது. ஸோ ஹி வாஸ் அ வெரி லேர்னட் லாயர். ஹி டோல்ட், இது நல்லதில்லை உங்களுக்கு, யோசிச்சு பார்த்துட்டு 2 நாள் கழிச்சு உங்கள் ரெப்ரசன்டேஷனை கொடுங்கன்னு. 2 நாள் கழிச்சு அதே ரெப்ரசன்டேஷனை போய் கொடுத்தாங்க. சரின்னு வாங்கிட்டார். அவர் என்ன பண்ணுவார் பாவம், கூப்பிட்டு ஆஃபீஸரை போய் கேட்டோம்னா, சார் வெரி குட் ஒன் சார், அப்ராக்சிமேட்லி நம்ம கணக்கு பிரகாரம் பார்த்தீங்கன்னா ஒரு 650 crore rupeesலேருந்து 1200 crore rupees வரலாம் ரெவன்யூ வில் இன்க்ரீஸ். ஆக்சுவலி they are going to lose lot of ITC actually. ஒன்றும் பிரச்சனை இல்லை சார், we can do it. ஃபைன், இம்ப்ளிமெண்டட். என்ன விஷயம் என்னங்கன்னா, இதான் புளியை பார்த்து பூனை சோடு போட்டுக்கிறது சார். அவர் ஏதோ ஹோட்டல் இண்டஸ்ட்ரியில் ஏதோ பண்ணிட்டு போகிறாங்க சார், அவங்களுக்கு வேறு. நீங்கள் பிராண்டட் கூட்ஸை வாங்காமல் இருக்கும் சார். அயனு, ஸ்டீலு, சிமெண்ட்டு, ப்ளூ மெட்டல், இதெல்லாம் போய் நீங்கள் எவ்வளோ வந்து அன்ரிஜிஸ்டர்ட் பர்சன்கிட்ட வாங்கிட முடியும் இந்த உலகத்தில், இந்த இந்தியாவில்? 20 லட்ச ரூபாய்க்கு மேலே போனால் ரிஜிஸ்டர் தான் பண்ணணும். எத்தனை பேர் ரிஜிஸ்டர் பண்ணாமல் இந்த தொழில் நடத்திட முடியும்? எவ்வளோ திருத்தரமாக பண்ணிட முடியும்? எவ்வளோ இவே பில் இல்லாமல் கூட்ஸ் மூவ் ஆகிடும்? எவ்வளோ வந்து ரிஜிஸ்டர் பண்ணாத ஸ்டாக்கிஸ்ட் வந்து ஸ்டாக் வச்சுக்க முடியும்? ஸோ தே ஷுட் பி ரிஜிஸ்டர்ட். இட்ஸ் நேச்சுரல் இந்த ஜிஎஸ்டி என்விரான்மெண்ட். அவர் ரிஜிஸ்டர்டாக இருந்தார்னா அவர் ஜிஎஸ்டி போட தான் செய்வார். அவர் ஜிஎஸ்டி போட்டு நீங்கள் வாங்கினீங்கன்னா அதுக்கு உங்களுக்கு ஐடிசி கிடைக்கிற மாதிரி இருந்தால் தானே உங்களுக்கு நல்லது. பட் அதை யாரும் யோசிக்கல. இப்போ என்ன எடுத்து அப்படின்னீங்கன்னா, நான் அன்ரிஜிஸ்டர்ட் பர்சன்கிட்ட வாங்கலான்னு முயற்சி பண்ணால் கூட ஒரு பக்கம் ஐடிசி இஸ் ரெஸ்ட்ரிக்டட். நீ ரிஜிஸ்டர்ட் ஆள்கிட்ட வாங்கினாலும் ஐடிசி யூஸ் பண்ணுறதுக்கு ஒரு பக்கம் ஐடிசி ரெஸ்ட்ரிக்டட். ஆஸ் ஐ டோல்ட் யூ 5% ஆன் தி எஃபெக்டிவ் பேசிஸ். இன்னொரு பக்கம் என்னன்னா, ரிஜிஸ்டர்ட் ஆள்கிட்ட தான் வாங்கணும்னு ஒரு கண்டிஷன். 80% ஆஃப் யுவர் பர்ச்சேசஸ் இன் எ ஸ்பெசிஃபைடு மேனர் சப்போஸ் டு பி ஒன்லி ஃப்ரம் த ரிஜிஸ்டர்டு சோர்ஸ். Beneath it, if you are buying, then you will be liable to pay the RCM. அது depending upon the goods which are causing shortage may even be 28%. சிமெண்ட் தான் அந்த ஷார்ட்டேஜை கிரியேட் பண்ணுது அப்படிங்கன்னா ஒன்றமா அந்த ஐட்டம்னா அது 28% will be causing. அயனு, ஸ்டீலு, கிளாஸு, ப்ளூ மெட்டல், all these things. Perhaps some items like sand and blue sand may be in 5% is different one. பெரும்பாலான ஐட்டம் வந்து இஸ் கிரியேட்டிங் அ டேமேஜ் டு யூ. உங்கள் பிஸ்னஸில் நீங்கள் அக்கௌண்டண்ட்டாக இருந்தால் நீங்களோ இல்லை உங்களுக்கு அக்கௌண்டன்ட் ஒர்க் பண்ணுறா இருந்தீங்கன்னா ப்ளீஸ் டெல் தம் தட் ரெஜிஸ்டர்டு பர்சன் கிட்ட வாங்குறதுன்றது வேறு யாருக்கும் கவலை இல்லைப்பா, நமக்கு தான் பெரிய பிரச்சனை. ஹேவ் ஏ ட்ராக் ஆஃப் திஸ். வருஷத்துக்கு ஒரு தடவை பார்த்து கடைசியில் நேரத்தில் ஐயோ போயிடுது இது 80% வரலேன்னு வருத்தப்படுறதுல யூஸ் இல்லை. ட்ரை டு சி தட் வாட் வி ஆர் பையிங் அண்ட் வாட் வி ஆர் டூயிங். எக்ஸப்ஷனலி சில ஐட்டம் பண்ணுறாங்க, அதெல்லாம் வந்து எக்ஸ்க்ளூடட் ஐட்டம். என்ன சார் டிப்ரிசியேஷன் ஓடலான்றாங்க, சேலரி ஓடலான்றாங்க, பெட்ரோல் ஓடலான்றாங்க. என்ன சார் பெரிய விஷயம்? இதெல்லாம் போக P&L sizable amounts are relating to your inward purchases. They are all supposed to be from the registered parties at least up to the 80%. At least. If it is not there, then you will be in trouble. Now, as I already told you, commercial complex நான் கட்டுறேன் சார் அப்படின்னா நான் ஏற்கனவே சொல்லிட்டேன். உங்களுக்கு ஒன்றும் இல்லை சார், 18% சார், அவ்வளோதான் சார். உங்களுடைய கன்ஸ்ட்ரக்ஷன் பில் எடுங்க, 18% போடுங்க, உங்களுடைய ஐடிசியை சந்தோஷமாக என்ஜாய் பண்ணுங்கள், யூ டோன்ட் ஹேவ் எனி ப்ராப்ளம் அட் ஆல். தட்ஸ் ஆல் த திங். வேறு ஏதாவது ஸ்கீம் ஒன்றும் கிடையாது சார். நீங்கள் பிஸ்னஸ் பண்ணுறீங்க, 18% சார்ஜ் பண்ணுறீங்க, ஐடிசி எடுக்கிறீங்க, எல்லாரும் மாதிரி நிம்மதியாக இருக்கீங்க, அவ்வளோதான் விஷயம். தேர் ஆன்சர் மேட்டர். சார் இது ஓகே, என்னுடைய கஸ்டமர் கேட்குறாரு, அநியாயமாக இப்படி 18% எனக்கு சார்ஜ் பண்ணுறீங்களே, ஒரு 18 பைசா கூட எனக்கு ஐடிசி கிடையாதா அப்படின்னு கேட்குறாங்க. அது அவருடைய தலையெழுத்து, நம்ம ஒன்றும் பண்ண முடியாது. எந்த கன்ஸ்ட்ரக்ஷன் ஒர்க்கும் யாருக்குமே will not give any ITC at all. It is 17.5 prevented item. அது எந்த விதத்திலும் உங்களுக்கு உதவாது. ஒரு பில்டருக்கு இன்னொரு ஒர்க் கான்ட்ராக்ட் கீழே ஒர்க் பண்ணாருனாலே, ப்ளீஸ் நோட் த வேர்ட், if a builder is there, main builder, developer, let me say, he is there under 3.5 3.75 residential complex building work. அவருக்கு கீழே ஒருத்தர் இருக்காருனால, ஒருத்தர் இல்லை பல பேர் இருக்காங்க சப் கான்ட்ராக்டர்ஸ், சென்டரிங், கேஜிங், ஒயிட் வாஷிங், வாட்டர் ப்ரூஃபிங், இது அது எவ்வளோ வேலை இருக்குது, டைலிங், plumbing, electrical work, so many things are done there. Back to back subcontract is also given there. என்ன யாருக்கு எந்த ஒர்க்கு கொடுத்தாலும், the simple story what we need to note is one thing, the main ஆளால் கிரெடிட் எடுக்க முடியாது, ITC is prevented. ஒரு கஸ்டமருக்கு பண்ணி கொடுக்குறீங்க, கஸ்டமரால் கிரெடிட் எடுக்க முடியாது. சார் கஸ்டமருக்கு நான் ஃபேக்ட்ரி கட்டி கொடுக்குறேன் சார், ஃபேக்ட்ரி இல்லாமல் எப்படி சார் அவர் வந்து மேனுஃபேக்சர் பண்ணி GST கட்டுவார், அதுக்கெல்லாம் கொடுக்க முடியாதுன்னா சார் அது இம்மூவபிள் ப்ராப்பர்ட்டியாக டெவலப் ஆகுது. 17.5Dயில் இது ப்ரிவெண்ட் ஆகிருக்கு. 2 ரீசன் தான் சீரியஸான ரீசன். ப்ரிவெண்ட் ஆன கிரெடிட் அவருக்கு வரவே வராது, என்ன பண்ணாலும் வராது. அது கேள்வி கேட்கறதுல எந்த யூஸும் இல்லை, அது வேறு பிரச்சனை. அது ஒரு கோர்ட்டில் போய் கேட்க வேண்டிய விஷயம், நம்ம 2 பேரும் பேசுகிற விஷயம் இல்லை. ஸோ இட் வில் நாட் பி அவைலபிள். இல்லை சார், சம்மர் ஐ ரெட் 2018 ஒரிசா டிசிஷன் ஏதோ பாம்ப்ளப்ஸ்னு ஒரு கேஸில் பார்த்தேன் நான், கல்யாண மண்டபம் கட்டுறதுக்கு வந்து ஐடிசி வந்து அவைலபிள்னு சொல்லிட்டாரு அப்படின்னு ஒரு டிசிஷன் வந்திருக்கு. அப்படின்னா ஹைலி டிபேட்டபிள் டிசிஷன், ஸ்டில் பிஃபோர் த சுப்ரீம் கோர்ட். வி டோன்ட் வாண்ட் டு கிவ் தட் சஜஷன் டு யூ. ஏன்னா கன்சல்டேஷன் ஸ்டேஜில் என்ன சொல்லணும் அப்படின்னீங்கன்னா, ஹைலி ஹார்ம்லெஸ் எது அப்படின்றத சொல்லிவிட்டு, உங்களுக்கு தேவைப்பட்டதுன்னா இன்னொரு ஒரு ரிஸ்க் இருக்குது, இது எடுத்துக்கோங்க. கைட் பண்ண வேண்டியதை, சப்போர்ட் பண்ண வேண்டியது எதுக்குன்னா ஹார்ம்லெஸ், சேஃப். ஒரு பிஸ்னஸ் மேனுக்கு வேலை வந்து பிஸ்னஸ் பண்ணுறதை தவிர லிட்டிகேட் பண்ணுறது கிடையாது. நீங்கள் பண்ண வேண்டிய வேலை என்ன அப்படிங்கன்னா, எது சேஃப், கையை விட்டு நம்ம கொடுக்காமல் இருக்கிறது எப்படி, முடிஞ்சால் கஸ்டமர்கிட்ட வாங்கி கொடுக்கணும்னா கரெக்ட் டைமுக்கு எப்படி கொடுக்குறது, கம்ப்ளைண்ட் பண்ணுறதுனா எவ்வளோ நேரத்துக்கு சீக்கிரமாக கம்ப்ளைண்ட் பண்ணிடுறது, இதுதான் புத்திசாலித்தனம். இதுக்கு மேலே நான் ரிஸ்க் எடுக்க பேர் வழி அப்படின்னு சொல்லிட்டு சண்டை போடணும் அப்படின்னீங்கன்னா, அதுக்கு தனியாக ஒரு பட்ஜெட் எடுத்து வச்சுட்டு சண்டை போடலாம். தட்ஸ் ஓகே. Prudent businessman is not supposed to take up a matter of litigation as his lifetime process. அது தேவையே இல்லாத, புத்திசாலித்தனம் இல்லாத ஒரு விஷயம். Prudent businessman will not do that. Then coming to this one, land developmentன்றது ஒரு பெரிய கான்செப்ட் சார், அது எங்கள் பிஸ்னஸ்லேயும் நிறைய ஓடின்னு இருக்கு. இதுக்கு என்ன சார் டாக்ஸேஷன் வரும், லேண்டுக்கு என்ன வரும், அது ஒரு பெரிய கொரியாவும் பிரச்சனையாகவும் அடிக்கடி சண்டை போட்டுக்கிறாங்க, தொந்தரவு வருது. ஆஃபீஸர் வந்து இதுக்கெல்லாம் டாக்ஸ் கட்டுங்கிறாரு, நான் வந்து கஸ்டமர்கிட்ட டேக்ஸ் கேட்க முடியல, வாட் இஸ் த ஸ்டோரி அப்படின்றது இஷ்யூ. லெட் அஸ் அண்டர்ஸ்டாண்ட் திஸ் வே. திஸ் இஸ் அ வாட்டர் பாட்டில், ரைட்? இந்த வாட்டர் பாட்டிலில் லேபிளும் இல்லை, ஓகே, தெர் இஸ் நோ கைண்ட் ஆஃப் திஸ் கைண்ட் ஆஃப் டிசைன்ஸ் அண்ட் ஆல். ஒரு மாதிரி ஒரு முழுன்னு இருக்கிற ஒரு வாட்டர் பாட்டில், ஓகே. பிராண்ட் இல்லை, அஃப்கோர்ஸ் பிராண்டை பற்றி நம்ம பெருசாக பேசல, பிராண்ட் இல்லை. நான் இது என்ன அப்படின்னு இந்த கவர் இல்லாமல் கேட்டிருக்கேன் அப்படின்னு வச்சுக்கோங்களேன், வாட் யூ வில் சே? இந்த கவர் இல்லை சார் இதில், ஐ எம் ஜஸ்ட் ஆஸ்கிங் யூ சார், இப்போ இதுக்குள்ளே இந்த பொருளுக்கு என்ன சார் பேர், காமன் பர்லான்ஸில் என்ன பேர் அப்படின்னு நான் கேட்குறேன். வாட்டர் பாட்டில். ஸோ நான் கேட்கும்போது உங்களுக்கு எந்த விதமான கன்சர்னும் இல்லாமல் எப்படி சொல்கிறீங்கன்னா, வாட்டர் இருக்கிற பாட்டில் வாட்டர் பாட்டில். சரி, இதெல்லாம் நான் போட்டுட்டு இதெல்லாம் கவரெல்லாம் பண்ணிவிட்டு இதை எடுத்து சார் இது என்ன அப்படின்னு கேட்குறேன். ஒரு சின்ன ப்ரிஃபிக்ஸ் கேஷியஸை சேர்த்துட்டு பிராண்டட் வாட்டர் பாட்டில்னு சொல்லுவீங்க. இட்ஸ் ஓகே, இட் ஜஸ்ட் தட் பார்ட் இஸ் நெக்லிஜிபிள், ஸ்டில் இட்ஸ் அ வாட்டர் பாட்டில், அவ்வளோதான் விஷயம். லேண்டை பொறுத்தவரையிலும் இட்ஸ் அ லேண்ட், ஆஃப்டர் ஆல் இட் இஸ் அ லேண்ட். நீங்கள் டெவலப்மெண்ட் ஒர்க் ஏதாவது பண்ணியிருக்கலாம், லெவலிங் பண்ணியிருக்கலாம், கொஞ்சம் கொஞ்சமாக ஏதாவது வேறு ஏதாவது ஷேப்பிங் பண்ணியிருக்கலாம், பெராப்ஸ் சிம்பிள் ஃபென்சிங் பண்ணியிருக்கலாம் ஃபார் தி சேக் ஆஃப் என்ஷூரிங் தட் த ஷேப் இஸ் நாட் மிஸ்டு, கொஞ்சம் கிராஸிங்கை லிமிட் பண்ணியிருக்கலாம். ஸோ மெனி திங்ஸ் குட் ஹவ் டன். ஆனால் இது எதுவுமே அதனுடைய பேசிக் கேரக்டரிஸ்டிக்ஸை மாற்றலை. பொயட்டிக்கலாக சொல்லணும்னா, ஏ ரோஸ் இஸ் அ ரோஸ் இஸ் அ ரோஸ் ஒன்லி. யார் என்ன சொல்ல முடியாது? A land is a land only, subject to minor developments. இதில் ஹை சிவில் ஒர்க்ஸ் ஏதாவது பண்ணிடுறீங்கன்னு வச்சுக்கோங்க, பிரமாதமாக ஏதாவது ஒன்று பண்ணி வச்சுருங்கன்னா, தென் ஸ்லோலி இட் இஸ் கெட்டிங் தட் கலர் ஆஃப் டிஃப்ரெண்ட் ஒன். இதுக்கு இந்த நோட்டிஃபிகேஷன் நம்பர் சர்க்குலர் நம்பர் 177 வாஸ் இஷ்யூட் இன் August 2022. அதில் இந்த பேரா நம்பர் 14.3 உத்து படிங்க, கவனமாக படிங்க. 14.4 அதை விட ரொம்ப கவனமாக படிங்க. 14.3 நான் சொன்னதை கிளியராக சொல்லிடும், அதோடு விட்டுட்டு போயிடாதீங்க. தயவு செய்து 14.4 படித்து பாருங்கள், அதில் உங்களுக்கு அந்த வித்தியாசம் தெரியும். என்ன ஆகிடுறதுன்னா, அதில் 14.3 சே சிம்பிளி 12th இஷ்யூ, அதில் 14th பேராகிராஃபாக வரும். 12வது இஷ்யூ அந்த சர்க்குலரில் அது 14th ஐட்டமாக வரும். அது 14.2ல என்ன சொல்கிறது அந்த பேராகிராஃப் அப்படின்னா, இன் கேஸ் ஆஃப் திஸ் ஒன், ஒருவேளை டெவலப்டு லேண்டாக இருக்குன்னா, ஆஃப்டர் ஆல் இட் இஸ் அ லேண்டு ஷெட்யூல் 3 கவர் பண்ணுறது என்ட்ரி நம்பர் 5ல் இருக்குது. இட் இஸ் நாட் அட் ஆல் taxable item. Land is an immovable item. அவ்வளோதான் முடிஞ்சிட்டு. டு தட் எக்ஸ்டென்ட் இட்ஸ் கிளியர். 14.4ல கேர்ஃபுல்லாக அவர் என்ன சொல்கிறாருன்றது படிச்சு பாருங்கள். லா மேக்கரை ரொம்ப கேர்ஃபுல்லாக, however it may be noted, இதே வார்த்தை இருக்குது, however it may be noted, leveling or any kind of work relating to development of land is a service which is taxable. சார், இவங்களுக்கு ஆரம்பத்துலேருந்து இது ஒரு ரெகுலர் ப்ராக்டிஸாக இருக்குது நான் பார்க்குறேன் சார். நல்ல தெளிவாக ஒரு சென்டென்ஸ் சொல்கிறீங்க, அப்புறமா குறப்படாத மாதிரி வேறு ஒரு சென்டென்ஸ் சொல்லிடுறீங்க சார். இது ரொம்ப அநியாயம் சார். ரொம்ப தெளிவாக தான் இருக்குது ஆக்சுவலாக. 14.3ல என்ன சொன்னார்னீங்கன்னா, the per se product, namely developed land, if it is transferred, then it is after all not taxable in this law at all, because it is not the one to be covered by this law at all. But ஒரு லேண்டில் டெவலப்பிங்கிற வேலையை செஞ்சு தரேன் அப்படின்னு ஒருத்தர் சொல்லி அதுக்கு ஒரு கன்சிடரேஷன் ரெக்கார்ட் ஆகுதுன்னா, ஐடென்டிஃபைபிளி, தென் இட் வில் பி லைபிள். இப்போ நம்ம இப்படி வச்சுப்போம், நம்ம ப்ராக்டிக்கலாக வரும். சார், நான் வந்து ஒரு லேண்ட் டெவலப் பண்ணிட்டேன் சார், ஒரு 10-15 ஸ்கெட்ச் போட்டாச்சு சார், மொத்தமாக ஒரு 100 பிளாட் இருக்குது, அது PLOT. ஸோ அந்த பிளாட்டில் வந்து எல்லாத்துக்கும் தேவையான நீங்கள் சொன்ன அந்த லெவலிங் எல்லாம் முடிச்சுட்டேன். ஃபென்சிங் போட்டேன், சிம்பிள் லைட்டிங், ரொம்ப பிரமாதமான லைட்டிங் எல்லாம் போட்டிங்கன்னா ரிஸ்க், சிம்பிள் லைட்டிங்லாம் போட்டுட்டேன். இப்போ நான் விற்றா எங்களுக்கு ஏதாவது பிரச்சனை வருமா சார்? 177 பேரா நம்பர் 14.3, ரெஃபர் இட், சேஃப், யூ ஆர் நாட் இன் தி GST bracket at all. கிளியர் சார். இதே லேண்டு, இதே சேல்ஸ், எவ்ரி திங் இஸ் ஃபைன். இதுக்கப்புறமா அவர்கிட்ட என்ன சொன்னேன்னா, 3 வருஷம் உங்களுக்கு இந்த லேண்டை நீங்களே வீடு கட்டிக்கிறீங்களோ, இல்லை யாருக்காவது வீடு கட்டிக்கிறதுக்காக விற்கிறதுக்கு நீங்கள் வெயிட் பண்ணுறீங்களோ, வாட் எவர் இட் இஸ், நான் உங்களுக்கு டெவலப்மெண்ட் ஒர்க் பண்ணிட்டு இருக்கேன் அப்படின்னு சொல்கிறேன் சார். டெவலப்மெண்ட் ஒர்க்னா என்ன சார் பண்ணுங்க? ஒன்றும் இல்லை சார், கத்திரிக்கோள் எடுத்து போய் கற்கருக்குன்னு கட் பண்ணுவேன் சார், ஏதாவது லைட் இருந்ததுன்னா போடுவேன் சார், ஏதாவது சாக்கடை கேடு இருந்தால் வாரி விட்டுடுவேன் சார், இதான் பண்ணுவேன் சார், லெவல் பண்ணி வைப்பேன். அதை பண்ணால் அது சர்வீஸு, அதுக்கு கன்சிடரேஷன் இருந்தால் அதுக்கு டேக்ஸ் உண்டு. ஆர் லேண்டுக்கு இவ்வளோ ரூபா, டெவலப்மெண்ட் சார்ஜஸ்னு இவ்வளோ ரூபாய் தனியாக போட்டு நான் ரீச் பண்ண மாட்டீங்க. நீங்கள் அதை போட்டிங்கனாலே இட் வில் ஜஸ்ட் ட்ரை டு அட்ராக்ட் தி லைபிலிட்டி. நார்மல் ஆஃபீஸராக இருந்தாருன்னா வேறு, GST ஆஃபீஸர்னுடைய பழக்கம் வேறு, இன்கம் டேக்ஸ் ஆஃபீஸர்னா கூட கொஞ்சம் பரவாயில்ல, GST ஆஃபீஸர்னோட பழக்கம்னா வேறு. GST ஆஃபீஸருக்கும் மற்ற டேக்ஸ் ஆஃபீஸருக்கும் ஒரு பெரிய வித்தியாசம் இருக்குது. அந்த வித்தியாசம் வந்து சிம்பிளாக சொல்லணுன்னா, நீங்கள் வீட்டில் உளுந்து வடை சாப்பிட்ருப்பீங்க, உளுந்து வடை பார்த்தீங்கன்னா இதான் வடைன்னு கொடுத்தீங்கன்னா, நான் உங்களுக்கு ஒரு நல்ல உளுந்து வடை கொடுத்தேன்னா நீங்கள் என்ன பண்ணுவீங்க? வாங்குவீங்க, சாப்பிடுவீங்க, நல்லா இருந்தால் நல்லா இருக்குன்னு சொல்லி தேங்க்ஸ் சொல்லுவீங்க. இது வந்து நீங்களும் நானும் ஹியூமன் பீயிங், நார்மல் ஹியூமன் பீயிங். இன்னொரு எலைட் குரூப் ஒன்று இருக்குது, அவங்க பேர் GST ஆஃபீஸர்னு பேர். நீ அவர்கிட்டயே போய் இந்த மாதிரி ஒரு உளுந்து வடையை கொடுத்தீங்கன்னா, சார் இந்த வடையில் உளுந்து மாவு இருக்குது, ஓகே, நடுவில் இந்த உளுந்து மாவு எங்கே காணாமல் போச்சு அப்படின்னு. இதுதான் சாதாரண மனிதனுக்கும் GST ஆஃபீஸருக்கும் இருக்கிற பெரிய வித்தியாசம். நீங்கள் எதை இல்லைன்றதை பார்க்கறதுக்கு மட்டுமே தான் அவன் வேலை செஞ்சிடும். இருக்குது எதை கொடுத்தீங்கனாலும் இருக்குன்னு பண்ணுங்க. சார் 400 கோடி டர்ன் ஓவர், அப்படிங்களா? 399.85 crore rupeesக்கு நாங்கள் டேக்ஸ் கட்டிட்டோம் சார். ஷா, என்ன சார் சேன்றீங்க? இந்த 0.15 crore rupees ஏன் மிஸ் ஆச்சு அப்படின்னு. அதான் ஆஃபீஸர் 399.85 crore rupees டேக்ஸ் கட்டிங்களா, சந்தோஷம்னு சொல்லவே மாட்டார். அந்த 0.15 எதுக்கு சார் விட்டீங்க, அது என்னாச்சு எடுங்க பார்க்கலாம் டீட்டெயிலில், அதான் ஒரு ஆஃபீஸர். ஸோ திஸ் இஸ் ஹவ் ஹி வில் பி ட்ரெயின்ட். ஸோ அப்படின்னு இருக்கும்போது இந்த என்டையர் ப்ராசஸில் வாட் வி ஆர் சப்போஸ் டு அண்டர்ஸ்டாண்ட்னா, நீங்கள் ஒரு பார்ட்டை டேக்ஸில் போய் அங்கே தேவையில்லாமல் போய் கோத்து விட்டீங்கன்னா, தட் இஸ் வாட் இஸ் அட்ராக்டிங் அன்னெசரி. நாம் சாதாரணமாக அதுக்கு மட்டும் டேக்ஸ் கட்டுறோம், அவர் என்ன பண்ணுவார், மிக்சர் சப்ளை போட்டு அதை விளையாடிட்டு இருப்பார். இதான் நடக்கும். இது சப்ளை, இது மிக்சர். சார் அது சப்ளையே கிடையாது சார், நீங்கள் முதல்ல நோட்டீஸ் வாங்கிக்கோங்க அப்புறம் பேசுகிறேன் அப்படின்னு. ஸோ ப்ளீஸ் டோன்ட் கிளப் திஸ் non-taxable item per se, which is very safe, with a highly debatable or not debatable also, highly taxable item it is actually. Don't bring that here. அப்படி வரீங்கன்னா தனியாக ஒரு அக்ரிமெண்ட் போட்டு தனியாக GST கட்டி போயிடுங்க. அது நான் சர்வீஸ் பண்ணி தான் சார் திரும்ப பிடிவாதமாக இருக்கீங்கன்னா சர்வீஸ் பண்ணுங்கள், அதுக்கு மட்டும் GST கட்டி போயிடுங்க. லேண்டாக வச்சுக்கோங்க, ரெக்கார்டாக லேண்டுக்காக வச்சுக்கோங்க, you will be very safe. Last but one item is the joint development. Joint development will be a very serious topic. As such, பார்த்தீங்கன்னா இந்த ஒரு டாபிக் மட்டுமே வந்து we have to discuss for a long time. What is the time available for me? Should be another or 11-12 minutes? Oh, fine, okay, thank you. I was estimating another 12 minutes will be available to you. 15 minutes, 3 minutes bonus. That is for your questions. Fine, okay. Now, you just imagine this is a land piece. Just imagine, இப்படி தான் ஒரு land piece வந்து rectangular land piece is there. Okay. ஸோ இந்த பீஸில் வந்து இந்த லேண்ட் ஓனர் என்ன பண்ணுறாருன்னா, இந்த நான் ஆரஞ்சுன்ற வார்த்தையை சொல்கிறேன், இது வேறு சாஃப்ரான்னு சொன்னால் நாட்டில் பெரிய பிரச்சனை வருது. நல்ல கலர் இது, ஃபைன், ஓகே. ஆரஞ்சு கலர் வந்து 1/4 வச்சுக்கோங்க. ஸோ மீதி இருக்கிறதெல்லாம் வந்து இட் இஸ் கோயிங் டு தி பர்சன் ஹூ இஸ் கோயிங் டு பில்ட் தட், டெவலப்பரே பார்த்துக்கிறார் அந்த ஏரியாவை. இன் அதர் வேர்ட்ஸ் 1/4 இஸ் ஸ்டில் தேர் இன் த ஹேண்ட்ஸ் ஆஃப் லேண்ட் ஓனர், ஈவன் த ப்ராடக்ட் இஸ் கண்டினியூ. ஒரு ரெக்டாங்குலர் லேண்ட் இருக்குங்க, இந்த லேண்டில் 1/4 போர்ஷனை லேண்ட் ஓனர் என்ன பண்ணுறாரு, நானே வச்சுக்கிறேங்க, எனக்கு கொடுக்க வேண்டிய ஃப்ளாட்ஸ் என்கிட்ட கொடுத்துருங்க, இந்த லேண்ட் என் கண்ட்ரோலில் இருக்கட்டும், மீதி இருக்கிற 3/4 லேண்டு நீங்கள் என்ன பண்ணிக்கோங்க, யார்கிட்ட விற்றுக்கோங்க, எதனா பண்ணிக்கோங்கன்ட்டார், பில்டிங் கட்டிக்கோங்க விற்றுக்கோங்கன்ட்டார். இதை எடுத்துகிட்டு போன இந்த பேசிஸில் என்ன பண்ணுறாரு, இவர் ப்ரொசீட் பண்ணுறாரு. இஸ் வாட் இஸ் த ப்ராடர் பிக்சர் ஆக்சுவலி. ஒரு 30 கோடி ரூபாய் இருக்கிற ஒரு லார்ஜ் லேண்ட் பீஸ்ன்னு வச்சுக்கோங்களேன், இதை ஆசச் பார்த்தீங்கன்னா நவ் இப்படி தான் வந்து பில்டிங் கட்ட போகிறாரு. கொஞ்ச நேரத்துக்கு முன்னாடி பார்த்தீங்க இல்லையா, இதில் ஸ்க்ரீனில் பார்த்தா உங்களுக்கு தெரியும், இந்த சாஃப்ரன் கலர் பார்த்தீங்கன்னா உங்களுக்கு தெரியும். So you'll be seeing this part which is relating to his land. இந்த ஆரஞ்சு கலரில் ஃப்ளாட் எல்லாம் வந்து லேண்ட் ஓனருக்கு போயிடுறது. இந்த ஸோ கால்டு கிரே கலர் இருக்குது இல்லைங்களா, இந்த கிரே கலர் ஃப்ளாட்ஸ் எல்லாம் இஸ் கோயிங் டு பி கண்ட்ரோல்டு பை தி பில்டர். அவர் வச்சு போகிறோம் விற்று போகிறோம் வாட் எவர் இட் இஸ் 75% இருக்குது. இதுதான் வந்து அவங்களுடைய ஐடியா. 100 ஃப்ளாட்ஸ் மொத்தமாக கட்டியிருக்காருன்னு வச்சுக்கோங்க. இந்த 100 ஃப்ளாட்ஸில் என்ன பிளான் அண்டர்ஸ்டாண்டிங் எப்படிங்கன்னா, ஓகே ஒரு about some 30 flats versus 70 flats, something like that will be shared in ஏதோ ஒரு அண்டர்ஸ்டாண்டிங்க்கு வராங்க. ஒரு நம்பருக்கு சொல்கிறேன், நாட் எக்ஸாக்ட்லி திஸ் நம்பர். ஸோ இப்போ ஹவு டு பிளான் திஸ், அவருடைய லைபிலிட்டி. சார் 70 ஃப்ளாட்ஸ் நான் தான் சார் டெவலப்பரு, 100 ஃப்ளாட்டில் 70 ஃப்ளாட்ஸ் என் கண்ட்ரோலில் இருக்குது, நான் விற்றுக்கிறேன், எனக்கு ஒன்றும் பிரச்சனையே இல்லை. வித் என்ன அதுக்கு GST வரும், ஏன்னா 3.75 - 1.5 ஏதோ சொன்னீங்க, ரைட், வாட் எவர் இட் இஸ், நான் கட்டு போயிடுறேன், வாட் எவர் இட் இஸ். இப்போ இந்த 30 ஃப்ளாட்ஸ் நான் கட்டுறேன் இல்லையா சார், இதுக்கு நான் யார்கிட்ட போய் சார் GST கேட்கணும்னா, சார் உங்கள் லேண்ட் ஓனர் தான் சார் கஸ்டமர், அவர்கிட்ட தான் போய் நீங்கள் GST கேட்கணும். சார் லேண்ட் ஓனர் சொல்கிறாரு, நான் உங்களுக்கு லேண்டு கொடுத்தேன், நீங்கள் எனக்கு பில்டிங் கொடுத்தீங்க, நான் ஒரு ரிமூவல் ப்ராப்பர்ட்டி கொடுத்தேன், நீங்கள் ஒரு ரிமூவல் ப்ராப்பர்ட்டி கொடுத்தீங்கன்னா இல்லையே. லேண்ட் ஓனர் உங்ககிட்ட லேண்ட் டெவலப்மெண்ட் ரைட்டு கொடுத்தாரு, எங்கேயாவது லேண்டை உங்கள் பேரில் அவுட் ரைட்டாக ட்ரான்ஸ்ஃபர் பண்ணி கொடுத்தாரா? நீங்கள் அவுட் ரைட் பையரா? ஒரு ஜாயின்ட் டெவலப்மெண்ட் அக்ரிமெண்ட்டில் எங்கே சார் நீங்கள் வந்து அவுட் ரைட் பையரா? நீங்கள் யூ நெவர். ட்ரான்ஸ்ஃபர் ஆஃப் ப்ராப்பர்ட்டி ஆக்டில் ஃபார் த பர்பஸ் ஆஃப் பிலீவிங் தட் யூ ஆர் எ ரைட்ஃபுல் பொசஸிங் பார்ட்டி, இட் மேக்ஸ் எ சென்ஸ், எஸ். Otherwise, you are not a registration act 1908 நீங்கள் ஒன்றும் ஓனர் ஆகலையே. You are not the owner of the land. You have the right to do development as it is permitted by the owner. திருப்பி அந்த வார்த்தையை சொல்ல பாருங்க, ஓனர். இப்போ கடைசி வரலாம் ஓனர்ன்ற வார்த்தைக்கே அவர் தான் உரிமையாக இருக்கார். டைட்டில் ஹோல்டர்னுடைய எல்லா ரைட்ஸும் உங்ககிட்ட கொடுக்குறாரு, நீங்கள் அதை பண்ணிட்டு இருக்கீங்க, அவ்வளோதான் நடந்திருக்கு. ஸோ யூ கேன் பி கன்வின்ஸ் தட் யூ ஆர் நாட் த ஓனர் ஆஃப் த லேண்ட் இன் திஸ் கிவன் கேஸ். Perhaps some kind of an understanding permitted by law is there, it is going fine, let it be, இருக்கட்டும். இப்போது சரி சார், நீங்கள் சொன்ன மாதிரி அந்த 30% 30 ஃப்ளாட்டுக்கான ப்ரைஸ் கூட நான் போய் ஏதோ ஒன்று ஃபிக்ஸ் பண்ணிவிட்டு நான் வந்து டேக்ஸ் கேட்கணும்னு ஆசைப்பட்றேன். என்ன ப்ரைஸ் நான் கேட்குறது? லேண்ட் ஓனர்கிட்ட நான் 10 பைசா வாங்கலை சார், அப்படிங்களா சார்? நான் கேட்டாலும் கொடுக்க மாட்டார் சார் அவர். சரி ஓகே, இதை விட வைத்தீச்சல் சார், நான் தான் சார் ஃப்ரீ மணி கொடுக்குறேன் அவருக்கு. ஓ அது வேறு இருக்கா? அதை விட வைத்தீச்சல் சார் 1.5 வருஷம் டிஸ்லொகேஷனுக்காக நான் தான் சார் ரெண்ட் கொடுக்குறேன். ஓ இது வேறு இதில் இருக்கா? அவ்வளோ இதுக்கு மேலே கூட இருக்குது சார், அதெல்லாம் சொல்ல முடியாது சார். சரி ஓகே ரைட், நோ வாட் யூ நீட் டு டூ? சார் நான் தான் சார் பணம் கொடுக்குறேன், அவர் எங்கே சார் கொடுத்தாரு? கொடுக்காத பணத்துக்கு நான் எங்கே சார் போய் டேக்ஸ் போடுறது? என்ன சார் இதுக்கு வேல்யூ இருக்குது? சிம்பிள் சார். தேர்ட் பார்ட்டி பையர்லாம் இந்த கிரே கலர் பில்டிங் இருக்குது பார்த்தீங்களா, இந்த கிரே கலர் ஃப்ளாட் வாங்கினா வந்தாங்க இல்லையா பையர்ஸ் எல்லாம், அந்த வந்த பையர்லாம் என்ன பண்ணான், செக்லேயோ எதையோ வந்து உங்களுக்கு பேமெண்ட்டை கொடுத்தோம். தட் இஸ் த ஃபார்ம் ஆஃப் கன்சிடரேஷன். அதே இந்த ஆரஞ்சு கலர் வீடு லேண்ட் ஓனர் இருக்கார் இல்லையா, அவர் என்ன கொடுத்தாரு? கொஞ்ச நேரத்துக்கு முன்னாடி போன ஸ்க்ரீனில் காமிச்சேன் இல்லையா, இந்த லேண்ட் போர்ஷன், the grey color land portion, இந்த டெவலப்மெண்ட் ரைட்ஸ் உங்ககிட்ட கொடுத்துருக்காரு. ஸோ இன் கைண்ட் இட் ஹஸ் பீன் கிவன் தேர். சார் வெரி குட் சார், நல்ல பாயிண்ட் சார். இன் கைண்ட் வாட் ஐ காட் இஸ் ஒன்லி த லேண்ட் டெவலப்மெண்ட் ரைட்ஸ். அந்த லேண்டுக்கு என்ன வேல்யூன்னு பார்த்து அது ஒரு கைடன்ஸ் வேல்யூ எங்கேயாவது சப் ரிஜிஸ்டர் ஆஃபீஸில் பிடிச்சி அந்த வேல்யூவை போட்டு அதுக்கு டேக்ஸ் கட்டிட்டு கவர்மெண்ட் ஆஃபீஸை போட்டு வெறுப்பேற்றி விட்டுடலாம் சார். எந்த டேக்ஸும் ரொம்ப லோ டேக்ஸாக இருக்கும், பார்த்துடலாம் சார். ஐ கேன் சே தட் அதில் நிறைய லாஜிக்கல் ஃப்ளா இருக்குது. ஃபர்ஸ்ட் ஆஃப் ஆல், ஏன்னா வெறும் லேண்டை நீங்கள் ஓனர் ஆகிறதுக்கே ஒன்றும் முயற்சி பண்ணலன்றது வேறு விஷயம், லேண்ட் டெவலப்மெண்ட் ரைட்ஸ் தான் ட்ரான்ஸ்ஃபர் ஆகிருக்கு, நீங்கள் லேண்ட் ஓனர் ஆகலன்றது வேறு விஷயம். அதுதான் முன்னாடி ஆரம்பிக்கும் போதே நான் சொன்னேன். சரி இருக்கட்டும், ஒரு ஆர்குமெண்ட் பர்பஸ்க்கு அந்த ஆர்குமெண்ட் அப்படியே ஓப்பன்லேயே இருக்கட்டும். அவனுடைய ஸ்டாண்ட், லா மேக்கர்னுடைய ஸ்டாண்ட் என்னன்னு புரிஞ்சுக்கோங்க. இன் கேஸ் ஆஃப் திஸ் மேட்டர் வாட் இஸ் ட்ரைங் டு சே இஸ், சார் எல்லாரும் செக்கில் பணம் கொடுத்தாங்கன்னா உங்களுடைய இந்த ஆரஞ்சு கலர் ஃப்ளாட்டுக்கு ஓனராக போகிற அந்த லேண்ட் ஓனர் என்ன பண்ணார்? லேண்ட் டெவலப்மெண்ட் ரைட்ஸை கொடுத்தாரு. நீங்கள் மற்றவங்களுக்கெல்லாம் எப்படி அந்த 1648 ஸ்கொயர் ஃபீட்டு 3 பெட்ரூம் ஃப்ளாட்டை செலவு பண்ணி கட்டினீங்களோ அதே மாதிரி தான் இவருக்கும் கட்டினீங்க. ஸோ உங்களுக்கு தேர்ட் பார்ட்டி ஆர்ம்ஸ் லென்த் ப்ரைஸாக தேர்ட் பார்ட்டிக்கு என்ன ப்ரைஸில் நீங்கள் பண்ணி கொடுத்தீங்களா கன்ஸ்ட்ரக்ஷன் காஸ்ட்டு, அதை இதில் கம்பேர் பண்ணிக்கோங்க, அதான் உங்களுக்கு நல்லதுன்றார். சிம்பிள். சார் இது புது கான்செப்டாக இருக்கே. இப்போ என்ன இந்த 2019 தான் வந்ததுன்னா சார் ஏற்கனவே ரூல் 27 இருந்தது, ஏற்கனவே செக்ஷன் 15 இருந்தது, இதுக்கு கரோலரி எல்லாம் நிறைய இருந்தது. ஸ்பெசிஃபிக்காக 1/4/2019, 3/2019, 6/2019 எல்லாம் சர்க்குலர் வந்தது. அதில் விளக்கமாக சொன்னாங்க. ஒரு FAQ 14/5/2019 அன்றைக்கி வந்தது. இன்னும் தெளிவாக சில வார்த்தைகளே அதுலேயும் சொன்னாங்க. பட் லாவில் இருக்கிறது தான் எக்ஸ்பிளைன் பண்ணாங்க. இல்லாத ஒன்று அவங்க புது ப்ரொவிஷன்லாம் எடுத்து வந்து கொடுத்துடல. ஸோ அப்போ என்ன தெரிய வருதுன்னா, யாருடைய கம்பேரபிள் ஃப்ளாட் தேர்ட் பார்ட்டி கிட்ட போகிறதோ அதுதான் உங்களுக்கு கம்பேரபிள் வேல்யூவாக உங்களுக்கு இருக்குன்றது தெரியுது. ஸோ அது பண்ணலாம் சார். இதுவும் ஓகே சார், நான் அது கூட ஒத்து வரேன் சார். இப்போ அதுக்கு என் பிரச்சனையை முதல் தீர்த்து வைங்க. யாருடைய ஃப்ளாட்டை நான் கம்பேரபிள்னு எடுக்கிறது? 100 ஃப்ளாட் நீங்கள் சொன்னதில் 70 ஃப்ளாட் மூணாவது மனுஷன் சார், தேர்ட் பார்ட்டி சார். இந்த 70 பார்த்தா வந்து ஒரு இந்த பீரியட் ஆஃப் அபவுட் சம் 1 year and 8 months, about 20 months சார். செவரல் பீப்புள் ஹவ் காட் கம் தேர் அண்ட் ரிஜிஸ்டர்டு. எந்த ஃப்ளாட்டோட போய் நான் வந்து கம்பேர் பண்ணி எடுத்துக்கிறது? இல்லை நீங்கள் இதே மாதிரி ஈக்குவலன் ஃப்ளாட் தான் சார். அந்த ஃப்ளாட்டில் வந்து ஒரு 25 ஃப்ளாட் வந்து 3 bedroom ஃப்ளாட் சார். லேண்ட் ஓனர் ஃப்ளாட் மாதிரியே 3 bedroom ஃப்ளாட். இந்த 25 பேரில் யாருடைய வேல்யூ நான் இதில் வந்து கம்பேர் பண்ணி எடுத்துக்கிட்டோம்? விச் வில் பி ரைட் ஃபார் மீ அப்படின்னா தட் ஆல்சோ காட் ஆன்சர். அதை சொல்லும்போது தெளிவாக அவங்களே என்ன சொல்கிறாங்க அப்படின்னீங்கன்னா, அந்த நான் சொன்ன பார்த்தீங்களா FAQ, இதுக்கு முன்னாடி அது கிளாரிட்டி இருக்குது, பட் FAQ இன்னும் கொஞ்சம் பெட்டராக இருக்குது. இந்த பேராகிராஃபில் வாட் இஸ் நியரஸ்ட் டு த டேட் ஆன் விச் சச் டெவலப்மெண்ட் ரைட் எக்ஸெட்ரா இஸ் டிரான்ஸ்ஃபர்டு டு த ப்ரொமோட்டர். வீடு கட்டுற டெவலப்பரான உங்களுக்கு எந்த டேட்டில் ஜாயிண்ட் வெஞ்சர் அக்ரிமெண்ட் போடுறீங்களோ அந்த ஜாயிண்ட் வெஞ்சர் டேட்டுக்கு கிட்டக்க ரொம்ப கிட்டக்க இருக்கிற ஒரு தேர்ட் பார்ட்டி டிரான்சாக்ஷனை எடுத்துக்கோங்க. தேர்ட் பார்ட்டி மூணாவது ஆள் வந்து பையர் வந்து வாங்குறாரு இல்லையா, அவரோட இருக்கிறத எடுத்துக்கோங்க. அவர் தான் உங்களுக்கு கரெக்டான வேல்யூவை இண்டிகேட் பண்ணுறவர். ஒரு 3 bedroom ஃப்ளாட்டு மூணாவது மனுஷனுக்கு தேர்ட் பார்ட்டிக்கு ஆர்ம்ஸ் லென்த் ப்ரைஸில் கன்ஸ்ட்ரக்ட் பண்ணி கொடுக்கறதுக்கு கன்ஸ்ட்ரக்ஷன் காஸ்ட் நீங்கள் என்ன சொல்கிறீங்களோ அந்த கன்ஸ்ட்ரக்ஷன் காஸ்ட்டை நீங்கள் இவருக்கும் இருக்குது, அதாவது வந்து லேண்ட் ஓனருக்கும் இருக்குதுன்னு நினச்சிட்டு யூ பே ஃபார் தட் ஒன். யூ ஆஸ்க் ஒன் சார். இப்போ கூட நான் கொஞ்சம் கன்வின்ஸ் ஆகலை சார். சார் நீங்கள் தேர்ட் பார்ட்டியோட கம்பேர் பண்ணுறீங்க சார், இது ரொம்ப அநியாயம் சார். தேர்ட் பார்ட்டி வந்து ஒரு பீஸ் ஆஃப் லேண்ட் UDSையும் வாங்கிக்கிறாரு, ஒரு என்ன கன்ஸ்ட்ரக்ஷன் பண்ண சொல்லி ஒரு ஃப்ளாட்டையும் சொல்கிறாரு. அது ஒரு தனி ஸ்டோரி. ஒரு 70 பேருக்கும் ஒரே மாதிரி பண்ணிட்டு இருக்காங்க சார். லேண்ட் ஓனரை பொறுத்தவரைக்கும் லேண்ட் ஓனருக்கு நான் என்ன லேண்டை கொடுக்குறேன்? நான் ஒரு லேண்டும் கொடுக்கல. இல்லாத லேண்டுக்கு, கொடுக்காத லேண்டுக்கு என்ன வேல்யூவேஷனு, என்ன வேல்யூ, என்ன டேக்ஸ் வேண்டி கிடக்கு, எப்படி நான் கொடுக்க முடியும்? லேண்ட் ஓனருக்கே எப்படி லேண்டு கொடுக்க முடியும்? அவரே ஒரு 25% லேண்டு பிடிச்சி வச்சுருக்காரு அவர் கையில். நான் எப்படி கொடுக்க முடியும்? என்ன வேல்யூவேஷனா சார்? மேர்லி ஃபார் வேல்யூவேஷன் பர்பஸு ஏற்கனவே சொன்ன மாதிரி நீங்கள் ஒரு பினைன் அசஸியாக இருந்தீங்கன்னா கிராஸ் வேல்யூவில் 1/3 டீமிங் பேசிஸில் லேண்டை விட்டுட்டு நீங்கள் பே பண்ணுறதுனா பண்ணுங்க சார். நான் சண்டை போடுற அசஸி சார், அக்ரெசிவ் சார். சரி ஓகே, லேண்ட் வேல்யூ கண்டுபிடிச்சி ரிமூவ் பண்ணிவிட்டு நான் அந்த சோகால்டு ஃபஸ்ட்டு நியரஸ்ட் பையர் சொல்கிறேன் பாருங்க, அவருக்கு வேல்யூ கண்டுபிடிச்சிட்டு பேலன்ஸ் அமௌண்ட்டுக்கு டேக்ஸ் கட்டுறேன்னு ஒத்துக்கோங்க. எதிர் ஆஃபீஸ் யூ கேன் டூ. ரெண்டுமே பண்ணல அப்படின்னா யுவர் இன்டர்பிள். யூ கேனாட் டெனை யுவர் லைபிலிட்டி. ஐ சே இல்லை சார், ஐ வாஸ் டோல்டு தெர் இஸ் ஒன் கேஸ், இந்த வசந்தா கார்டன்ஸ்னு ஒரு கேஸ் ஏதோ ஹைதராபாத் செஸ்டாட்டில் டிசைட் பண்ணாங்களா சார். இந்த பேரா நம்பர் 7 எழுதும்போது ஜட்ஜி எழுதியிருக்காரு பாருங்க சார், மிஸ்டர் ரவீந்திரன். ஒரு ஃபண்டாஸ்டிக் வேர்ட் சார். இட் இஸ் நாட் அ ராக்கெட் சயின்ஸ் டு அண்டர்ஸ்டாண்ட். ஆஃப்டர் ஆல், இன் அ கேஸ் ஆஃப் a JDA, already the builder is making the entire process to suffer the tax, including the value of the landowner. Then where is the question of that being taxed again, which is leading after all to the double taxation? இதே வார்த்தை அப்படியே பேரா 7 எழுதியிருக்கார் சார். அப்புறம் பேரா நம்பர் 11 வந்து ஒரு பியூட்டிஃபுல் அனாலிசிஸு, 14 ஒரு ஹிட்டு, அப்புறம் இந்த அப்புன்னு ஒரு கம்பெனியினுடைய சார்ட்டர்ட் அக்கௌண்டன்ட் சர்டிஃபிகேட்டு நீட்டாக வருது சார். அதே மாதிரி நாங்களும் பண்ணிட போகிறோம் சார். சார் ஃபஸ்ட்டு விஷயம் அது சர்வீஸ் டேக்ஸ் கேஸ். ரெண்டாவது விஷயம் அது சுப்ரீம் கோர்ட்டில் தொங்கின்னு இருக்கு. மூணாவது விஷயம் இதுக்கு அதுக்கு இருக்கிற சில சீரியஸ் டிஃபரன்சஸ் இருக்குது. சப்ஜெக்ட் டு தட் ஒன்லி வி கேன் டேக் தட் ஸ்டாண்ட். நாட் ஈஸி. நீங்கள் தப்பு பண்ணிட்டீங்கன்னா நீங்கள் ஃபைட் பண்ணுறதுக்கு இதை ஒரு டூலாக யூஸ் பண்ணுங்கள். தப்பு பண்ணுறதுக்கு முன்னாடி தயவு செய்து இந்த டூலுக்குள்ளெல்லாம் போகாதீங்க, இந்த நெகட்டிவ் பிரச்சனைக்குள்ளெல்லாம் போகாதீங்க. இது ஒரு ஐடியாவாக தயார் பண்ணுறது, டெவலப் பண்ணுறது அவ்வளோ பெயின்குள்ளே நீங்கள் மாட்டிக்க வேண்டிய அவசியம் இல்லை. அட்வைசபிள். இது ஒரு டிஸ்பியூட். இந்த டிஸ்பியூட் வந்து இங்கே கோர்ட்டில் செட்டில் ஆகிறதுக்கு இட் வில் டேக் டிகேட்ஸ் டைம். ஆக்சுவலி இட்ஸ் அ வெரி ஓல்டு கேஸ் வாட் ஐ எம் ரெஃபரிங் டு ஹியர். அது ஆக்சுவலாக 2014 எமனேட் ஆனது. 9 வருஷ கேஸு. இது 17 டிசைட் ஆச்சு, இன்னும் போயிட்டு இருக்கு. We have to see that what is going to happen there. So I won't be able to give you a complete clean sheet for this kind of argument in case of a GST scenario, because GST law is very reasonably giving the liability related questions clear. Last point. இல்லை சார், இந்த ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்ஸ்னு ஒரு குண்டு ஒன்று தூக்கி போடுறாங்க. அது என்னென்ன புரியவும் மாட்டேங்கிறது ரொம்ப பிரச்சனையாக இருக்குது சார். வாட் இஸ் தட் ஆக்சுவலி? அதுக்கு என்ன வேல்யூ, யார் கட்டணும்? ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்ஸ்னால் எந்த ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்டுன்ற அந்த வேலையை செஞ்சவர் யார்? எனக்கு ஒன்றுமே புரிய மாட்டாங்க. அதில் வேறு 2018 முன்னாடி போட்ட அக்ரிமெண்ட்டு, 25th January 2018 ஒரு கட் ஆஃப் டேட் ஏதோ நல்ல நாள் சொல்கிறாங்க. அது என்ன டேன்னு எனக்கு தெரியல. அது ஏதோ ஒரு டேட் ஒரு குறுக்க வர்றது, எது சார் நான் பண்ணணும்? இட் இஸ் அ கொஸ்டின். வெரி சிம்பிள். வாட் யூ நீட் டு நோ இஸ், ஃபர்ஸ்ட் ஆஃப் ஆல் ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்டுன்ற ஒரு வேலையை செஞ்சவர் யாருன்றது உங்களுக்கு எல்லாருக்குமே தெரியும், லேண்ட் ஓனர். அவர் லேண்டை விற்கல. ப்ளீஸ் ரிஜிஸ்டர் இன் யுவர் மைண்ட். இன் எ ஜாயிண்ட் டெவலப்மெண்ட் அக்ரிமெண்ட், லேண்ட் ஓனர் டிட் நாட் செல் ஹீஸ் லேண்ட் அவுட்ரைட் பேசிஸ். இ நெவர். அவர் பார்க்கல, லேண்ட் டெவலப்மெண்ட் ரைட்ஸை கொடுத்தார், அவ்வளோதான். லேண்டை ட்ரான்ஸ்ஃபர் பண்ணல. சரி, லேண்ட் டெவலப்மெண்ட் ரைட்ஸை ட்ரான்ஸ்ஃபர் பண்ணது ஒரு சர்வீஸா சார்னா நிச்சயமா நிச்சயமா. ஒரு விஷயத்தை நீ எப்படி பண்ணிக்கிறியோ பண்ணிக்கோ, இதுதான் என்னுடைய ப்ராப்பர்ட்டி வச்சுக்கோ அப்படின்னு ஒரு ரைட்ஸை கொடுக்குறாங்க. ஏன்னா அந்த ரைட்ஸ் அவருது. இந்த மாதிரி ஒரு ஜேடிஏ இல்லைன்னா சிஎம்டிஏல போய் அப்ரூவல் வாங்க முடியாது. ஏன்னா யாருடைய லேண்டில் யார் டெவலப் பண்ணுறது? லேண்ட் ஓனர் ஒத்து வந்தால் தான் நீங்கள் போய் கை வைக்க முடியும். யுவர் மென் அண்ட் மெட்டீரியல் கேன் என்டர் ஆன் திஸ் பர்டிகுலர் டே, யூ ஆர் பர்மிட்டட் அப்படின்ற வார்த்தை அதுக்குள்ளே இல்லைன்னா கடப்பாறை தூக்கி நீங்கள் உள்ளே எல்லாம் போக முடியாது. இட்ஸ் நாட் பாசிபிள். ஸோ அப்போ அது ஒரு விதமான டாக்குமெண்டேஷன் ஃபார் ரைட்ஸ் ட்ரான்ஸ்ஃபர். அந்த டெவலப்மெண்ட் ரைட்ஸை ட்ரான்ஸ்ஃபர் பண்ணுறச்சே யூ நீட் டு ஃபிக்ஸ் த வேல்யூ. சார் அதுவே கட்டாந்தர, அதில் என்ன வேல்யூ போய் ஃபிக்ஸ் பண்ணுறது? வேணா வச்சுக்கலாமா? கைடன்ஸ் வேல்யூ வேணால் போட்டுக்கலாமா சார்னா? சார் டெவலப் பண்ணி அதில் என்ன வருதோ அதுக்கான ரைட்ஸ்க்கான வேல்யூ பற்றி பேசிகிட்டு இருக்கோம். நீங்கள் ஒரு 4 மீட்டர் பாலிஸ்டர் துணி வாங்கினீங்கன்னு வச்சுக்கோங்க. வாங்கினீங்கன்னா சின்ன ஜன்னலாக இருந்ததுனீங்கன்னா ஒரு கர்டன் போடலாம். ஓரளவு துணி கௌரவமாக டீசெண்டாக இருந்தது, ஆஃபீஸுக்கு போட்டு போகலான்னீங்கன்னா ஒரு நாள் சட்டை தேய்ச்சிக்கலாம். ஸோ இல்லை நீங்கள் ரொம்ப கன்றாவே இருந்ததுன்னா அட்லீஸ்ட் ஒரு டேபிள் கிளாத்தாக யூஸ் பண்ணிக்கலாம். ஸோ நீங்கள் வாங்குகிற துணியை என்ன பண்ண போகிறீங்கன்னு பொறுத்து தான் அதனுடைய வேல்யூ இஸ் டிஃபரிங். ஸோ ஒரு பில்டர்கிட்ட கொடுக்குறீங்கன்னா நீங்கள் பேரன் லேண்டோட வேல்யூ போகிறோன்னா அவனை லேண்டாக வச்சு பிளாட்டாக வித்துட்டு இருக்காரு. பிளாட் மேலே அவர் டெவலப் பண்ணுறாரு சார், அதனால தான் டெவலப்மெண்ட் ரைட்ஸ்னே சொல்கிறீங்க. அப்போ அந்த டெவலப்மெண்ட் பண்ணும்போது கிடைக்கிற ப்ராடக்ட்னுடைய வேல்யூ என்ன அப்படின்னீங்கன்னா த ஆன்டிசிபேட்டட் வேல்யூ. சார் அப்போ கூட அது ஆன்டிசிபேட்டட் தான் சார். அது எப்படி சார் டிசைட் பண்ணுறதுன்னா, ஆஸ் ஐ ஆல்ரெடி டோல்ட் யூ, டெவலப்மெண்ட் ரைட்ஸுக்கும் இதே 41A 41B என்ட்ரி எல்லாம் நோட்டிஃபிகேஷன் நம்பர் 33/2009 என்ட்ரி போடும்போதெல்லாம் தே ஆர் ரெஃபர்டு டு திஸ் மேட்டர் ஒன்லி. ஒரு ஜாயிண்ட் டெவலப்மெண்ட் ரைட்ஸில் ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்ஸ் பண்ணும்போது ரிவர்ஸ் சார்ஜ் இந்த பில்டர் மேலே விழுறதுன்றது உண்மை தான். ஆனால் எக்ஸ்க்ளூஷன் சொல்லும்போது என்ன சொல்கிறாங்கன்னா, சார் நீங்கள் ஒரு பில்டராக ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்ஸ் எல்லாம் கட்டவானான்னு ஆசைப்பட்டீங்கன்னா, ஆமாம் சார் அதுக்கு தான் சார் ஆசைப்பட்றேன், எப்படியாவது காப்பாற்றுங்க சார் அப்படின்னா நீங்கள் என்ன பண்ணணும்னா உங்கள் ஃப்ளாட் எல்லாத்தையும் கம்ப்ளீஷன் சர்டிஃபிகேட் டேட்டுக்கு முன்னாடி கம்ப்ளீட்டாக புக் பண்ணிவிடுங்க. ரொம்ப கன்ஃபியூஷன் ஆகி போச்சு. சேல்ஸ் மேனேஜர் கூட இதெல்லாம் சொல்லவே இல்லையே நமக்கு. என்ன சொல்கிறான் லா மேக்கர்னே புரியலையே. உன் ஃப்ளாட் எல்லாத்தையும் வித்துடு அப்படின்னு என் எம்டி சொன்னார்னா கரெக்டு. ஏன்னா பாவம் பணத்தை காசை போட்டு உட்காந்து மூச்சுட்டு இருக்காரு. இல்லை நம்ம ஆஃபீஸில் வேலை செய்கிற நம்ம ஒரு பெரிய பில்டர் கம்பெனி, நமக்கு ஒரு சேல்ஸ் மேனேஜர் இருக்காரு அப்படின்னீங்கன்னா அவர் சொன்னார்னா ஒரு நியாயம். இந்த லா மேக்கர் எதுக்கு நார்த் பிளாக்ல உட்காந்து இதெல்லாம் சொல்லிட்டு இருக்கான் அவன், உன் ஃப்ளாட் எல்லாத்தையும் வித்துவிடு அப்படின்னு. என் ஃப்ளாட்டை விற்கிறதுல உனக்கு என்னையா சந்தோஷம் அப்படின்னா சந்தோஷம். லாஜிக் ரொம்ப சிம்பிள் சார். கவர்மெண்ட் எதுவுமே மீனிங் இல்லாமல் எழுதாது. என்ன சொல்ல வராங்க அப்படின்னா, நீங்கள் ட்ரான்ஸ்ஃபர் ஆஃப் டெவலப்மெண்ட் ரைட்ஸை கட்ட வேணான்னு ஆசைப்பட்றீங்களா? எஸ் வி பர்மிட் யூ, ப்ரொவைடட் யூ see that all your flats are all, the word is important, all your flats are booked well before the date of, or at least before the date of your completion certificate. அப்படி ஆனால் என்ன ஆகும்? அப்படியே கொஞ்சம் இமேஜின் பண்ணி பாருங்கள், பிக்சரைஸ் பண்ணுங்கள். நீங்கள் புக் பண்ணுற எல்லா ஃப்ளாட்டுக்கும் ஜிஎஸ்டி கமிட் ஆகிறீங்க. அப்படின்னா என்ன அர்த்தம்? நான் காமிச்ச அந்த பிக்சரில் இருக்கிற அந்த 100 ஃப்ளாட்டுக்கும் யூ ஆர் கமிட்டிங் டு த கவர்மெண்ட் தட் எஸ் ஐ எம் ரெடி டு பே த ஜிஎஸ்டி வாட் எவர் இட் இஸ், நான் கமிட் ஆகிட்டேன்ப்பா, ரைட். ஸோ கவர்மெண்ட் இஸ் கேரண்டீட் த ஜிஎஸ்டி ஃபார் தட். அப்போது போனால் போதுன்னு ஒரு கன்செஷன் தானே, சரி ஓப்பா 100 ஃப்ளாட்டுக்கு வேறு ஜிஎஸ்டி கட்டிடுறேன்னு ஒத்துன்ட்டு ஓய்வு பண்ண கொடு, அந்த டிடிஆர் ஒன்று வேண்டாம். அப்போ நம்ம திருப்பி நம்ம வழக்கமான இந்தியன் கேள்விக்கிறோம், சார் 100 ஃப்ளாட்டு கரெக்டாக புக் பண்ணாதான் பண்ணலன்னா சார் அதை கேட்கணும்ல, கேட்டால் தானே நமக்கு சந்தோஷம். சரி சார் 90 ஃப்ளாட் பண்ணால் என்ன சார் பண்ணுவீங்க அப்படின்னா 90% கொடுப்போம். 90% ஆஃப் வாட்ஸ் 90% விட்டுருவாங்க சார் டிடிஆர் போட்டு, மீதி இருக்கிற 10%க்கு நீங்கள் வேல்யூ போட்டு 18% டேக்ஸ் கட்டணும். சரி சார் ஓகே, புக்கே ஆகலை என்ன சார் பண்ணுவீங்க நீங்கள்? மொத்தத்துக்கும் கட்டுங்க. சார் இதுனா சார் அநியாயமாக இருக்குது, புக் ஆகலன்றது எனக்கு பனிஷ்மெண்ட்டா சார்? உங்களுக்கு பனிஷ்மெண்ட் இல்லை சார், புக் ஆகலாம் கவர்மெண்ட்டுக்கு ஜிஎஸ்டி வராது. நீங்கள் ஒரு திருப்பி இதே லாஜிக் திருப்பி பிக்சரைஸ் பண்ணுங்கள். ஒரு ஃப்ளாட் கட்டுறீங்க, அப்பார்ட்மெண்ட் வந்துடுது, ஒருத்தம் கூட வரவே இல்லை, கேட்ட காலம் வரவே இல்லை, கொரோனானாலும் இல்லை, சும்மாவே வரலாம், ஏன் வரலன்னு தெரில. ஃப்ளாட்டே விற்கல, 20 ஃப்ளாட் கட்டணும், நம்ம கட்டிட்டு முழுசாக ஏமா மாதிரி நிற்கிறது முன்னாடி ஒன்றும் விற்கவே இல்லை, 20 ஃப்ளாட் இருக்குது, லேண்ட் ஓனர் மட்டும் தான் வந்திருக்கார். இப்போ என்ன பண்ண முடியும்? இந்த சிச்சுவேஷனில் யூ ஆர் நாட் கோயிங் டு பே அட் ஆல். கம்ப்ளீஷன் சர்டிஃபிகேட் ரேராவில் வேறு ரொம்ப பிராணம் வாங்குறான்னு சொல்லிட்டு நீங்கள் என்ன பண்ணீங்க? போய் வாங்கிட்டீங்க, கிளியரன்ஸ் சர்டிஃபிகேட் வாங்கியாச்சு. நீங்கள் போய் சிஎம்டியில் போய் கம்ப்ளீஷன் சர்டிஃபிகேட் வாங்கியாச்சு, ரெக்கார்ட் பண்ணியாச்சு. கம்ப்ளீஷன் சர்டிஃபிகேட் வாங்கின அப்புறம் வாட் யூ வில் பி டூயிங்? Nothing can be done. You are not going to pay GST at all. When you are very sure that you are not going to pay GST at all, government is very sure that somehow they will collect the money from you, at least by way of TDR. Sir, proportionately if I am doing it, proportionally they will collect the TDR. That's how it is, simply. So the logic is very clear. Anyhow, winner is government. So strictly speaking, unga plans eppadi pannunganna, please don't push your RERA process or completion certificate unduly. உங்களுக்கு எவ்வளோ டைமுக்குள்ளே சீக்கிரமாக புக் பண்ண முடியுமோ முதல்ல பண்ணுங்க. ஏதாவது ஒன்று தான் சார் வரணும், சின்ன கோடு பெரிய கோடு கதை தான். ஒன்று தயவுசெய்து புக்கிங் முடிச்சிடுங்க. முடிக்க முடியல தயவுசெய்து கம்ப்ளீஷன் சர்டிஃபிகேட் பின்னாடி தள்ளி போடுங்க. எத்தனை ஒன்று பண்ணுங்க. கம்ப்ளீஷன் சர்டிஃபிகேட்டையும் வாங்கிடுவேன், நான் புக்கிங்கும் வந்து பண்ண மாட்டேன், நான் GSTயும் கட்ட மாட்டேன், TDRம் வரக்கூடாது. You cannot have the cake and eat the cake too. Either of these should be possible. So in that sense, please make some business plan. If you are an advisor to any company, please give them advice that don't hurry unduly for getting the completion certificate or first occupation. Please ensure that you are occupying all the premises or say, booking all the flats in your project and do. சார் எனக்கு திடீர்னு ஒரு டவுட் வந்தது சார். நீங்கள் காமிச்சிங்களே சார் அந்த எக்ஸாம்பிள், அந்த 100 ஃப்ளாட் மேட்டர் காமிச்சிங்க இருக்கட்டும் சார். அதில் வந்து ஒரு 50 ஃப்ளாட் வந்து தேர்ட் பார்ட்டி புக் ஆகிடுதுன்னு வச்சுக்கோங்க. இப்போ நான் என்ன சார் கவுண்ட் பண்ணணும்? 50/100 போடணுமா? ஏன் சார் 50/100? அதானே சார் 50 தானே புக் பண்ணாங்கன்னு. நல்லா ஞாபகம் வச்சுக்கோங்க. யுவர் ஃபர்ஸ்ட் கஸ்டமர் in JDA is the landowner. Please remember this sentence. Your first customer in a JDA is your landowner. Sir, barren land எப்படி வரப்போகுதுன்னே தெரியாத போது மென்டலி நீங்கள் எப்படி கன்சீவ் பண்ணீங்களோ அதே மாதிரி அவரும் யோசிச்சு 4வது ஃப்ளோரில் E பிளாக்ல 2வது ஃப்ளாட் எனக்கு, 5வது ஃப்ளோரில் F பிளாக்ல 6வது பிளாக் எனக்குன்னு அவர் தான் புக் பண்ணுறார். தட் இஸ் புக்கிங். Joint development agreement is an evidence for booking. So it got booked. Believe that landowner portion is the first set of booking, subsequently somebody will be coming there and you will be booking it. That's how it is. So that way you have to plan that one. If you have any questions, and I am having the mercy of yours to have the reply also, you can plan. Did you? We are paying approval fees to the CMDA DTCP whether RCM applicable on approval fees payment. Prabhakaran DR. In this case, question புரிஞ்சுக்கோங்க சார். நாங்கள் சிஎம்டிஏக்கு டிடிசிபிக்கெல்லாம் வந்து அப்ரூவல் ஃபீஸ்ன்னு கட்டுறோம். நீங்கள் தான் சொன்னீங்க கவர்மெண்ட் ஃபீஸ்க்கெல்லாம் வந்து 13/2017 CTRனு ஒன்று இருக்குது. அதில் கவர்மெண்ட் சர்வீஸ் ரிசீவ் பண்ணிங்கன்னா யூ வில் பி லைபிள் டு பே GST என்ற RCM 18% அப்படின்னு. அந்த RCM கட்டிட்டு உங்களுக்கு வேறு GST ஐடிசியும் கிடையாதுன்னு வேறு சொல்லிட்டீங்க. இது வீணாக போயிடும். இந்த மாதிரி கேஸில் வருமா? இது கவர்மெண்ட் சர்வீஸ் தானேன்னா கண்டிப்பாக அது லோக்கல் அத்தாரிட்டி கேட்டகரியில் வரணும். த பாயிண்ட் இஸ் அவங்க லோக்கல் அத்தாரிட்டி பாயிண்ட்டுக்குள்ளே வராங்கனாலே யூ கேன் ஆல்வேஸ் அண்டர்ஸ்டாண்ட் ஒன் பாயிண்ட். The services rendered by central government, state government, local government, read together with 234W and 234M respectively for municipality and the corporation, have a separate exclusion. Few services rendered by them. அவங்களே exempted அப்படின்னீங்கன்னா, லோக்கல் சர்வீஸ் அத்தாரிட்டி சர்வீஸ் பண்ணுறாங்க அப்படின்னீங்கன்னா, அவங்க எக்ஸம்ப்டட்னா அவங்க சர்வீஸை கன்சியூம் பண்ணுறாங்க, யூ ஆர் ஆல்சோ ஹேவிங் நோ லைபிலிட்டி. 2 தடவை இதுவரை ஆல்ரெடி we got the refund. We paid under protest, got the refund also, one in Karnataka and one in Kerala. So in this case, you can prove that it is a service rendered by local authority which is exempted by 12/2017 CTR. Hence, 13/2017 CTR shall not be applicable. அதுக்கு exempted RCM வராது அப்படின்னு you can do. Not a problem. In a JDA, when will the landowner become liable to GST even when the developer is paying GST under RCM? அப்படின்றது கேள்வி. As I already told you, hope you can recall, the moment you get into the lease agreement, the JDA agreement as a landowner, you have to anticipate that the builder is going to collect the GST from you. The time of collection only is officially postponed. Only just for the purpose of quantifying in a better way, அந்த கீ ஹேண்ட் ஓவர் பண்ணும்போதோ ஃபர்ஸ்ட் ஆக்குபேஷன் போதோ கம்ப்ளீஷன் சர்டிஃபிகேட் வரும் விச் எவர் இஸ் ஏர்லியரில் வரப்போகிறது, அவ்வளோதான் விஷயம். ஸோ இஸ் லைபிள் டு பே, லேண்ட் ஓனர் இஸ் லைபிள் டு பே. கொஸ்டின் என்னன்னா, தட் இஸ் ஓகே சார், பட் அவர் ஆர்சிஎம்ல பே பண்ணுறாருன்னா அப்படின்னா, RCM is relating to transfer of development right only, not relating to the landowner's liability to be paid. The builder has got all official legal rights to collect the GST related to the landowner flat. Please understand. He has got a right. And the right exercise பண்ணுறதுக்கு your bilateral agreement should give way. If not, okay, நீங்கள் வேணா சார் நான் அதெல்லாம் கொடுக்க முடியாது, நீங்கள் எதை பே பண்ணிக்கோங்க, நீங்கள் அண்டர்ஸ்டாண்ட் பண்ணிட்டீங்கன்னா அது உங்கள் இஷ்டம். Subject to income tax provisions. Take care. 224 is wide enough in income tax, it will cover everything. 224 இருந்தாங்கன்னா that will become your liability paid by them, ஏதாவது வரலாம் டிஃப்ரெண்ட். பட் உங்கள் கேள்விக்கு பதில் என்னென்னா, எந்த டைம்லையும் டெவலப்பர் இஸ் நாட் அண்ட் cannot அண்ட் ஷல் நாட் ஆல்சோ பே ஆர்சிஎம் ஃபார் யுவர் லேண்ட் ஓனர்ஸ் போர்ஷன். அவர் டிடிஆர்னு நான் சொன்ன கேல்குலேஷனில் சர்டிஃபிகேட் கம்ப்ளீஷன் சர்டிஃபிகேட் வரும்போது ஒரு பிரச்சனை போகுது, இமே பே. சார் நான் லேண்ட் ஓனர் டேக்ஸை நானே வாங்கி கட்டிடுறேன் சார் அப்படின்றதுனா, நானே வாங்கி கட்டுறதுன்றது தான் உங்கள் வேலை. தட்ஸ் வாட் யூ ஆர் டூயிங் இட். கையை விட்டு கட்டுறேன் அப்படிங்கிறது இட்ஸ் a bilateral understanding unless it is recorded. That is not the case at all. So there is no question about the RCM at all as such. Then TDR should be for all 100 flats right away. We have taken only owner's part because owner is giving TDR for all 100 flats only, not for 30 flats. TDR should be for all 100 flats. Of course, the working is done in that way only. See, as far as calculation is concerned, இப்போ நம்ம பார்த்த எக்ஸாம்பிளில் பார்த்தீங்கன்னா 100 flats இருக்குன்னா 100 flats can overall rights are taken up as such. This is what development rights. Whether 30 is booked-னா நான் முதல்ல சொல்லிட்டேன். First customer is landowner, booked. Sir, 70 third party buyers are coming there, booked. 30 plus 70, 100 booked divided by 100, completely cleared, no TDR at all. No sir, 30 flat owners, 50 third parties, totally 80. 80 by 100 is duly covered, 20 by 100 not covered, 20 by 100 will be the ratio of TDR payable. In simple words, நீங்கள் கட்டாமல் விட்டுட்டீங்க அப்படின்னீங்கன்னா, ரேதர் நீங்கள் புக் பண்ண விடையாமல் விட்டுட்டீங்க அப்படின்னா, எது புக் பண்ணாமல் விடையாமல் போயிடுத்தோ அது உங்களை டிடிஆரில் இழுத்து விட்டுரும். அவ்வளோதான் விஷயம். புக்கிங் முடிஞ்சுடுது சார், அப்புறம் தான் கம்ப்ளீஷன் சர்டிஃபிகேட் வந்தது, ரொம்ப சந்தோஷம். முடிஞ்சால் கம்ப்ளீஷன் சர்டிஃபிகேட்டை தள்ளி போடுங்க, இல்லைன்னா புக்கிங்கை முன்னாடி போடுங்க, எதனா பண்ணுங்கள். ரெண்டுமே பண்ண மாட்டேன், ஆனால் எனக்கு டிடிஆர் வரக்கூடாதுன்னீங்கன்னா நான் ஒன்றும் பண்ண முடியாது. Then
So one request, can we take 2 more questions and
that's all.
other
The
questions
time is
we
not
can
there.
take?
Yeah. In a joint development construction, additional work done for the landowners like interior, this, that and all. Okay. At what rate GST is chargeable? See, when the agreement is encompassing this kind of work in single component actually, or construction agreement, as a composite supply only, it will be covered. The same 3.75 will ruling it. That's all. 3.75 by 3.75 minus 1 by 3. However, ஒரு clear demarcating line is there. கட்டி கொடுக்கறதுக்கான ஒரு அக்ரிமெண்ட் தனியாக இருக்குது. Additionally, if you are doing any work identifiably as it is evidenced by your own records after completion, after handing over, its finishing services, post-finishing services, 18% will be straight away attracted because it is not falling under the normal developer's work. Developer வந்து interior decorationலாம் உட்காந்து பண்ணி கொடுக்கணுன்றது இல்லை. Developer interior decoration சேர்த்து பண்ணலாம். Nothing wrong in that. That's how it is. ரத்னா கஃபேல போய் திருவள்ளிக்கணியில் போய் இட்லி சாம்பார் சாப்பிட்டீங்கன்னா சாம்பாருக்கு தனியாக பில் வராது, குடமாக எடுத்து கொட்டுவார். அதே போய் ஐடென்டிஃபைடு ஒரு ஷாப்பில் போயிட்டு இது இட்லி, இதுக்கு இது சாம்பார்னு ஒரு பேக் கொடுத்தப்பறமா இன்னும் கொஞ்சம் சாம்பார் வேணும் அப்படின்னு தனியாக கேட்டிங்கன்னா சாம்பாருக்கு அவர் சார்ஜ் பண்ணுவார். அதே தான் இந்த சாம்பார் சமாச்சாரம் தான் நம்ம ஜிஎஸ்டி சமாச்சாரம். ஒரே ஸ்டோக்கில் ரத்னா கேப் மாதிரி ஃப்ளாட்டாகவே இதுதான் உனக்கு ஸ்பெசிஃபிகேஷன் சொல்லிட்டா யூ ஆர் சேஃப். அந்த ஸ்பெசிஃபிகேஷன் முடிஞ்சப்புறமா நான் தனியாக ஏதோ பண்ண போகிறேன்னு சொன்னேன்னா you will not escape it, you will be doing it. I think this should be the last question. In a joint development construction, as to what rate is chargeable to landowner for the area portion handover as per JDA? That's what we had been explaining. As we told, as far as landowner is concerned, you might have noted when I told, he is after all another customer. வேறு ஒன்றும் அவருக்கு ஒன்றும் பெரிய ஸ்டேட்டஸ்லாம் நம்ம கொடுக்கல சார். அவர் ஒரு கஸ்டமர், அவர் ஒரு கைண்டில் பே பண்ண ஒரு கஸ்டமர். நார்மல் கஸ்டமர் செக்கில் எடுத்து கொடுத்துட்டு போகிறாரு, பேங்க் ட்ரான்ஸ்ஃபர் பண்ணிட்டு போகிறார், அவ்வளோதான். ரேட்டை பொறுத்தவரை அதே 3.75 இஸ் அப்ளிகபிள் தேர். இல்லை சார் நான் தான் கேட்குறேனே, லேண்ட் ஓனர்கிட்ட லேண்டை நான் எங்கே சார் கொடுத்தேன், வெறும் பில்டிங் தானே சார் கட்டி கொடுத்தேன், அதுக்கு என்ன சார் வேல்யூ போட முடியும்னா ஐ கிளியர்லி எக்ஸ்பிளைன்ட். இஃப் யூ ஆர் அ benign SSC, elect the route number 1, that is take the comparable third party value, artificially the so-called 1/3 they are saying remove it, try to pay that amount of tax. I just underline the word tax in the case of landowner also. Simple. No, I am a litigant assessee. நீங்கள் சொல்கிற மாதிரிலாம் நான் பினைன்லாம் கிடையாது. சண்டை போடுவேன் சார், போடுங்க. நம்ம குஜராத் கேஸில் வந்த மாதிரி நீங்கள் என்ன பண்ணலாம் அப்படின்னா ஐடென்டிஃபை த லேண்ட் வேல்யூ, இதான் சார் ஒரிஜினல் லேண்ட் வேல்யூ, இதை ரிமூவ் பண்ணுங்கள். சப்ஜெக்ட் டு தட் ஒன்லி ஐ வில் பி பேயிங் தட். ஃபைன், ஓகே, யூ கேன் டூ இட். தட் ரேட் யூ கேன் கோ ஃபார் இட். ஓகே. ஸோ அதர் கொஸ்டின்ஸ் வி மே ஜஸ்ட் ஷேர் லேட்டர். ஸோ டைம் இஸ் த கன்ஸ்டன்ட் actually. So thanks for your passion hearing. Thank you.
Thank you for the wonderful presentation, sir. May we now request CA Raghunathan, life member of the Society of Auditors, to present a memento to our speaker. May we now request CA Raghunathan. So very indulged in the GST session. Ladies and gentlemen, a big round of applause. I'm sure many of you have a lot more questions to ask. Request you to please keep it offline for paucity of time. Thank you. We now quickly move on to the next session. Accounting in real estate. May we now request CA Mr L Srikaanth on the dais, please. CA Srikaanth is a practicing chartered accountant with a master's in economics from the Madras University, working as a senior audit manager at NC Rajgopal & Co. He specializes in corporate audits, handling clients globally, including listed entities across a wide array of sectors, including real estate, banks, NBFCs, PSUs, automobiles, hospitality, manufacturing, etc. He also handles forensic audits, business valuations, M&A transactions, and frequently consults for ROC, FEMA, RBI, and semi-compliance matters. Apart from audits, he has conducted various seminars on diverse topics. Glad to have you here. May we now request CA Chandrasekharan, life member of SOA, to present a health bouquet to CA L Srikaanth. A proud moment indeed. Yes, sir.
Good evening to one and all. I myself would like to introduce because I rarely come to Society of Auditors, though I am a life member. That's my point for that. But today I had the rare opportunity of making one of my student, L Srikaanth, to present the paper. It is his maiden attempt. First, I wanted to inform you, number one. Number two, this particular subject itself, after hearing a lot of lectures right from the eminent advocate from GS specialist Mr Vaitheeswaran and from Prasanna, was able to be very lighter as well as most lucid way, both English, Tamil, Tamil English, such a beautiful versatile personality is having presented. I only wish good luck to my student, and with these few words, I would like to hear from you, and it will be a very interesting subject. Thank you to one and all. Thank you. Thank you, Steve.
Thank you for those kind words, sir. Over to you.
Very good afternoon to everyone here. I would like to thank the Society of Auditors and the MMA for giving me this. It's on? It's on, good? All good? Great. Okay. So I would like to thank the Society of Auditors and the MMA for giving me this wonderful opportunity to share the stage with such eminent personalities. And also when you are welcomed on stage by your guru, it really calms your nerves. So thank you, Chandrasekhar sir, for that. So this particular topic of real estate sector in this very novel idea of the AGILE series by the Society of Auditors is very important and warrants a lot of deliberation for many reasons. It adds to the national GDP. It contributes to the socio-economic growth of the country. All those reasons are there. My personal reason as to why real estate is very important for discussion is actually stemming from my 11th standard business studies. There is this one professor, Abraham Maslow, who has given us 5 hierarchies of needs that a human needs to satisfy. And the first one is physiological needs, and one of those is shelter. Shelter being something that affects every single human in the world needs something that needs to be highly regulated and deliberated upon to make sure that everyone gets that smoothly and in a hassle-free manner. So I think the concept of real estate being taken up for this discussion is a wonderful idea by the society, and I thank them for it. Moving on, the different aspects of real estate that's been discussed today, GST, the different technological developments that have happened, the RERA Act, the income tax angle that TJ sir is going to speak later on. These are all highly complex items that require a lot of interpretation issues, a lot of man hours being spent to understand and make others understand. When compared to all of them, accounting actually is very, very simple. All it has is one debit and one credit. That's it. So what we need to know is how much to debit, how much to credit, and where to do it, right? So compared to those other topics, mine is going to be very simple. I just have 10 slides over here, so you can all rest easy. But the thing that is complex inside accounting is what to debit and what to credit and when to do it. That's all. So inside this scope of real estate accounting, I want to cover 3 areas, which is construction contracts, JDA transactions, and leases. The reason for taking up construction contracts is simple, because in my mind, when someone says real estate, the first thing that comes to mind is one building that is half constructed, the ones that come in the climax of movies where a fight takes place, that is a constructed building that comes under real estate. So I want to cover the accounting standards that follow construction contracts. The second thing that I want to cover is a very hot topic of JDA transactions. And the third is leasing relating to immobile properties also, because that also is covered under this huge ocean of real estate activities. Going into construction contracts, there are 2 sets of standards that we have in prescription right now. AS7 construction contract and Ind AS 115, which is revenue recognition for contracts with customers, right? The standard that needs to be followed by each company or each entity depends on the set of standards that they follow. It can be the accounting standards or the Indian Ind AS 115. We'll cover AS7 first because it is actually pretty simple at the end of the day. I don't want to put in a lot of theory behind me because AS7 is something that all of us already know. I just want to touch upon it and mention certain specific areas which in my practical experience I've seen that some people might miss out on. Okay. So the first thing that we need to understand about AS7 is its perspective, and this applies for Ind AS 115 as well. The perspective under which the accounting standard revolves is from the developer's angle. It is the seller, the constructor, the contractor whose books are being regulated by AS7 and not the buyer or the contractee. Let's understand this first. Okay. The next thing is recognition. So what is recognition? Recognition is the debit and the credit that I once said. When to debit, what to debit comes under recognition, and the accounting period. The concept of accounting period becomes very prevalent for real estate transactions because invariably they get covered over 2 or 3 or more accounting periods, financial years. So we need to know when the debit and credit is supposed to come in. So that is where AS7 talks about the accounting period concept. The third is the accounting principles. There's a typo here. Okay, good. Fine. So the accounting principles that the standard wants us to follow are mainly 3. The first is the matching concept. The second is the reliability of revenue recognition and its collection. And the third is conservatism. The second and third are pretty straightforward. What the standard wants us to understand by matching concept is the revenue that is recognized in the statement of P&L for 1 year should be equivalent, not equal to, obviously, should be equivalent to the cost that gets recognized in that year, so that the profit that's booked throughout the life of the project is in a consistent manner. So that any user who looks at the financial information understands that the project has undergone a hassle-free development environment. So that is the underlying principle for AS7. The main thing that AS7 wants us to know is the contract costs and contract revenues. Of course, the definition of what a contract is, what the type of contracts are, all these are covered, but they are pretty basic theory. The most important thing would be the contract costs and contract revenues. Within these two matters, there are two things that we need to know as part of the accounting aspect. The first thing is the identification of a construction contract or a contract cost or a contract revenue, and the second would be the second part in this list, the recognition. When I am supposed to recognize in the P&L, and which are the items that I need to bring into the domain of AS7 for the deliberation as to when I am supposed to debit it to the P&L. Okay, so we will look at the first part. What are the contract costs and contract revenues, and how am I supposed to identify them? For this, the list of costs that can be taken up as a contract cost and the list of revenues that can be taken up as a contract revenue is fully prescribed by AS7. One very beautiful advantage that we have, as accounting practitioners is, when compared to at least legal practitioners, is there is a very little scope for interpretation. Lot of acts, even Income Tax Act, GST, RERA, they do have a lot of provisions which are open to interpretation. The standards try as much as they can to not have this problem, right? So it straight up says what are the contract costs that can be taken up and identified as in fact being contract costs and deliberated as to whether they can be recognized or not. The first clause here, it relates directly to a specific contract. This is straightforward. For example, I'm going to construct this building. So all the costs that I incur for this building, like purchase of steel, purchase of other materials, the labor that I hire, the depreciation for the property, plant and equipment that I employ for constructing this building, all of that will get covered under the first clause, which is relate directly to a specific contract. One small area where AS7 is a little open to interpretation would be the second clause, in my opinion. That is, those which are attributable to the specific contract activity and can be allocated to that contract. Whenever the standard does not say what the list of items is supposed to be, and it gives an open statement like this, immediately interpretation issues would crop in, right? So what the standard tries to do to mitigate this problem is, it lists out examples of what are the items that can be attributed and gives us specific items that cannot be attributed. The examples that qualify for this are also simple. Like for example, any overheads, any travel and conveyance expenses that we incur, which are specifically in relation to one particular contract, is a contract cost. That gets covered under the second clause. The problem comes with those items which are not covered under this clause. Even examples are available, but still practically we see a lot of interpretation issues coming up. For example, there are 2-3 costs like research and development, selling costs, marketing costs. These items, the standard says, are not attributable to contract activity, and therefore they are not eligible to be identified as a contract cost. Without naming the client, I can give you 1 or 2 examples in this case. We had one small time residential complex constructor who was just starting up his business. He had incurred a lot of brand, I would say brand recognition expenditure. I'm not supposed to call it marketing expenditure. He had incurred a lot of brand recognition expenditure, and the entity wanted those costs to be identified as a contract cost, and he wanted it to be added to the cost of the entire project. Now, one thing that we all need to know is the effect of identifying a cost as a contract cost or not, because any expense that I as a contractor incur, at some point of time I am going to take it to the P&L. Yes, there is no point in holding the contract cost as an asset in my books through eternity. It is supposed to hit my P&L and reduce my profit. The problem here is the matching concept that the standard wants us to follow. Only when a cost becomes a contract cost can it be eligible for deliberation as to whether it is supposed to go to an asset or not. Right? So this entity was saying that the cost that they have incurred is not a marketing cost in nature, but rather a brand recognition cost, and they wanted it to be eligible under this second clause. They wanted to call it a contract cost, they wanted to load it to the project's cost, and wanted to take it as an asset. The first thing that us as auditors said was, no, this straight up looks like a marketing expense. You are not supposed to take it to an asset. Please expense it off. They came back with another response. They said, see, all these clauses, the 3 clauses on the left, the 2 clauses on the right, all of them relate only to specific contracts that are in motion right now. The, again, brand recognition cost that I have incurred is not for any of the projects that I am running up. This is just to make the market know that myself as a player have started my business. I am just making everyone recognize my name, and it is not specific to one single contract. So, this does not fall under the domain of AS7 at all. This is not at all relating to a contract. So, who are you to call it a contract cost? So, that was their second question. He said, okay, if it is outside the domain of AS7, what is it that you want me to do here? They said, the benefit that I am going to get out of this not a contract cost is going to accrue over several years. So, by their own definition of matching concept, they did not want it to be taken to the P&L in a single year. There are 2 flaws here. The first thing is the concept of a deferred revenue expenditure has been totally done away with. First thing. Second thing is, if this is not relating to the contracts at all, then there is no point in deliberating as to whether benefit would accrue in the future or not, because the business of the entity is to do construction contracts. And if this particular expense is not relating to construction, then who are we to say when the benefit would accrue, and the entire thing would ultimately go to the P&L. Now, what I want to bring across in this point is, this second clause is very, very open to interpretation and needs to be discussed on a case-to-case basis. So, please, when you audit or account for construction costs which are not directly relatable to a specific contract, look into its nature on a singular basis and see if it is an eligible contract cost or not. Okay. The third clause is specifically chargeable to a customer. This is also pretty easy. These would basically entail all the reimbursement expenses that we claim. The catch here is that these type of reimbursements need to be entered into in the agreement that's entered between the contractor and the contractee. As long as they are listed out, then taking them as contract cost would not be a problem. Okay. So, we have done the first thing. We have identified what the contract cost should be. We'll do the second thing, which is identifying contract revenues. Contract revenues is easy. It is the initially agreed amount, which would be the consideration for the asset that is constructed, that is mentioned in the agreement, right? But I use the term initially agreed because it can change subsequently. It can change because of 3 or 4 reasons that are listed out here: variations, claims, incentives, penalties, discounts, rebates. All these are items that affect the initially agreed amount of contract revenue. Okay. So, all these terms bring out a single meaning. They change the initially agreed amount. So, what is the point in discussing each term separately? It's because the standard itself says the way a variation stems into a contract revenue is different, how a claim stems into is different, how an incentive comes into is different. See, a variation is something that the contractee develops. Say, for example, I am a contractee and an engineer or an architect is designing a house, a residential house for me. I go tell the architect to stop designing for tile flooring and ask for a marble flooring. Or I asked the engineer to use a different type of wood for my door or for my furniture. These are all items that the contractee asks for, right? He is the one who initiates the variation in the contract revenue. So that would fall under the terminology of variations. Claims would be those that the contractor asks for. Like the first example that would pop into everyone's mind would be escalation costs. Because of reasons which are outside the control of the contractor, if the costs that he incurs goes beyond his projected amounts, he might ask for an escalation in the amount of revenue. The third thing of incentives. Incentives are also claimed by the contractor, but the conditions for the incentives are mentioned by the contractee. So for example, the contractee says, sir, you are supposed to finish this house in a matter of 24 months. If you do it in 22 months, I will increase the consideration by 0.5%. The condition here is mentioned by the contractee, but it is achieved by the contractor. So this is the difference between these three terms. Again, these will affect the contract revenue if and only if they are all fully mentioned in the contract agreement. The agreement has to say that these are the incentives, these are the performance limitations that need to be achieved for the incentive to be claimed. All these need to be properly spelled out. Okay, so what we have done now is, we have identified what a contract cost is, we have identified what a contract revenue is, right? So the next thing that we would have to do is the recognition of the contract cost and the contract revenue in the statement of profit and loss. If I don't recognize now, I would have to take it to an asset in case of a cost, or I would have to take it in the liability if the money is received. It would be in the parlance of an advance received from customer. That's all. Now, the standard uses a term called percentage of completion method, and it says this method should be applied on the work performed. That's all. This is all the standard says. It says, for the amount of contract cost to be recognized or the revenue to be recognized, you apply the percentage of completion method, and with relating to the actual work performed, you recognize the cost and revenue in your P&L account. Now, what is this percentage of completion method? Is pretty simple. It is the actual cost incurred till date divided by the estimated cost of the entire project. But the standard does not say how the actual work performed is supposed to be measured. For identifying the POCM, there are three methods that are issued by the standard. One of the most important would be the definition that I gave, the actual cost incurred upon the total cost. There are two other methods as well. One would be based on surveys done by an external engineer, or based on the physical work that's been carried out. But the most prevalent one would be the basis of the cost incurred. Now, coming to the second part of what A7 says, the actual work performed, the standard is pretty silent. And in fact, the example given by the standard in this regard is also a little misleading. I won't use the word erroneous, but it is a little misleading. It says, for example, the estimated cost for a contract happens to be 1,000 rupees, and I have incurred 400 rupees till now. Now, the percentage of completion would be 400 upon 1,000, 40%. And the amount of contract cost that I need to recognize would be 40% into the total estimated cost of 1,000, which would once again come to 400. So what this would result in is all the contract costs that have been identified would be taken to the statement of profit and loss in the same year of incurrence, or rather the same year in which they have been identified as contract costs. This is a problem because it affects my previous principle that we discussed about, that is matching concept. The underlying assumption that we are supposed to take is the cost that has been incurred should be for the entirety of the project. Let's assume that this entire hall is one single project. The example given by the standard would mean if the cost is incurred only for this half of the hall, then the cost should be incurred for this hall. But that might not be in actual parlance. The cost might have been incurred for an unsold area also. It can be incurred for an area which has not been considered till now. So because of all these practical problems, the institute came up with a guidance note the guidance note on accounting for real estate transactions. There, while applying the percentage of completion method, the guidance note says 2 points. The first thing is to start recognizing contract revenue in your profit and loss statement. You can identify the contract revenue, but to recognize it as a revenue in your P&L account, you need to satisfy 3 conditions. The first thing that the guidance note says is at least 25% of the total land area, or rather the total constructed area, must have been constructed. Generally, this is taken on a square footage basis. The next thing is at least 25% of the land area or the constructed area must have been agreed to sell. A sale deed need not be entered into, but at least an agreement to sell must have been entered into. And the next thing is at least 10% of the consideration for the agreed to sell area must have been actually received. Okay, so if all these 3 conditions are satisfied, the guidance note says you can start recognizing revenue in your P&L account. But this is only for a condition to start recognizing. Sir, what am I supposed to actually recognize? You only said whether I can recognize or not. The guidance note once again says, to achieve the matching concept that the standard wanted us to achieve, you apply the percentage of completion method on only the consideration for the agreed to sell area, not the entire estimated revenue. For example, the total estimated revenue, let's assume, was say 10 crores, and I have agreed to sell only 2 crores. I would actually not satisfy my first condition of 25% getting achieved. So I would not recognize any revenue. But the moment I start entering into an agreement to sell for the 26th crore, say for example, let's say I have agreed to sell 30 crores, then if the percentage of completion happens to be, for example, 40%, the guidance note says you apply 40% not on the entire 10 crores, but only the 30 crores for which you are sure that the revenue is going to be recognized, where you have entered into agreements to sale. This is for the revenue part. Coming to the contract cost part, the guidance note says, instead of applying the percentage of completion method, because the percentage of completion method is once again based on the cost itself. So to take a percentage from the cost to apply it once again on the cost incurred it doesn't seem logical. So the guidance note says, you take the actual cost incurred and multiply that by the percentage of sales that you have done. In our example, the sales that we have achieved is 30%, right? And the cost incurred, let's assume, say for example, was 20 crores. So the guidance note says you apply this 20 crores on the percentage of sales that you achieved, which is 30%, and you recognize that integer as your cost. One thing that we can see here is the guidance note wants us to recognize cost based on the revenue achieved, and the guidance note wants us to identify revenue based on the cost incurred. So this ensures that a matching concept has been achieved here. So that is one example that we can see from the guidance note. Ivida AS7, pretty simple. Now, moving on to the disclosures under AS7, they are all pretty theoretical in nature. Basically, it wants us to say what the contract revenue is, what the cost is, what the methods were used and all. So I don't want to discuss too much on that. I'll just leave it up on the slide behind me. The next standard for construction contracts would have been Ind AS 11, but unfortunately that was subsumed into Ind AS 115, revenues from contract with customers, in 2018. Now, this Ind AS 115, at least in my personal opinion, has a lot of technical jargons that wantedly make our life difficult, right? So I would like to simplify it as much as I can. The first thing that Ind AS 115 wants us to look into is the term performance obligation. What it means by performance obligation is, it is not a liability per se, but it is the agreed, I can't use the term performance once again, it is the agreed task or rather the promised goods or services. This is the exact word used in the standard. It is the promised goods or services that the seller, or in our case the contractor, has agreed to achieve in his agreement with the contractee. So the standard says, you look at the performance obligation and check what your liability to achieve is going to be. So that is the first thing that we need to identify under Ind AS 115. Unlike AS 7, where we started identifying the contract cost and contract revenue, here the Ind AS 115 first wants us to understand what our liability as a contractor is supposed to be. Once we do that, then we can identify what the contract cost and contract revenue is going to be. Now, contract revenue in Ind AS 115 would be the transaction price. The term that I used in AS 7 was initially agreed price, whereas in Ind AS 115 it is transaction price. Now, please note that in a lot of places in Ind AS, the term fair value would be used. It's a very popular term for the Ind AS gap to ask the accounting person to identify the fair value and use it in their books of accounts. The contract revenue as per Ind AS 115 is not fair value, it is transaction price. Why I want to stress here is, one of the demons that we are facing right now as auditors would be the NFRA, and they brought up a circular in March 2023 where they specifically stated that a lot of companies in their significant accounting policies, they state that their revenue recognition is based on the fair value of consideration, which is actually wrong. So in case you are accounting for your revenue that way, please change it to transaction price. Then what would be transaction price? Transaction price, once again, is pretty similar to the initially agreed amount of revenue. That's all. But the jargon once again used in Ind AS 115 is that it is transaction price. Transaction price would be the consideration you receive provided you perform your performance obligation. That's all. And there would be other variations to the contract also, which would result in variable considerations, non-cash considerations, or considerations payable to the customer, reversal. But these things generally are not taking place in construction contracts, so I don't want to go into those aspects right now. Coming to the contract costs, the standard says the costs would be those which are incurred in relation to achieving your performance obligation. When you achieve your performance obligation, you identify the contract revenues and recognize them, and the cost that you've incurred to achieve this performance obligation would be your contract cost. Now, when I spoke about AS 7, I started with contract costs and went to contract revenue. But in Ind AS, you might notice that I started with contract revenue and I'm now going to contract cost. Why? I'll give you two reasons. The first one is pretty simple. The standard talks about revenue recognition, so I will have to speak about contract revenue first. The second main reason that I can see is AS 7 basically has its source as the cost incurred for a contract, which will be used to derive the amount of contract revenue. Whereas in Ind AS 115, the driving force is the revenue, not the contract, not the contract cost. So the driving force being the revenue, once being recognized in the P&L, would entail for the contract cost to be recognized after the revenue is recognized. So we see that the direction in which AS 7 and Ind AS 115 work is the opposite. This is mainly because when there was Ind AS 11 construction contracts, the direction was same as AS 7. But when Ind AS 115 came into the picture, this just got reversed. Okay, moving on. These are the disclosures under Ind AS 115. Once again, pretty technical, so I wouldn't want to go into the theory too much. Okay, right? So this completes the accounting standards and Ind AS that I wanted to cover on construction contracts, except for one part. When I said we were supposed to identify the contract costs and the contract revenue, and we are supposed to recognize the contract costs and the contract revenue, the one thing that was left out was those items that we did not recognize. What would happen? Let's say that we've incurred costs of rupees 100. We identified the entire 100 to be contract costs, but what was eligible was only 80. What would happen to the other 20? It still would have to be debited to the books because it was an amount that was paid by the contractor. what would happen is that it would take the parlance of an asset. In the books of a contractor, they can get assets based on two methods. The first thing is an ineligible contract cost or a contract cost which is yet to be recognized in the P&L. That would come into the books as an asset. The second thing is the costs incurred for a future activity. Let's assume that I am a contractor and I have agreed to build two buildings, this one and the one right next to it. I have bought in a lot of materials and I have dumped all of them in this site. But I've decided that half of the materials is supposed to be used for that building and I have not yet started constructing that one at all. Only this is going on. In such a case, the cost that I have incurred towards the materials bought for the second building is for a future activity. It will not even come into the picture of a contract cost for the first building and therefore it would be an asset. So please keep this in mind as well. Okay, right. So the next thing that I want to see is JDA transactions. Why JDA? We have been seeing into JDA transactions since morning. RERA-liyum paathachu. We saw it in GST as well. I want to see it in accounting also. Why? Because the AS7 or the Ind AS 115 that I talked about was from the perspective of the contractor, the seller, the developer, right? The things that I want to discuss under JDA transactions must be from the perspective of the landowner. In this case, the landowner is also the seller, but we'll call him just the landowner or we'll call him the contractee in our case. Okay, so the first two things that you can see here are the timing of land transfer and the timing of asset recognition. Now, in a JDA, as far as an accountant is concerned, he should look into one debit and one credit, right? The debit would be the asset that he gets, the credit would be the land that he gives up. This is all the accounting entry is going to be. But the problem here is that the timing of the building or any other asset coming into the books and the timing of the land going out are two distinct transactions. They are not supposed to be seen together. I'll give you some practical examples. We had one client in Maharashtra who had a pretty huge land bank and he wanted to construct 5 phases of IT towers and he wanted it to lend it out. Okay, so what happened was the JDA agreement that he entered into said the land would get transferred only at the end of the JDA transactions. This is how most of the JDA transactions are entered into. The land would get transferred only at the end of the closure of the agreement. But the buildings that were going to be constructed here, like I said, were supposed to be in 5 phases and the intention was to be rented out, not sold. Okay, so as soon as the first phase was constructed, the entity wanted lease revenue. He said, okay, I'm going to rent it out to one other company and I want to earn rent. The problem here is, I don't have a building asset in my books, but I am expecting lease revenue. I am not leasing out my land. I am leasing out the building along with the land and I am going to get revenue in my books of accounts, but I don't have an asset in my book to back the revenue that I am going to recognize. So what he had to resort to is to recognize the building as soon as the lease deed was entered into. So as and when each phase got completed and as and when each lease deed was entered into, that portion of the building was debited in the books of accounts. But what happens is only at the end of the 5th phase, the land would go out, right? So debits would be coming in, but there would be no credit to land. So he had to resort to keep a separate liability towards the developer. And only when the JDA got over, the developer's liability would get closed and the land would go out of the books. So in most cases, we can see that the timing in which the asset gets recognized and the timing in which the asset of land gets de-recognized would be two different items. So please make sure that you go through the JDA agreement properly and the clauses therein with regard to the transfer of title is properly adhered to and given effect to in the books. The next thing for JDA transactions is revaluation. Now, this is a pretty popular concept. What happens is, Generally, we'll take the same example of giving up land and getting 5 phases of buildings. Okay. Now, the land would, in the books of accounts, would initially be at the purchase price or the historical cost in which the land was bought. The buildings that are going to come into the books would be at their fair market value, or it might reflect the cost that the developer had incurred in constructing them. If the debit for the building is going to be at their fair market value and the credit to the land is going to be in the historical cost in which the land was initially held in their books, there would be a mismatch which would have to be taken to the statement of profit and loss as a gain out of a JDA transaction. Some might want this, some might not want this. Some might want this because they want more funds in their surplus in the statement of P&L so that they can declare dividends. Some might want to restrict the amount of dividends that they want to declare and say, okay, I don't want to take this to the P&L, I need to have another recourse. The recourse here is that the land can be revalued. It can be revalued before it is transferred to the developer, so that the amount of credit to the land would be same as the amount of debit, and the P&L would not take any hit as a gain out of the JDA transaction. The complexity that arises here is this. I have taken an amount to revaluation reserve out of revaluation that I have done to the land. But once the JDA gets over, the land has gone out of my books. So I have to revert back to the same example that I had for the lease agreement. When I got the lease agreement, there was no building in my books. Similarly, now I have a revaluation reserve in my books, but I don't have an underlying land asset. I have a building, but this revaluation reserve is not relating to that building at all. It is relating to the land which has gone out of the books. So, the party is supposed to transfer the amount of revaluation reserve to either a general reserve or a capital reserve. And that option is with the company. If they feel that they want to declare dividends out of it, they can take it to the general reserve or they can take it to the capital reserve. Now, one problem that I see here, but for which I have been trying to get answers but not yet, I would like to ask T G Suresh sir also if I can. If the land was kept as a revaluation reserve and it was taken to general reserve after the sale, even though the amount did not hit the statement of profit and loss, it gets included under the book profit under section 115 JB. There is a specific explanation given to 115 JB which says any amount that gets reduced from the revaluation reserve and added to the surplus in the statement of profit and loss out of a sold asset, that gets added to the book profit, so your MAT provisions are not distorted, right? But in this case, the asset got sold. It is no longer in the revaluation reserve and the company does not want to hold it to general reserve and he wants it to take it to capital reserve. In such a case, the 115 JB explanation does not talk about items which are not hitting the general reserve. The amount has gone out of revaluation reserve, but it has not come to general reserve, it has gone to capital reserve. So what I would like to know is whether this item would also get included with the amount of book profit under 115 JB or not. So this is one thing. And the last thing that I want to cover under JDA transaction is the sale of rights. Now, sale of rights is pretty simple. This is something that happens. This is the development right that Prasanna sir was talking about earlier. The developer during the period of the JDA has the right to construct buildings. Sometimes what happens is the party who has given the land for the JDA might face financial crunches. He might want money earlier before the construction gets over and he is given an opportunity to sell his portion of the developed area. So, in 99% of the cases, this sale of rights would happen with the developer itself. So, what the landowner would say is, we had initially agreed on 30-70. That is, if you construct 1000 flats, you give me 300, you take 700. When the JDA is in motion, when the construction is going on, the landowner now has rights towards 300 apartments, right? This right can be sold to an outside person or even the developer himself in lieu of money. So what would happen in such a case? There would be no building coming into the picture. So my debit is not going to be another asset or rather a constructed asset. It would be the money that is received as part of the sale of the right itself. And what would go out is land. Even a revaluation is possible in this scenario as well. I can revalue the land, bring it to its fair value. I can credit it and take it, the debit to my bank account directly instead of bringing in a building. Okay. Now, again, pretty simple da. GST paathalukala accounting la kadiyadu. Now, the next thing that I want to cover is leases. Leases is a very straightforward concept, at least in India. And both AS 19 and Ind AS 116 are somewhat the same except for small differences. The first thing that both demarcate is whether it's an operating lease or a finance lease, which we all know. A finance lease is something that gives the majority of the risks and rewards at the end of the lease period to the lessee, which does not happen in the case of an operating lease. Now, what the difference is between AS 19 and Ind AS 116 are two things. First thing, AS 19 does not cover lease of land area alone. If, for example, I lease out a plot of land, it is not covered under AS 19. But if I develop that and I lease out a building along with a landed property, that would get covered under AS 19. First thing. The second difference is, you see the concept of operating lease under Ind AS 116. That is available only in the books of the lessor, not in the books of the lessee. As far as the lessee is concerned, all leases would entail a finance lease. They don't call it a finance lease in Ind AS 116, but the method of accounting that's been prescribed for both operating and finance leases is the same as far as the lessee is concerned. In fact, it does not even demarcate as to whether a lease is an operating lease or a finance lease as far as the lessee is concerned. Now, we all know how an operating lease is supposed to be accounted for. The lessor would basically recognize the rental income, the lessee would recognize the rental expense. There ends the matter. As far as finance lease is concerned, and as far as all leases are concerned when it comes to Ind AS 116 for the lessee alone, what they are supposed to do is recognize a separate lease asset and a lease liability. The jargon used for Ind AS 116 is it is an ROU asset, a right of use asset and a contract liability. How we are supposed to identify this is, we are supposed to take the present value of the total lease amount that is going to be paid over the lease period. We are supposed to discount it to its present value and recognize that as an asset as well as a liability. Under AS 19, the term ROU asset is not used. What is used is, it is a simple net lease receivable asset. That's all. But the method of computing this asset's value is the same for AS 19 and Ind AS 116. But the method of computing this asset and liability between the lessor and the lessee is different. Because when we discount the lease payment to its present value, the rate that we are supposed to use is the imputed rate in the lease amount. What the imputed rate means is, the amount, the difference between the current carrying value of the asset in the lessor's books and the total amount that the lessor gets throughout the lease period, and the discounted IRR between these two values would entail the imputed lease rate. But the problem is, in most cases, the lessee might not even know what the book value of the lease, the asset in the lessor's book is, right? So the lessee would not be able to compute the imputed lease rate. In such a case, the standards, both AS 19 and Ind AS 116 say that he can take the incremental rate of borrowing. What the incremental rate of borrowing is, if the same asset is being loaned out by the lessee from an outside party on the same date, under the same conditions, whatever would be the applicable interest rate that they would get, you discount it at that cost and you recognize the ROU asset and the ROU liability. Sorry, the lease liability. So once these assets and liabilities are recognized by the lessor and the lessee, the accounting throughout the lease term becomes simple. For the lessor, he would have to recognize the lease revenue, but he would have to interchange that lease revenue into repayment of the assets that he is recognized and the finance income that he gets based on the asset that has been recognized. As far as the lessee is concerned, he would have to replace the lease expense amount into two concepts. One would be the interest for the lease liability that he has recognized, and the next would be the repayment for the principal portion of the lease liability. There is one more asset that the lessee has recognized, which is the ROU liability. That would get depreciated over the life of the lease. Now, under Ind AS 19, the standard says this lease asset is only supposed to be depreciated and the concept of a revaluation model is not allowed. But coming to Ind AS 116, there is an option to follow either the cost model, which entails depreciation, or they can also follow a revaluation model. But the catch here is that all the other similar assets that the lessee has in their books of accounts, if they are also followed only by revaluation model, only then for the leased asset also I can take a revaluation model. For example, I am a lessee, I have taken a building on lease. I have other buildings also which I own. If those buildings are also under my revaluation model, I check the value of the other buildings that I own at every year end. In that case, the ROU asset can also be revalued at every year end. Otherwise, he will have to go under the depreciation model only. And the disclosures for Ind AS 116 or AS 19 is also pretty simple. What you will have to say is the amount of asset and the amount of liabilities that they have recognized, what the lease payment here would be, and the particular term used by the standards is minimum lease payment. So what they want for minimum lease payment is the amount of lease that is going to be paid in the next 1 year or from the next 1 to 5 years, and what it is going to be paid after 5 years. Just two things that we need to take care as far as leases are concerned based on the recent amendments to Schedule 3. The first thing is this lease liability that gets recognized under Ind AS 116. Initially, it was held as an other current liability, but now it is supposed to be separately shown in the balance sheet, both on the as a financial liability, both on the current and the non-current aspects. The same thing when I come to AS 19, the lease liability that I had was initially shown as a long-term borrowing, as a finance lease obligation, and the current part was called current maturities of finance lease obligation that was going to other current liabilities. What the recent amendment to Schedule 3 has done is the current maturities of debts has now been transferred from other current liabilities to short-term borrowings. But one thing that I've seen practically happening is the current part of the finance lease obligations is also being transferred from other current liabilities to short-term borrowings. That is actually not what Schedule 3 wants us to do. Only for its outside debts that the company has taken, the current maturities is supposed to be a short-term borrowing. As far as lease obligations are concerned, the current maturities should continue to be disclosed under the other current liabilities and should not be moved to short-term borrowings. So please take care of this also. Before going to the thank you slide, I have a small bonus content that I wanted to include. I didn't want to put it under the slide specifically because it is not relating to accounting. But one more aspect of compliance that I've seen is generally lacking among the clients that we faced. That relates to the FEMA guidelines and the RBI guidelines relating to the real estate sector. I'll just take 2 minutes on this, not much. The thing is, real estate, as far as real estate is concerned, FEMA splits it into two: real estate business and real estate development. What FEMA means by real estate business is trading in landed properties, just buying and selling. That is not allowed. It is prohibited under both the automatic route and the approval route. Also, construction of farmhouse lands or trading in transferable development rights, all of these are prohibited under FEMA. But real estate development, that is development of say bridges, townships, riverbeds and all. These items are allowed under FEMA under the automatic route itself with 100% sectoral cap. So the entire investment can be brought in by an NRI or a outside Indian party as far as it is a real estate business of construction and he doesn't intend to trade in landed properties. But two catches here is, the first thing is there is a minimum lock-in period of 3 years. If the party wants to take back his investment before a period of 3 years, he would have to seek the approval of the Reserve Bank of India first. The second thing is, he is not supposed to, I'll put it this way, the minimum amount of square footage that the investment needs to be in is also prescribed. Say for example, it is a farmhouse, not a farmhouse construction, it is just a serviced plot that is going to be developed, then there is no minimum square footage. But if it is going to be a developed project like a building or a bridge or something, then the minimum square footage is supposed to be 20,000 square meters. Not square foot, it is 20,000 square meters. With this, I would like to conclude my presentation on accounting and real estate. Thank you very much.
Thank you for the wonderful presentation. The flow of presentation commencing from the basic principles, clear explanation of contract revenue, cost, revenue recognition, and the normal misinterpretation and corrective measures. Thank you so much. It was very, very insightful. May we now request CA Sharda Hariharan to present a memento to Mr. L Srikaanth. And unless your guru told like it didn't look like your maiden attempt at all, a big round of applause for that. Thank you. Questions, request you to take it offline because we're already out. Yeah. Thank you. We'll quickly move on to the last technical session of the day, an insight into real estate and direct taxes, the IT portion of it, AGILE. May we now request CA T G Suresh on the dais, please. A person again apparently needs no introduction. Mr. T G Suresh is also a leading faculty in Chennai in domestic taxation, international taxation, financial management, cost accounting, financial accounting for close to 30 years. He has been a pioneer and role model for thousands of students pursuing chartered accountancy, cost and management accountancy, corporate secretaryship courses. He is also a visiting faculty for taxation at the Regional Council of ICAI Chennai, Bangalore, Mysore, Ernakulam and Cuttack. Many students fondly call him CGS for his exemplary discussion of capital gains. He has been regular faculty in RTI Chennai, which conducts training for income tax officials. Winner of National Award from Capital Foundation Society, New Delhi, from the Union Law Minister. He has produced many rank holders in CA, CMA, CMS, CS exams, many chartered accountants, cost accountants and company secretaries. Mr. T G Suresh is a regular member of the Direct Tax Committee formed by professional bodies and trade associations formed for suggestions or opinions to the government on tax issues. He was a co-opted member of the International Taxation Committee of ICAI and Direct Taxation Committee of SARC of ICAI for the year 2016. He is a coordinator for the Diploma in International Taxation conducted in Bangalore branch by International Taxation Committee. He was also a coordinator for the program 1 to 298 sections of the income tax conducted by SARC of ICAI and transfer pricing program conducted by SARC, co-opted member of International Taxation Committee and Direct Tax Committee of ICAI, co-opted member in industry of SARC of ICAI for the financial year 18-19. He was also a co-opted member, special invitee of the International Taxation Committee of ICAI and Direct Tax Committee of the SARC of ICAI. He is currently chairman of International Fiscal Association, SRC, and chairman of SICI in Direct Tax Committee. T G Suresh qualified as a chartered accountant in November 1988 and started practicing immediately. He is a pioneer in forming the firm Suresh and Balaji in 1990. Mr. Suresh has been instrumental in setting up a strong internal control systems for various clients He is also represented before assessing officers for high-pitch assessments. He has also given opinions of wide-ranging issues in domestic and international taxation to various corporate clients. He has interviewed many CAs, CMAs, CS on technical lines for placing them on various positions in accounting and financial levels on behalf of our clients. A big round of applause to TG Suresh, sir. May we now request CA Karthik Bhatt, committee member of the Society of Auditors, to present a health bouquet to TG Suresh, sir. I think that's again a Guru Sishya combo. The dice is all yours, sir.
Good evening. I know the coffee break was not given. It was more a conscious effort because I told them if you go to give a tea break and then I think me and Chaz will be present. So, but I think you can still say good evening. Good evening. Right. No, just to ensure that all of you are awake, because in any case I will definitely try to make you sleep also. People say that the most difficult session take is post-lunch. I think the most difficult session must be the last one, especially, you have not been given that tea break also. In fact, the reason why Subhashini was trying to, my only good thing was she didn't say, after reading for close to 3-4 minutes, after a brief introduction. It was not a brief introduction. It seems to be a very, very lengthy introduction. Whenever people say about this, I remember of a wonderful Tamil speaker called Tenkachi Swaminathan. கேள்விப்பட்டிருக்கீங்களா? அவர் பியூட்டிஃபுல்லாக சொல்லுவார் ஆக்சுவலாக. ஸோ என்னை பற்றி அவங்க நிறைய இப்போ சொன்னாங்க ஆக்சுவலாக. அதெல்லாம் நான் எழுதி கொடுத்தது தான். இதெல்லாம் அவங்க முழுக்க சொல்லுவாங்கன்னு தெரிஞ்சால் இன்னும் 2-3 பேருக்கு கூட எழுதி கொடுத்துருப்பேன் அப்படின்பார் ஆக்சுவலாக. ஸோ ஐ take this opportunity to thank the Society of Auditors and particularly the first women president of Society of Auditors. Amidst a big challenge, whenever a sector specific topic is given, a lot of people will always come back and say, will it go, will the crowd will come and all those things. In fact, I remember on March 3rd, when we had a program, the same premises for IFA, again, our committee also saying, you are keeping on a Friday, people will not come on a Friday, that was Egadasi, people will not have lunch. So many things were given first week. I told them whether people come or not, we'll go ahead and do the program. And of course, that was beautifully attended. And of course, for that program, for this program, I think I must really thank the one and only Captain J. Kumar for extraordinarily organizing the program. In fact, I think we don't have to think too much about many things, right from menu to so many things. MMA has been a great support. In fact, he knows. IFA Delhi was specifically sent a message to us. We should learn from Chennai how to organize a program, and all credit should go to Captain. Thank you, sir, for all your support for all our programs relating to Society of Auditors or IFA. They have been so kind and so supportive. And of course, the entire committee were also, I just like, it's not a vote of thanks, so, but still I thought I should mention Rupa and others for really working tirelessly to make this program grand success. But no program can be a grand success without your participation. The program started at 9:30, but 4:30, this much number of people are there. I think full credit to you. But when I was given a topic, தனுஷ் ஒரு படத்தில் சொல்லுவார் ஆக்சுவலாக. ஸோ நாங்களாம் வந்து பாயசன்னு கொடுத்தாலே பாயசம் மாதிரி கொடுப்போம், ஆனால் பாயசத்தையே கொடுத்துட்டோம் அப்படின்ட்டு. So taxation on real estate, Mr. Krishnan is also there. He knows that. I think we can, the one-day program should not go to be enough for income tax. So therefore, under these circumstances, but I've been told that because of the time slot, I think I was supposed to finish at 5:15. I think it will be a big injustice to finish in 45 minutes. Income tax issues on real estate, it takes 45 hours. I don't think we can do justification in 45 hours, but in 45 minutes it's going to be very difficult. But one thing what I have done, I've chosen some of the sections which are slightly going to be unexpected here. In fact, I was very conscious I should choose sections which most of you are unlikely to expect. So it's just like a C exam, expect the unexpected. So I have decided, okay, let's try to do something different. Therefore, if it disappoints you, I'm very sorry. But at the same time, I feel these are the areas where definitely some pleasant surprise packages will be there. These are some areas where when the issue takes up at the department, the very will be very, very big. That is what is very important. Varada varikku idella problem illa. Vandana it's going to be a big thing. I don't think I will definitely have the time to go to the fourth one. 3 chances are very, very less. But first and second, hopefully I should be in a position to cover the first and second. So the first one I'm going to take about is the taxability of an unsold inventory. Since normally whenever there's a real estate, we focus more on the capital gains. We generally don't focus on the real estate companies. So therefore, I thought for a moment the first 2 issues we'll try to take up from their perspective, and maybe from the third one we'll try to go to the other side. So normally what happens, especially when large projects are done, it's going to be phase 1, phase 2, phase 3. So many times a lot of properties remain unsold. Now, what will happen to the unsold property, whether they can be taxed under income from house property? I think definitely we must give the credit to the assessing officer. So in this particular case, okay, that's the background behind before I come back to the section. Now the Delhi High Court in the case of Ansel Housing was the triggering point for the introduction of this particular section by our beloved finance minister, who is no longer with us, but was definitely one of my greatest, I'm the greatest fans of him, for his extempore delivery of many things. So who brought this very interesting amendment in section 23 of the Income Tax Act? So in the case of Ansel Housing, the Delhi High Court took a very interesting stand that the unsold inventory of a real estate company should be chargeable to tax under income from house property. Just visualize for a moment, you have 200 flats. So you have sold only 100 flats. Remaining 100 flats which remain unsold, the assessing officer took a very interesting stand that 100 unsold properties on the basis of expected rent, you have to pay tax under income from house property. Hats off to the assessing officer, because we have, I think definitely we must compliment the assessing officer. For whatever be the case, he put a beautiful order. Whether we accept that or not is a different story. Just visualize for a moment, if it is going to be 1,000 flats and you are only sold 100, 900 flats remaining unsold. So what is the shelter you can take? The assessee first took a stand. This property is held as a stock in trade, the income of which should be taxable only under the head profits and gains from business or profession. So once the income is going to be taxed under the profits and gains from business or profession, then the taxability arises only on the basis of real income. Now, since I don't have any real income, the question of taxing this does not arise. It's a very fair point. So he also strongly relied on the decision of the Supreme Court in
Chennai properties. The facts of that case are slightly different because in the Chennai properties case, the object of the company is very clear. The object of the company is to construct properties to let them on rent. The memorandum was very clear. So the purchase or construction of property by the company is only for the specific purpose of letting out the properties on rent and get a rental income. So therefore, the Supreme Court took a stand that the rental income should be chargeable to tax only under the head profits and gains from business occupation. So in the case of Ansal Housing, what is the object of this company? The object of the company is to construct flats and sell them. The object is not to construct flats and let out on rent. The object here is only to construct the property and sell the property. So therefore, the High Court distinguished this with that of Chennai properties. Therefore, they said Chennai properties is not going to help you. Then the SSC made a very interesting contention. I should be given the benefit under section 23 1C of the Income Tax Act. Now, what is section 23 1C? Possibly those who are familiar with income from house property. Till assessment year 2001-2, so we had a concept called vacancy allowance. There were totally 9 deductions were there. Not like those youngsters who studied from assessment year 2002-3, where you have only 2 deductions. When I was a student and substantially for my first 15 years, there were 9 deductions in income from house property. So one of the deduction was vacancy allowance. So if your property is let and if it remained vacant, then you can claim the period for which your property is vacant as a vacancy allowance. But that section was very clear, 24(1)(9), that the property must be let during some part of the year. The property must be let during some part of the year. So if the property is not at all let during the previous year, then the question of claiming vacancy allowance does not arise. That was 24(1)(9) H12 section. But from assessment year 2-3, we have only 2 deductions, standard deduction and interest on capital borrowed. And the vacancy concept was moved as a part of annual value under section 23 1C of the Income Tax Act. Unlike 24(1)(9), or 23 1C says where the property is let and remained vacant for whole or part of the previous year. So we have to differentiate between 24(1)(9) and 23 1C. 24(1)(9) was very clear, where the property is let during any part of the previous year. So unless the property is let for at least 1 day, you cannot claim the benefit. But whereas in 23 1C, where the property is let and remained vacant during whole or part of the previous year. So that means for the first time from 1962-63, the concept of full vacancy was recognized in the Income Tax Act from assessment year 2002-3, 23 1C. So therefore, SSC said, in this particular case, even assuming for a moment Chennai property case is not applicable to me, the property remained vacant throughout the year, whole of the previous year, since the whole vacancy is recognized now in the Income Tax Act, I should be considered the benefit under 23 1C of the Income Tax Act. The whole vacancy is also recognized. However, again, Delhi High Court did not accept this particular view, relying on the Andhra Pradesh High Court judgment stating that where this particular case, the SSC, as soon as the property was constructed, right from day 1, was claiming the property remained vacant. The property was never let out at all. Every year, he was claiming the property is vacant. See, the Andhra Pradesh High Court said, you can't keep on ever saying that you had an intention to let. At some point of time, you should have let out. But in that particular case, there was no evidence of property. There was no advertisement in the paper, there was no to-let board, nothing was there. So therefore, APA court said neither there was an intention, nor there was an actual letting out. So therefore, you cannot claim the benefit of 23(1)(c). So what is a vacancy? A vacancy is a time gap between two tenants. Now what is this 23(1)(c) is recognizing now is that that time gap can be more than 12 months also. So the Delhi court was asking this question, when did you let this property? Ever since this construction, the property was never let out at all. So therefore, they said, on account of the Andhra Pradesh High Court judgment, we cannot give you the benefit of 23(1)(c) also. Immediately the board latched onto this point of the Delhi Court judgment. They also gave a circular. Yes, 23(1)(c) should not be given, no question of applying Chennai property, reopen the assessments wherever possible, tax unsold inventory on an expected rent basis. And the most interesting aspect of it, the circular said a very interesting point. I think we must appreciate the board for such a beautiful, reasoning. They said, our idea is not to tax the property. Our idea here, real estate companies should not be saddled with inventories. We want them to liquidate. Oh, we never knew that CBDT is going to be this kind. Worried about the real estate people accumulating inventories and all, liquidate the inventory. The one advantage for real estate is not your tomato or potato is not perishable. So therefore they try to hold. They said that we don't want it to hold. Possibly even Nitin Gadkari once mentioned, I want the real estate companies to don't keep inventory. Just move, sell, go to the next project. That was what he used to say. So therefore here, they said that was our intention. But the problem here, I have constructed 1,000 flats. Don't expect me to sell immediately in the same year. Impossible. And if you are going to tax on an expected rent, that is going to be unfair. So in this context is where section 23(5) was introduced. Now what section 23(5) says when it started off with, so this is a very interesting section where the property consisting of any buildings or lands appurtenant thereto is held as a stock in trade, and the property or any part of the property is not let during the whole or any part of the previous year. The annual value of such property or part of the property for the period up to 2 years from the end of the financial year in which certificate of completion of construction of property is obtained from the competent authority shall be taken to be nil. So even I just want to read out the FM speech on that. At present, the houses which are unoccupied after getting completion certificates are subject to tax on notional rental income. For builders for whom constructed buildings are stock in trade, I propose to apply this rule only after 1 year of the end of the year in which completion certificate received, so that they get some breathing time for liquidating their inventory. Now, if you are wondering about, it's mentioned as 1 year in the FM speech and 2 years in the section. Initially, it was introduced as 1 year, and subsequently that 1 year was increased to 2 years. So therefore, I just want you to understand the purpose of section 23(5) from the FM speech as well as also the explanation. Now this is the explanatory memorandum. No notional income for house property held as a stock in trade. Now section 23 of the Act provides for the manner of determination of annual value of the house property. Considering the business exigencies in the case of real estate business, it is proposed to amend the said section so as to provide where the house property consisting of any building and land upon thereto is held as a stock in trade, and the property or any part of the property is not let during the whole or any part of the previous year, the annual value of the property or part of the property for the period up to 1 year, which is now 2 years from now, so from the end of the financial year in which certificate of completion of construction properties obtained from the competent authority shall be taken to be nil. So I also mentioned that 1 year is substituted with 2 years by the Finance Act of 2019 from 1/4/2020. Now, So what do you think? This section appears to be a section which meant for benefit of the assessee, right? Do you think it's for giving benefit from the budget speech as well as from the explanatory memorandum? Is the government is trying to give the benefit? Is that what? Yes. So this is more a beneficial provision. But where they made the change? 22 is the charging section. 23 is the computation section. More easy to say in capital gains. 45 is the charging section. 48 is the computation mechanism. So what they have done, they made a change in the computation mechanism, which is under 23(5). They state that your annual value will be taken as nil for a period of 2 years from the end of the financial year in which you get the project completion certificate. The 2 years will be counted from the end of the financial year. Now, please understand, no changes have been made in the charging section, which is section 22. So before I go to the charging section to slightly have a different dimension of it, it is very unfortunate. The Delhi High Court, when it delivered this judgment, so we had 23(5) has already been introduced. The assessee made another very important or a very interesting contention that this 23(5) should be applied retrospectively. There are many instances. For example, the most popular section, 50C. So you have a safe harbor provisions in 50C. Consistently, the courts have held the safe harbor provisions of 50C will apply from assessment year 2003-04 when the section was introduced. So that means consistently, 40AI. All changes of 40AI, courts have taken a stand, it will be retrospective, whether it is the first proviso or second proviso. So therefore, one logically expected that the Delhi High Court will take a stand that 23(5) will also be held, because after all you can see from the explanatory memorandum and the budget speech that this is something which was intended to give the benefit. Normally, the courts have held, notwithstanding what is mentioned in the section, if a section is introduced for removal of genuine hardship to the assessee, in such circumstances, the provisions should be normally taken as curative in nature and should be applied retrospectively. Now see the budget speech. Both the finance minister himself and the budget itself has said, this is something which will help the real estate sector. The explanatory memorandum was also that. Therefore, one expected that 23(5) will also be construed, but unfortunately the judge took a stand that no, 23(5) cannot come to your rescue. Very unfortunate. And interestingly, has now been there in the Supreme Court also, has given some very interesting judgments of recent time. All charitable trust judgments which you are seeing, so are all authored by him. So now he has moved to Supreme Court also. And only one point here, the Supreme Court has admitted the special leave petition against the above order of Delhi High Court. Still it is pending. So no decision has been taken so far on this. So therefore, what we are trying to do under these circumstances, when you saddle with this kind of an issue, is there a defense for the real estate companies when they have a huge unsold inventories? Can they have some kind of a shelter? Now just go to the charging section. The annual value of the property consisting of any buildings or lands pertinent thereto, of which the assessee is the owner, other than such portions of such property as he may occupy for the purposes of any business or profession carried on by him, the profits of which are chargeable to income tax shall be chargeable to income tax under the head income from house property. So just go to the third line, of which the assessee is the owner, other than such portions of such property as he may occupy for the purposes of any business or profession. So therefore, if I am using a property for the purpose of business or profession, the only issue here could be, am I occupying this property is the only question. Actually, I'm not occupying at all. But if you take a broader sense, Is this property is part of my business asset? The answer is yes. Now see the exclusions there. So the exclusion here is that properties which are for the purpose of own business or professions are excluded from the ambit of section 22. That means it has to go to section 28. So that means one difference possibly may take with the great difficulty, because still we already have one decision study against us, that without amending the charging section of 22, by only amending the computation provision, still with difficulty we can still challenge, stating that the above provisions may not hold because you have not changed the charging section. So even continue to charging section continues to say the property is occupied for the purpose of business occupation, then it is excluded from section 22. So that means without amending section 22, so using the computation mechanism you are trying to bring. So therefore that is one difference we can still try, but already as I told you, it's one High Court is against us. That judge is also there in the Supreme Court now. The second point is that both the FM speech and the explanatory memorandum are very clearly stating this is a beneficial provision. When it is a beneficial provision, then it has to be liberally construed and should also be taken retrospectively. So as we already talked about, so the decision of Vivek Jain which I mentioned is a slightly different context. Assessee purchased the property, he never let out the property, and there the Andhra Pradesh High Court took a stand. So can Vivek Jain be applied in the case of a real estate company on unsold inventory? It's very, very unfortunate. That's where we stand. So this is about 23.5, very, very, is it a beneficial section? After going through the section, I'm not sure whether the section is beneficial or painful. But it just looked as if the only redressal by the given is partial redressal given for 2 years. Ideal situation should have been, so long as the property has not been let out, a better amendment could have been, so long as the property is not let out, unsold inventory should not be taxed. I think that would have been a better amendment rather than saying that for 1 year or 2 years. Because when you're doing a large project, given the inflation, other trends today, what we are having, I think it's going to be very difficult for the real estate sector, which is doing a large project. That means you will be discouraging large housing projects to come. I think that's why the government could have been a little bit more lenient there. So that's on my first point. So if you have any questions, maybe if you have, because by the time I come to the last one, no, you will forget about what we discussed. If you have any quick take, we can take. If you have any clouds or clarifications, we can do. Otherwise, we'll go to the next issue. No, I'm not talking about, I think occupy should be construed not as a physical occupation. That's what you have to understand. So,
for business purposes. For business purposes, he cannot use the entire
No. I'm not saying you occupy and avoid the section. So what I'm saying, as the section was trying to say, occupy for the purpose of business or profession, thereby it is very clear, if the property is held as a stock in trade, the income of which is chargeable tax under the head profits and gains from business or profession, that property should be excluded from the ambit of 22 itself. That means without amending 22, you cannot have only 23.5 and tax this property. So therefore, occupy should not be construed as a physical occupation by you. That itself should be sufficient for you to take a stand that 22 will not apply, notwithstanding 23.5. But unfortunately, Delhi High Court did not accept the stand. We have set away one down. In my humble suggestion, I think the Delhi High Court could have given a better reasoning. None of the contention they've accepted. So that is one of the issues there. What I'm saying is that from the charging section itself, if the property is a stock in trade of view, then that will not come under 22. Once 22 is not there, once the charging section fails, computation section fails. Computation section fails, charging section also will fail. So therefore, in that sense, still there is a good chance some other high court may consider, okay, fine, that is only in the computation mechanism. We don't have the charging section. Therefore, you cannot use 23(5) to make a change to 22. That stand possibly we should try. Who knows? Some other judge may consider it favorably. I'm not saying you physically occupy. Which one? It was taken, but they did not consider. They said that occupy part of it, their stand was different. See, they were not willing to consider any stand. See, they were not willing to consider anything. That's a problem. So, the Vivek Jain case also I told you, that is an individual who brought the property, who right from day one was claiming the benefit under 23(1). There it was very clear. So I had a property, I'm saying that I'm going to work out, and they were only trying to rely on the whole. At no part of the time it was let out at all. There the Andhra Pradesh record took us on. We cannot keep on saying that I have an intention let out, I have an intention let out. At some point of time we should have actually let out. See, the point here is that you may occupy the property. So therefore, they are trying to take a stand. There should be a occupation by in the property. For example, so here this is the own property of MMA. Just for a moment, we'll assume it's a corporate. So this is their own property, and they are using this property for the purpose of their business occupation. So that is clearly going to come under 22. So here, the property you constructed is not intended for your occupation. That is intended for you to sell it to some other person. In the intervening period of time, I'm not getting any income. But I think let's give the credit to the assessing officer. He said, you don't have to get the income for the purpose of section 22, because section 22, basic charge of 22 is on the basis of notional income. Only when the real income is more, the real income comes into picture. So if you go to the scheme of 23(1), 23(1) says you have to pay tax on expected rent. 23(1)B and 23(1)C. 23(1)B says if your actual rent is more, actual rent will become your annual value. 23(1)C says if your actual rent is lower, and if it is lower on account of vacancy, then you can take 23(1)C. If you're not covered by B or C, IHB is always on 23(1)A only, which is always on a notional income. Real income comes into picture only when it is more or less on account of vacancy. So, I think the step is good. I think we have to appreciate they've taken a step of giving that concession, but they can be a little bit more liberal in that respect. So that's the only point. But anyway, I think the real estate company should also, they should put a constant pressure on the government to, if not at least 2 years, they should at least make it at 4 or 5 years is what they should try to claim, because that's already there in 24(B) and all. Because your pre-construction period, your construction period all is 5 years. That's what they should seek. So now the second issue is a very interesting one, which is a conversion of stock in trade into a capital asset, for which you have a new section, section 28(6)(a). This was a very interesting section. All of us are familiar with the reverse, 45(2). Conversion of capital asset into stock in trade. That was always there in section 45(2) of the Income Tax Act, introduced by assessment in 85-86. So that was a very interesting decision by the Supreme Court in by stream by K. Kuka. So I was having I have 5 acres of land. The land appreciated dramatically. So if I'm going to sell the land, I have to suffer capital gains tax. The assessor in that particular case, so what he did was, he started a business of real estate. Took this land as a part of his stock in trade. As my friend was talking about accounting aspects of it, Worldwide accounting allows you to take the fair market value on the date of conversion as your cost. So I purchased for 1 lakh, today it's 1 crore. So I started the business. I don't have to go to sub-register office, transfer at all. As a proprietor, I don't have to do it. So therefore, I credited in my books of account capital of 1 crore, land as a stock in trade of 1 crore. Immediately I sold the land for the same 1 crore. I filed my tax return with a business income of 0. And I also did not offer any amount under capital gains. The Supreme Court said, fantastic. There is no business income because the cost is accepted by the department itself as 1 crore. But department wanted to tax the difference between that 1 crore and 1 lakh as the capital gains. So in order to come under capital gains, we all know that 3 conditions must be satisfied. There must be a transfer, the asset must be a capital asset, there must be a profit or gain. Definitely capital asset, yes. But is it a transfer? If it is a transfer, to whom I am transferring? To your business. If Sachin Tendulkar starts a business, Sachin Tendulkar alone is taxable, not his business. Take the charging section of section 4. Income tax shall be charged for every assessment year and the total income of previous year of every person. His person is taxed. Person is defined by 231. Person includes individual. So if business is not taxed at all, business is only a source of income. It's only the person is taxed. Therefore, Supreme Court took a stand. Where is the transfer here? You cannot come back and say there is a separate entity concept in accounting, business and individual different. All those things and all will not apply for tax. There is no transfer. So only thing is that nowadays if a tribunal judgment also comes, they amend the law immediately. So it's a 1964 judgment, amendment was made in 85-86 assessment year. They amended section 247, clause 4 was introduced. Conversion of capital asset into stock in trade is a transfer. And then you also have a separate charging section, 45 subsection 2. So 45 subsection 2 says when your capital asset is converted to stock in trade, fair market value on the date of conversion shall be deemed to be the full value of consideration accruing or arising as a result of transfer. But interestingly, capital gains shall be chargeable to tax in the year in which the stock in trade is transferred, sold or otherwise transferred. Though the transfer happens the year of conversion, capital gains is postponed to the year of sale of stock in trade. Logically, because that is when I get the realizable consideration. That means the second person that the transaction comes only after the sale of stock in trade. We all know the principle of mutuality. I cannot make a profit with myself. But the section was correctly worded. The capital gains gets postponed to the year of sale of stock in trade. But there was no provision for the reverse. If I am going to convert my capital as in stock in trade, yes. What will happen if I do the reverse? Stock in trade to capital asset. For example, take a very simple, forget real estate for a minute. It's more easier to do in the case of shares. So I have some listed shares. The shares are held for more than 1 year. For a moment, forget about 112A. Think about 1038. In 1038, if I sell the listed shares and if it is a long-term capital asset, the entire capital gains becomes exempt from tax provided STT is paid. Definitely, there are some smart investors who had a shares in the books of as a stock in trade, but which are held for more than 12 months, moved the same to investment. And then they subsequently sold. The resultant capital gains has been claimed as exempt under section 1038 of the Income Tax Act. Because if I'm going to sell as a stock in trade, I don't get 1038. I get the benefit of exemption 1038 only if I sell it as a capital asset. Therefore, you are move your stock in trade into capital asset investment and then sell. Claim the benefit of 1038. Two issues arises here. One, how to calculate the holding period. Some tribunals took a stand that the holding period should be taken right from the date on which you hold the asset, not necessarily from the date on which it became the capital asset. So because the section never talks about how you should hold. Plus they said that 1038 benefit is available. So this is a very easier case for you to understand. Shazla, it's very easier. The same logic is also applicable in the case of real estate also. Assuming you have as a stock in trade, if you want to move it as a capital asset, there is no problems at all. There is no issue. There is no provision in the Income Tax Act similar to that of what we have in 45(2). That is where this 28(6)(a) was brought into Income Tax Act. Now, in 28(6)(a), the fair market value of inventory as on the date on which is converted into or treated as a capital asset determined in the prescribed manner. So the fair market value has been determined under 11 UAB, and 11 UAB specifically with reference to the immovable property. Stamp duty on the date of conversion is going to be taken as your fair market value. So that means if you are going to move your stock in trade into an investment or a capital asset, then the fair market value or the stamp duty valuation on that date is going to be considered as your consideration for the purpose of computing business income. But what you must understand, unlike 45(2), here the business income is not going to be postponed till the date of sale of your investment or capital asset. There are some people say there is even I might have also put in the slide like this, but I think I won't say this is both can be seen in the same direction, because stock in trade is something which you are supposed to liquidate immediately, right? But it's not the case of a capital asset. I think that is the one important difference you have to understand here. I won't say that entirely this section is at fault, but where we are trying to take a stand is because of the memorandum. Now, what is it memorandum saying? Now, sometimes the memorandum, they can avoid the memorandum itself. Now, section 45 of the Act inter alia provides that the capital gains arising from the conversion of capital stock in trade shall be chargeable tax. However, in cases where the stock in trade is converted into or treated as capital asset, the existing law does not provide for this taxability. I just shown it as an underlined. In order to provide symmetrical treatment and to discourage the practice of deferring the tax payment. Leave the deferring the tax payment, the symmetrical treatment. That means what they say is that whatever treatment 45(2) has got, same treatment has to be provided. That's what you are saying. If that be the case, that can be achieved only when you postpone the capital gains tax when the investment is sold, because that is when you actually get the realizable profit or profit to the second person. That is the underlying logic under 45(2). The symmetry will be reached only when the capital asset is subsequently sold. But however, the lawmakers would have thought when you convert a capital asset stock in trade is something you are supposed to sell immediately. But investment is something which you are going to hold for a longer period of time. Therefore, if I am going to say at the time of sale of capital asset, the second point, I think you can't see the symmetry treatment alone. Discourage the practice of deferring the tax payment. That's what the board will come back and say, boss, you don't read the memorandum up to only one point. Read the next point also. I said symmetrical treatment and also discourage the practice of deferring the tax payment. The deferring of the tax payment may not arise in the reverse situation, because since you are taking it as a stock in trade, as a businessman, you would never like to hold a stock in trade for a longer period of time. You would like to liquidate at the earliest point of time. Therefore, the question of deferring the tax does not arise. But when you do the reverse, that is more tantamount to deferring of tax. So therefore, I think to that extent we have to take, but however, still the real estate people can still say that you should give a symmetric treatment and all. That's for you to go and request. Now, let us look at the other points are there. They are making it very clear. The date of holding should be taken only from the date of conversion. You can't take the date of holding of the stock in trade. So those things they have made it very clear. That is open-ended in the case of 45. There is no such problem at all. Now, section 49 also very clearly provides that you have to compute the capital gains based on the stamp duty value. Take the stamp duty value as a cost. Everything was provided correctly. But now, so whenever you have a section, these are the provisions which are amended only from assessment year 1920. So let's have a quick comparison between the two sections. Now 45(2) is applicable for conversion of capital as stock in trade. The fair market value on the date of conversion will be deemed to be the full value of consideration, but you don't have any separate rules for determination of fair market values. Therefore, you have to go by the value at which will fetch in the open market. Both capital gains and business income will be taxable only in the year of sale of stock in trade, and the date of sale of stock in trade is relevant for exemption under 54 EC or 54F, because it's very important, because those sections allow 6 months from the date of transfer. But here, date of transfer is the date of conversion. Taxability arises only in the year of sale of stock in trade. I think we must really compliment the board, because they came out with a circular. The circular specifically says that you will get the benefit by investing from the date of sale of stock in trade and not the date of conversion. Interestingly, their first circular was reversed, and they withdraw the circular and gave a new circular, which is definitely a welcome measure from the board. Now introduced from assessment at 85-86 to overcome the decision of Supreme Court in by stream by K. Kuka. But whereas, so 28(6)(a) will apply for the reverse conversion of stock in trade to capital asset. FME and the date of conversion will be determined as per 11(u)(b), which is stamp valuation. And PGB will be taxable in the year of conversion, and capital gains will be taxable only when you sell the capital asset. Therefore, to that extent, you can find there is a difference in the treatment. Immediately on conversion, you will suffer income under the head profits and gains from business operation. The difference between your cost and the stamp value will be considered as your business income. So again, the decision which was overcome here was the Bright Star investment decision of the Bombay Accords, where since you don't have a similar provision, a liberal stand was taken. Now, is this section really bad? That's a question. Maybe yes, maybe no. But many times we find most of us have faced the 50C problem as well as 56(2)(10) problem, where you always find the stamp valuation, actual consideration difference was huge. And both buyer and seller for the same transaction are taxed. Now, let us assume a situation where your stamp valuation is 100 and your cost is 150. Your stamp valuation is 100, the cost is 150. Now, why don't you take advantage? 28(6)(a) does not say it's only income. Income always includes negative income also. In a scenario where the stamp valuation is less than your actual cost, in those circumstances, you can explore the possibility of moving that to investment, because you get immediately, there is going to be a business loss is going to be available for you. So there is one dimension of positive looking at the same section. Very importantly, you should also appreciate here, there is no safe harbor provided here. Assuming a situation where, so you convert it and the stamp valuation is more, but under 50C or under 43CA, you have a safe harbor of 10% is allowed. But there is no safe harbor is available for 28(6)(a). So you can ask the question, then can I then apply for 28(6)(a), 43CA, and then take the safe harbor? We ourselves have taken a stand that the provisions of 45(2), 45(3), 45(4) are self-contained code. Therefore, you cannot apply 50C to 45(2) or 45(3) or 45(4) because you have a specific provision. 50C a general provision. The cardinal rule for interpretation, specific section will always prevail over general provision. Now 45.2 is the charging section, self-contained code. Same thing is for 28.6a. 28.6a is a self-contained code. Therefore, it is not possible for to invoke 43CA. Now, the second point what you must understand, 43CA clearly uses the word, there must be a transfer. In order to apply the provisions of 43CA, the requirement of the section is there must be a transfer. You can't say in 28.6a you are transferring. Internally in your balance sheet, you are moving the item from a stock in trade to investment. No transfer is made. There is no transfer is made to another person. Therefore, in that context also, applying the provisions of 43CA becomes a difficulty. That means safe harbor provisions on a couple of reasons, very difficult by using 43.6a. But do you have a 28.6a, does it have a safe harbor? The answer is no. So that is something which you have to understand. But however, there is always, suppose assuming a situation where you have a brought forward capital loss, then you don't need a business income, right? Because brought forward capital loss can be set off only with capital gains. So in such a kind of situation, why don't you use 28.6a? Because you need only capital gains, right? So therefore, move it there. The difference between the stamp valuation, the actual sale consideration, that will be taxed only as a capital gains. Thereby, you can use the brought forward capital loss. Therefore, it is not that every provision we should always look into as if it is negative. Each and every provision, you look into what you can make the best use of it. See, always people come back and say the market is going up, no fundamentals. At the end of the day, don't grip. Market goes up, respect it. You also go with the wind. Never always blame the screen. The market knows much better than what you and me know. We may be reading P ratio, all the stuff. But always respect the market, respect the screen and go with it. If you start questioning, it is only a question of fear of missing out now. So instead, don't complain. That's it. Market moves up, you make a problem. What's the problem? Whether market moves on account of fundamental, whether marks on technical. So again, there is one information which is coming where if Korea is moved into developed market category, India could roughly get $26 billion under MSCI index. You just imagine $26 billion if it comes to India. Who cares about what is your PE multiple? We don't even know what is it. $26 billion, I can't even write how many zeros are there for it. So therefore, I think this is what you written. That's why the lawmakers have enacted 28.6a. Let us accept the 28.6a and find out what you can do with 28.6a rather than complain about it. Because at the end of the day, you are not the finance minister, I'm not the finance minister to change it. And accept, either pay tax or try to save tax. Organize his choice. Huh? Hopefully, we are not forcing them to sit. Kadala putli. So, any real estate discussion, I think I just wanted this issue because real estate issue with me around, possibly there could be some expectation that something will be on capital gains. I don't want to let it on, but definitely the first issues I took up primarily because wherever we get a topic, we always talk only about capital gains. In fact, I thought I should today break that this thing, talk on something different. It can be house parking and business income, but it should have an impact on real estate. I found these two are some recent amendments where the issues are very, very serious, and some cases where we also found that the department raised a very logical point. I won't say the department is wrong. Based on what is available in the law, their order is definitely correct only. But that's where I thought we should sensitize this issue. That also comes in. But this is something where we will have part of an issue which is going to be futuristic in nature and part of its current issue. So we all know about 50C. So what I'm going to do is the interplay between a 50C with 54, 54C, 54F, that is already come with a lot of sections. That with 49.4, no issue has come so far. It is going to be the issue of the future. So that I will be my final slide. Now, We all know 50C talks about if your stamp valuation exceeds the actual consideration, the stamp valuation shall be considered as a deemed full value of consideration for computing capital gains. But for the purposes of exemption under section 54 or 54EC or 54F, should I have to take the actual consideration or should I have to take the deemed consideration? Should the capital gains as computed using 50C should be used, or 50C is only for computation? When I come to exemption, I will not use 50C consideration. I will only use capital gains calculated based on actual consideration. Or to put the issue on a very simplistic manner, should 50C deemed consideration, should it be inbuilt into exemption sections also? Is the very interesting issue, and I will also try to extend it to, as I told you, with 14.4 also. So just to set the tone, 50C provides for substitution of stamp valuation as a deemed full value of consideration in certain circumstances. Now 56.2.10 provides for taxing the difference between stamp valuation and actual consideration as income from other sources. If you combine the first and second point, you can easily observe both buyer and seller are taxed for the same transaction. And how we are going to use this for our discussion in the last part is what I think something for you to think about while leaving this hall. Now section 54 ECF provides for exemption for reinvestment in another residential house or bonds. And what is the issue now? There are some conflicting decisions are there whether to apply the 50C consideration or actual consideration for exemption purposes. So this is where the next few slides I'm going to talk about. So the first of it is the decision by the Bombay High Court. We'll start with something against us and then we'll go to something favorable to us. Because when we leave, I think we'll go with what is favorable to us. So I don't want the reverse. So this is a very interesting case, Jagdish Dabalia. But what was interesting in this judgment was the judges virtually agreed with the assessee and then took a decision against him. அதுக்கு பேசாம நீ முதல்ல தப்புடான்னு சொல்லிருக்கலாம். நீ சொல்றதெல்லாம் கரெக்ட், ஆனா சாரி. ஸோ நீ அது சொல்லிருக்க வேணான்றப்போ இருக்கும். But anyhow, I think let's go into what they try to say. There was a sale of plot of land for a consideration of 25 lakhs. The entire 25 lakhs was invested in 54 EC bonds. Entire 25 lakhs. So assessee declared a long-term capital gains of 21.19 lakhs. Obviously, the difference of 4.81 lakhs should be the indexed cost of acquisition. The case was taken up for a scrutiny where the capital gains was assessed at 49.47 lakhs, obviously because the guideline value was much higher than the actual consideration. The assessee did not disclose the stamp valuation. He went by the actual consideration. The assessing officer said since the stamp valuation is more, the capital gains was changed to 24.47, which is 14 point as a difference as a capital gains. Assessee made a beautiful contention. Since the entire sale consideration was invested, my entire capital gains must be exempt from tax because the provisions of 50C will apply only for computation. You cannot apply section 50C for 54EC. So let's see in detailed manner what was the assessee's contention. Now, so before we go to that, just for the benefit of refreshing ourselves, this is actually how 54EC appears in the law. So where the capital gains are assessed from the transfer of a long-term capital asset, now of course it was land or building, earlier any capital asset, now from assessment in 1920, so it has been now changed to only land or building. So within a period of 6 months after the date of transfer, invested the whole or any part of capital gains in the long-term specified asset, that the cost of the long-term specified asset is not less than the capital gains, the whole of such capital gains shall not be charged. Let's not go into the second part of it. We'll stay with the first part. Now, if the cost of the long-term specified asset not less than the capital gains arising from the transfer of original asset, the whole of such capital gains shall not be charged under 45. The only question is how to calculate that. After superimposing 50C or without 50C. That is the issue. So for which we should go to 50C as to how it is worded. Now, Take only the last 3 lines, which is shown in bold. The value so adopted or assessed shall, for the purposes of section 48, be deemed to be the full value of consideration received accruing. I'm very, very surprised, shocked with the way in which they've recently introduced 50AA also. Now, you have to learn lesson from this. Now, you have introduced a section like this. This has been subject to litigation, and you have lost many cases. In this budget of Finance Act, you have introduced a new section 50AA, initially for market-linked debentures. Before the bill was passed as an act, with nobody in the parliament, it was passed. And there suddenly, as the media was talking about debt funds, it is not debt funds at all. They never said debt funds. They only said specified mutual funds, where it has been defined as not more than 35% is invested in equity shares of domestic companies. That means, please don't think it's a debt fund. If 35% or less is in equity shares, those capital gains will be considered as a short-term capital gains. Only thing is that now the wordings are identical here. They are also there for the purpose of section 48. In 50 also, Supreme Court itself has taken a stand. Capital gains on sale of depreciable asset is a short-term capital gains only for the purpose of computation, not for 54EC, not for 112, not for 74. Here also 50C, many courts have taken a stand that for the purpose of section 48, this you cannot impose it for the purposes of other section other than 48. If I had been the finance minister, I would have simply said in 50AA, notwithstanding anything contained anywhere in the act. Because I would have learned the lesson. I will not do another copy paste and 50C I make it as 50AA and modify. That is a mistake done. Again, we get an opportunity at the expense of the SSC, provided it is willing. So here the last line is, for the purpose of section 48 be deemed to be the full value of consideration. So therefore, the context is what I've set in now. Now, what is the SSC's contention here? Effect of deeming provision will be limited to the purpose of the same has been enacted. So it only talks about 48. Therefore, stick on to only 48. Don't go beyond that. The relevant provisions would require a harmonious construction. So what is the harmonious construction we are talking about? We'll come to it a little bit later. Now, I have 25 lakhs of actual consideration, right? Stamp valuation is 50 lakhs. Now, where will I go and invest the remaining 25? Suppose you want me to invest the entire amount. From where I will invest? I have only 25 lakhs. My actual consideration, my hands is only 25 lakhs. The deemed consideration is 50. The remaining 25 is something which I don't have. If I have to invest for the purpose of claiming exemption and I don't have any other money, that means you are asking me to perform something which is impossible to perform. Consistently, always the courts have held, you cannot ask the SCT to do something which is not possible to do. So therefore, as I said, I got 25 lakhs of consideration. I put the entire 25. Just because the 25 is taken as 50 by 50C, can I put 50? That means you are asking me to do impossibility. And since the section only talks about 48, for the purpose of 54EC, capital gains should be taken only as capital gains based on actual consideration alone. Therefore, whatever be your 50C amount, as I said, no problem. You take 50C even as 500 lakhs, no problem at all. There is no tax. So this is the contention of the SSC. But whereas, so revenue's contention was pretty simple. So you have to strictly interpret the law. The interpretation advanced by the SSC would effectively render the provisions of 50C of the Act redundant. I think that's a fairly good point, because whatever be the 50C value, once I invested my entire consideration, 50C will virtually have no effect. So that means when a law is enacted by the Parliament, you should always give life to the section. You cannot kill the section. So therefore, virtually this results in only killing of it. The SSC can claim exemption only in relation to investment made in the specified bond, not beyond. Because if you take that example, I would have invested 25 lakhs. If my stamp valuation is 100 lakhs, my exemption for 25 lakhs will be more than 25 lakhs also, if you want to make it a zero. That means without sections like 35 2AB, 54 EC would have acted like a weighted exemption, which according to the department was never the intention of the law. Then go to what the Bombay Court has got to say. So this is the first point. They said deeming fiction of 50C must be given its full effect, and the court should not allow to boggle the mind while giving full effect to such fiction. So don't try to go into these things, just apply 50C. But the contradiction is what I was mentioning earlier. We are not opposing the proposition canvassed by the counsel of the assessee that deeming fiction must be applied in the situation for which is created. I agree with you. I am fully with you. But don't expect a favorable judgment from me. Yella correct. Ana. So what is that anal? However, giving full effect to the fiction contains FD the Act for the purpose of computation of capital gains under 48, for which 50C is specifically enacted. The automatic fallout thereof would be that computation of assessee's capital gains and consequently the computation of exemption under 54 shall have to be worked out on the basis of substituted deemed sales consideration of transfer of capital asset in terms of section 50C. I agree with you, but you have to apply 50C to 54 EC also. I think the last point is where I think the court got a conviction. Any other interpretation, particularly one canvass with learned counsel, would render the provisions of 50C redundant. I think the reason which went in favor of the department is 50C will become redundant if I go by actual capital gains mechanism, which is fairly right. There is no doubt about it. But however, assessees we also know he agreed, but still he didn't get the decision in favor. Now that was the Bombay Court judgment. And then we'll go to a slightly different situation in the case of Karnataka High Court in Gauli Mahadevappa. Very interesting. This time, Karnataka dimension we should enjoy it. Assessee sold the property for 20 lakhs and he has invested 24 lakhs. Now obviously the question comes, where is that 4 lakhs, additional 4 lakhs? That 4 lakhs came in this particular case out of agricultural income. That means his investment was 24 lakhs comprising of 20 lakhs sale consideration, 4 lakhs, take it as some other savings. The AO assessed the capital gains by adopting the stamp valuation of 36 lakhs. After considering the investment of 20 lakhs for exemption to 54, capital gains was alright. We all know that 54F is a proportionate exemption. The officer or either actually. He said in the denominator, he will take 50C consideration. Denominator. Amount invested by net consideration into capital gain. It's a method of calculation. You have 54F. It's not like 54. It's a proportionate exemption. Cost of the new house numerator. Denominator net consideration into capital gains. Now, denominator is that I will take 50C value, which is 36 lakhs. Numerator is that I will take only 20. Now, why 20? He said 20 is what you have in your hand, right? 20 is alone your sale proceeds. If I take 24, that means 4 is not from the sale of this asset. So that means I will take 36, 60 not received in the denominator. Numerator or bongatano. Numerator kaila ola paisa in sale pan actual sales 20 da. Numerator only 20 divided by 36 into capital gains. See, lot of times this Gauli Mahadeva case, one-liner we also given our book. That's a problem. Here, the Karnataka did not went through whether 50C should be applied for 54F and all. Nothing have been considered. Not been you read the order any number of times, you will not find that. What it said was the numerator should be taken as 24. 36 discussion பத்தி அவன் கவலையப்படல ஆக்சுவலா அதை பத்தி பேசவே இல்லை. Assessee should be allowed to invest not only from the sale consideration, he can also invest out of his personal savings or loan also. It is not necessary that the investment should come only from the sale process. That means in this particular case, if the assessee had invested 36 lakhs, Department should have given full exemption. 20 from the sale profits, 16 personal. Deemed consideration 36, no problem. That's not a problem. They never went to whether 50C and 54F, that part of it never discussed at all. Only thing that numerator need not have to be only from the sale process. It can be from your savings or loan or anything. I will once again repeat, Karnataka Code never discussed about 50C, can it be superimposed on 54F, was never there in the judgment. Because lot of times we find one line in the book, as if Karnataka had said 50C can be applied in 54F also. No. Bombay Code, yes, not Karnataka High Court. So of course the more interesting judgments are so before we go to the last the judgment here, the net consideration is defined in 54F. It's defined in 54F. The net consideration laid into a transfer of capital asset means the full value of consideration received or accruing as a result of transfer of the capital asset as reduced by any expenditure wholly and exclusively for such transfer. So here the net consideration is full value of consideration minus expenses. The only issue here is that whether this full value of consideration, should it be deemed consideration as per 50C or not? That is the only question. Karnataka Code did not discuss Bombay Code judgment with the reference to 54EC only, not with the reference to 54F. So therefore, 54F, we will see the real judgment on 54F. I'll skip the judgment because we already talked about that. So here, it's a very interesting judgment. It's a beautiful judgment. I think definitely in this particular section, if you want to have a wonderful understanding, I would recommend you to read this judgment. Beautiful arguments, fantastic case law to get a full understanding of this discussion. Now here the SSC sold the property for 2460. He has reinvested the entire amount in new residential house. The AO assessed the capital gains by adopting the stamp valuations 9630. After considering investment of 2460, 54F was allocated. So what in this particular case assessing officer was doing, numerator 2460, denominator 50C value of 9603 into capital gains. But what assessee's contention was, that is only for computation of capital gains. 96.03 is only for computation. For the purposes of exemption, numerator is 2460. Denominator should also be only 2460. Why? Read 54F. 54F says net considerations mean full value of consideration minus expenses. What is full value of consideration? Only actual consideration, because 50C is not overriding the entire section. 50C only talks about 48. So that means for 54F, numerator and denominator, I will take it as only as 2460. But just for a moment, take in this particular case, capital gains as 50 lakhs. I don't know the exact number, just hypothetically. That means what will happen for an investment or 24 lakh 60,000, what will be my 54F? 2460 divided by 2460 into 50. That means in a proportionate exemption section, for a 24 lakh 60,000 of investment, you will get 50 lakhs of exemption. Might look absurdity the highest order. சும்மா நம்ம dispassionate நம்ம CA எல்லாம் விட்டுட்டு ஒரு mathematician பார்த்தா வச்சுக்கோ. The section says I am going to give you proportionate. Proportionate will get a weighted exemption. I think to that extent the section, if applied, throws illogic. Adala doubt illa. But however, logic and income tax generally don't go together. So adu nama paakudadu. So therefore in this particular case, this was the decision of the court also. It accepted. I just don't want, since we are already exceeding the time. So we already discussed about the point, but it was beautifully argued. So I'll not get into the details of it. Now I'll just come to my version of it. But before that, where do we stand now? Gauli Mahadevappa, I put a question mark there, whether it is against. In my view, the answer is no, because they never discussed. Surely Bombay Code is against, but that is not with reference to 54F, that with reference to 54EC. There are a lot of decisions in our favor. More importantly, sitting in Chennai, we want a judgment from Chennai Tribunal, which is already there. that is Bhaskar Babu shop. So that is something which in our favor, because at the end of the day, rest of the tribunal judgments we don't need. What we need is only our jurisdictional judgment, which is in our favor now. So that, of course, you can take. But so to that extent, we may not have a challenge, but just doing one step further here, one step further. Give me 5 minutes time. Thanks for your patience. இப்படி சொல்லிட்டோன்னா டக்குன்னு ஒரு 5 நிமிஷம் நீங்கள் சந்தோஷமா அடிங்கிறது தான் ஒரு 5 நிமிஷம். பட் எனி ஐம் வெரி அதாவது என்னன்னா, even next speech, I doubt whether I will try 23.5 and all, because the 23.5 and the 28.6 எல்லாம் போகிறப்போ அங்கே இந்த கேபிட்டல் கெயின்ஸ் வந்ததுக்கப்புறம் சடன்லி ஐ ஃபைன் the ஆடியன்ஸோட இது பயங்கர டிஃப்ரெண்ட்டாக இருக்குது. இந்த 23.5 இதே எப்படா இந்த 23.5 முடிப்பான் அடுத்து போடா அப்படின்ற மாதிரி இருந்தது. 28.6 ஏதோ சொல்கிறாரு, திடீர்னு இங்கே வந்ததுக்கப்புறம் பார்த்தா சடனாக பார்த்தா டீ பிரேக்கு எதுவுமே வேணால் நைட் ஃபுல்லாக எடுங்கன்னு சொல்கிற மாதிரி உட்காந்துருக்கீங்க ஆக்சுவலாக. ஸோ அதனால் பட் எனி நானே என்னோட கம்ஃபர்ட் ஜோன் விட்டு வெளில வந்தாட கஷ்டம் போல இருக்கு ஆக்சுவலாக. But anyhow, this is a slightly different dimension. We'll try to do something for the future, because you always talk about we should be futuristic. Now we have seen what is the department view in Gauli Mahadevappa. They want denominator to be 50C, numerator should be only on the basis of actuals. But please understand, when that particular judgment came, there is no 56.210, there is no 49.4. When this 56.27 has become 56.210, for the benefit of some of you, 56.27 came into effect from 1st October 2009. And when the section was introduced, for immovable property, inadequate consideration was not covered at all. Inadequate consideration not covered at all. It was there only for no consideration because of 50C. Mr. Pranab Mukherjee brought that provision in 2009, and immediately when it was told that results in double taxation, the very next budget, he withdrew the same. But unfortunately, when the finance minister from our state, when he became the finance minister, he said, we will introduce it. The section was brought back, where the section was made applicable to inadequate consideration also. The effect of it is what you must understand. For the same transaction, both buyer and seller are getting taxed for the same transaction. Effectively, take this example. Safe harbor and all, don't consider it. I just try to manage without safe harbor. If it is there, also ignore it. Stamp valuation 200, actual consideration 100. For the seller, though he receives 100, he has to pay capital gains on 200. That means 100 lakhs of amount he has not received, he should pay. For the same transaction, buyer should also pay under income from other sources 200 minus 100, 100. For which, when this was introduced, our finance minister from this part of the state made a beautiful argument. What is the cost of the buyer without this section? 100. What I have done is, I am asking you to pay tax on the base of 200 minus 100, 100 now, and that 100, I am going to allow you as a cost under 49.4. Therefore, he said, I have not done anything. Whatever amount you pay as income from other sources, that you are going to get as a cost of acquisition. Only I am preponing your tax. I have not done anything. This is what he said. I don't think we should spend the time on it. We can have a separate debate on that. So 200 minus 100, 100 excess consideration to be taxed in the hands of seller. 200 minus 100, 100 will be IOS, and 49.4 says deemed cost to the buyer is 200. For seller, deemed consideration is 200 lakhs. Hypothetically, if you are also convinced that 50C should be taken in the denominator. How many of you are convinced 50C should be there in the denominator? How many of you? Just, right, 50C should be there. Okay, we'll take. I don't agree with you, but still we'll take it. Now, if you take 50C in the denominator, that means if you're going to take 200 as your denominator, what should be the numerator? For this purpose, I will straight away take this situation 3. Now you purchase a new residential house for 150 lakhs. The stamp valuation offered is 180 lakhs. Other two situations I have skipped on account of want of time. Now, assume in this particular case, you can superimpose 50C in the denominator. What should be the numerator? So now let's go back to the equation. Stamp valuation 200 lakhs. Indexed cost of acquisition 80. Long-term capital gains 120. Now what is the department saying? I'll take for the numerator only actual cost. Denominator, I'll take on the basis of 50C into capital gains. What I am advocating here, if you can take 50C in the denominator, then your numerator should also be. See, what is 50C 200? It's a deemed consideration. If your deemed consideration can be taken in the denominator, and your numerator should also be deemed cost only. You cannot have a double standards. Once I can create a fiction and take the fiction in the denominator, in the numerator, what should be the amount? I paid 150 lakhs as consideration for buying this house. Stamp valuation is 180. 180 minus 150, is 30 lakhs going to be taken as income from other sources? Yes, unless it is from a relative. And once I take that 30 lakhs tax as income from other sources, 49(4) says 180 lakhs is going to be taken as my deemed cost. Once you are subject to 56(2), then the cost of acquisition will be the amount considered for the purpose of IOS. What is the amount considered for IOS? 180. So if you can take in the denominator 100 and 200, which is a deemed consideration, the denominator, if it can be on deemed, numerator should be also only on the base of deemed value. You cannot have 150 by 200. Just to convince you, I'll take you to the 49(4) extract on this particular point. Now this is 49(4). Now we have to see what is there in 49(4) to appreciate this particular point. 49(4). Now this is 49(4), where the capital gains arrested from the transfer of property, the value of which has been subject to income tax under 56(2), 7, 7A or 10. The cost of acquisition of such property shall be deemed to be the value which has been taken into account for clause 6 or clause 7 or clause 10. Now 49(4) says once you are subject to other sources, then the cost will be the amount you considered. So what is the cost now? Now what is the department saying? Once 50C is applied, 50C is converse. We already saw about 56(2), 6A, 28(6A) versus 45(2). Same thing here. One is for the buyer, one is for the seller. For the seller, department says your denominator should be deemed consideration. That means for my investment also, for the buyer also, the deemed cost should be taken. Identical wordings, 50C, 49(4). Now those who are convinced with denominator being on the base of 50C value, I think you should also take 49(4) value as your numerator. Of course, I do not consider, so far I am convinced, notwithstanding the amount of capital gains and all you should not see. It might look absurd, but however, that's a fiction. It is up to the lawmakers to change the law. When the law says it is only for the purpose of 48, I don't think we should go beyond that. But if you are convinced on that particular point, yes, I want to go by logic, not by what is there in the law. But that can also apply for the numerator. So with this, I think I've taken a lot of your time. Sorry for extending beyond that. I once again thank Society of Auditors and also MMA for giving me this great opportunity. And I think hats off to all of you from 9 o'clock to a stand. Thank you. Thanks a lot.
Thank you, sir. That was a perfect finish to AGILE, the full day program on accounting, GST, IT and legal exclusive to real estate industry. Thank you, sir. A lot of insights. The uncommon sections, as you rightly said, you gave the unexpected. Thank you so very much. May we now request C.S. Krishnan, Chartered Accountant and expert in capital gains himself, Krishnan sir to present a memento to CA T G Suresh. So the hall is full until evening, the last session, and also we have 540 people watching it online. So it's a great success, and thank you all. Without the audience, the conference is definitely not successful. Thank you so very much.
Yes, sir.
Thank you, sir. May we now request CA Anusha Sreenivasan, the first women president of the 90-year-old the Society of Auditors, to give her concluding remarks and share her gratitude for the successful AGILE, first of its kind, a sector-specific conference from SOA, and first ever with MMA. Over to you, ma'am.
I'm truly short for words, and I think TGS has been kind enough to propose a vote of thanks on my behalf. I would like to just add one thing. In fact, the link between MMA and SOA has been CA T G Suresh. It's only because of them this whole event went through. I just have a couple of pleasantries to be presented. May I request Captain Vijay Kumar to hand over a memento to CA Rupa Ramachandran, a health bouquet. She's been the biggest support from the SOA side in managing the whole event, right from designing, inception, implementation and execution and everything. A big shout out to CA Rupa Ramachandran. Our another committee member, CA Renuka Murli too, had been part of this. In fact, she designed the acronym AGILE and she was instrumental in bringing the chief guest for this morning, but she's already left for the day. As I always love to address this person as the voice of SOA, CA Subhashini Ganapati, being the MC of the day, as always, she took us through the event so seamlessly and a wonderful summing up after each session, keeping the audience energetic at all the times. May I request Captain Vijay Kumar to hand over a memento, a token of our appreciation and love from Society of Auditors and the management, MMA, to CA Subhashini Ganapati. I would like to join. From the bottom of my heart, I just request one thing, a standing ovation for Captain Vijay Kumar and his entire team. Please.
It's not for us, it's for the teamwork. I think we should learn collaboration is the order of the day. And thanks to Anusha and the team, they're brilliant actually. We really enjoyed working with them. Thank you so much.
Have a beautiful evening, all of you. Thank you. We'll join for tea. I think we'll have the national anthem now. Please turn.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे